2021. It is now 6:26 p.m. Madam Clerk?
Mayor Ronnie Felder. Chairperson Shirley Lanier.
Here.
Chair Pro Tem Kashamba Miller Anderson.
Present.
Councilperson Trodrick McCoy.
Here.
Councilperson Douglas Lawson.
Here.
Councilperson Julia Botel.
Here.
City Manager Jonathan Evans.
Present.
City Clerk Claudine Anthony is present. City Attorney Don Nguyen. Here. Thank you, Madam Chair.
Thank you. We will have a moment of silence led by the Pledge of Allegiance from Councilman Lawson. Are there any additions, deletions, or substitutions for this agenda this evening?
Yes, Madam Chair, I will ask that the city clerk read some of those items into the public record, and conceivably, if the board is willing to take some items out of order, staff would like to proffer that as well.
Okay, go ahead.
Madam Chair, members of the board, item number 10, resolution number 123-21, under the consent agenda is being tabled. Item number 11, General Employee Civil Service Board appointment, is being moved to the consent agenda. It will keep the number 11 and will be moved on the consent agenda right before the end of consent agenda. Because right now, if you look at your agenda, it's listed after end of consent agenda, so it just should have been moved up. And end of consent agenda should have been up under board appointments. Item number 12, a presentation on the interim budget report, is being deleted. Item number 13, presentation from the Fire Rescue Demographics and Diversity in Hiring presentation, is being deleted. We're adding item number 13A, a proclamation from the Office of the Mayor of the City of Riviera Beach declaring the month of October as Domestic Violence Awareness Month. Item number 23, concerning the authorizing settlement of attorney fees and costs, is being moved to unfinished business. It's going to keep the same number. Item number 24, resolution number 103-21, is being deleted from the agenda. Item number 27, city manager's evaluation, is being deleted from the agenda. Item number 26, resolution number 108-21, is being moved up on the agenda to after item number 13A. Item number 18 is being moved up on the agenda until right after item number 26 is considered. So item number 26 will be after 13B. 13B. Hold on, let me see this. 13A, I wrote down the wrong note. So item number 26 will be heard after 13A. And then item number 18 will be heard after item number 26.
And where is that under? Repeat that again.
Okay, item number 26 will be heard after 13A. So it's going to fall up under your public hearing.
Okay.
Question, Madam Chair.
Yes, go ahead.
So why aren't we deleting number 10 instead of tabling? Tabling requires a separate motion on its own.
We're
Madam-
deleting, oh, go ahead.
Madam Chair, if I may, it's anticipated that we should receive notice with regards to that grant at any moment. So we would prefer it to be tabled because it could happen, you know, before our next meeting or after our next meeting. So we just wanted to have it out there so when we do receive notice as it relates to the grant, we can pull it off the table and have the council act upon it.
Madam Chair,
Yes, go ahead.
I understand that, Mr. Evans, but under Robert's Rules of Order, to lay on the table is a total separate function than additions and deletions. So if that's the desire, then we just need to table it as a completely separate motion.
Madam Chair, if I may.
Yes, go ahead.
That is correct, Councilperson.
Okay.
Madam Clerk?
Madam Chair, members of the board, that is all of the revisions that I have.
And Madam Chair, if I may,
Yes.
the items that have been postponed will come back at a subsequent city council meeting. So the next couple of council meetings, we should have a good number of items, and we need to dispose of those items because we have other items in the queue that are time sensitive. So I did want to inform the board that these items you will see at some subsequent meetings. We will look at what items can conceivably be placed on consent to help resolve some of that, but we will be bringing a lot of these items back to the board at your next regular meeting.
Thank you. Are there any other additions, deletions, or substitutions for this agenda this evening? The items that are listed on this agenda this evening, are there any disclosures from the board in regard to these items?
Madam Chair,
Yes, go ahead.
I have had meetings with both the developers of the Crab Pot project and numerous residents of Marina Grande.
So, Madam Chair, can we adopt first and then do disclosures? Because we didn't, and I think we have to take a separate motion to table too, so.
No, the agenda, the disclosures are after additions and deletions.
Okay.
Madam Chair,
Yes, go ahead, sir.
I've had conversations with the developer for the Crab Pot and also the legal representative for the Marina Grande Association.
Thank you.
Madam Chair,
Yes, go ahead.
it's same as well, the same, and then also we all probably received emails from different constituents. So we've talked with both sides, developers and the constituents.
And I as
Yes, I
well,
have.
yeah, received emails from constituents in regards to these items.
Madam Chair?
Yes, sir.
So I had a meeting with the principal for Seven Kings, also for the agent for Marina Grande HOA, also one of the agents for Berkeley Landing, and I attended the HOA of Lakeshore Harbor as well.
And yeah, I'm sorry, let me add to that too, for the record, is that the HOA, I did attend, but it was the last 15 minutes, and I believe Ms. McCoy was there the time before I got there, and he left.
Madam Chair, members of the board, I don't know if you all were aware, but a notice was posted that 2 or more elected officials were going to be at that meeting, so you all were covered.
Okay, thank you. With those additions, deletions, and substitutions on this agenda this evening, and the disclosures have been disclosed, can we get a motion to adopt the agenda?
Move to adopt the agenda.
Second.
Madam Clerk?
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
We are at the consent agenda. All matters listed under this item are considered to be routine, and action will be taken by one motion. There will be no separate discussion of these items unless a councilperson so requests, in which event the item will be removed from the general order of business and considered in its normal sequence on the agenda.
Madam Chair,
Yes, go ahead, sir.
with regards to the item that was removed from consent, item 10, that staff is requesting to be tabled, the board needs to resolve that particular item with its own separate motion to place that item on the table.
Move to table number 10.
Second.
Back up. Say that to me again.
Madam Chair, staff is requesting that item 10, resolution 123-21 be placed on the table and is requesting that the board take the affirmative actions to place that item on the table, and it will come back at a subsequent meeting once the grant is received.
Move to table.
Second.
Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Pro Tem Millie Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved. Now, Madam Chair, we need a motion to approve the consent agenda as amended.
Move to approve the consent agenda as amended.
Second.
Any public comments on that, Madam Chair?
Madam Clerk?
Madam Chair, members of the board, we do not have any public comments on the consent agenda. The acceptance of public comments on the consent agenda is now closed.
Thank you. Go ahead, Madam Clerk.
Can we get a motion to approve?
We did.
We did.
Oh, we did. I'm sorry. It's early. Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Pro Tem Millie Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Can we, going forward, remove community benefits requests on consent completely off our agenda since we won't be experiencing that anymore?
We could.
Okay. Hopefully we won't.
Madam Chair, members of the board, we're now down to item number 13A, proclamation from the Office of the Mayor.
Yes, go ahead. Who is presenting this item?
Madam Chair and members of the board. Oh. Unfinished business first, Madam Chair.
Madam Chair, members of the board, we need to do unfinished business, which is where item number 23 was moved to.
You need to do what now?
Under revisions to the agenda, I read that item number 23 was moved to unfinished business.
Yes,
Okay,
yes.
so unfinished business is before item number 13A.
It is. Go ahead.
Which will come from the Office of the City Attorney.
Yes.
Thank you, Madam Chair. Item 23 was inadvertently placed on the agenda and should not have been. It was disposed of at your last meeting. However, based on new information received, I'd just like to give a brief update regarding the attorney's fees in the Goldwire versus City of Riviera Beach case. Based on new information received in the form of a letter issued by the city's insurance company, we have been informed that the insurance company is limiting their liability to a total of $315,000, which consists of $255,000 in attorney's fees and costs, as well as $60,000, which is the amount of the jury award. We've also been informed that as of October 8, 2021, no additional defense costs to defend this action, including but not limited to outside counsel fees of Mr. Stevens and his firm, as well as any expert witness fees or other defense costs, will be paid by the insurance company. Because the attorney fee settlement was not approved by the City Council, Mr. Stevens will move forward with defending the city in an effort to ask the court for a reduction of the plaintiff's attorney's fees. There is the possibility that the city will be responsible for payment of more attorney's fees on both the plaintiff and defense side. However, if we are successful, the court may reduce the attorney's fees requested by the plaintiff's counsel. There is also the possibility, and perhaps even likelihood, that we will incur more fees and costs and may have to pay additional fees to the plaintiff's attorneys, including the plaintiff's expert witness fees. Because the insurance company is limiting its liability, any additional monies paid in this case must come from the city's coffers. And that is the update.
Thank you.
Madam Chair,
Yes, go ahead.
I would like to make a motion to direct our city attorney to direct our outside counsel in the Goldwater case to immediately file a motion with the court on the city's behalf challenging the verdict, in addition to challenging the attorney's fees, including the per hour cost, I might say, to challenge the motion. If the motion is challenged, then there will be no attorney's fees.
Second. Any discussion on that item?
Yes, Madam Chair.
Yes, go ahead, sir.
Mr. Evans, Ms. Nguyen, what is, I guess the question is, Ms. Nguyen, is this coming from your budget if we're no longer having coverage for legal defense from the insurance company?
Madam Chair, if I may,
Yes, go ahead, sir.
the city would use legally available funds to be able to mitigate any cost over and above what the insurance company will cover. That probably would come out of our insurance fund. But Mr. Sherman can probably provide more specificities with regards to that if the board cares for that.
Not necessary, but I just don't want to, you know, first of all, if this prevails, I don't want to just start without having a goal or end in mind. I mean, do we literally send a defense attorney out to potentially rack up legal fees in the amount of, you know, $150,000 to save $60,000? So, I mean, do we have any kind of, and I guess this is for the proposer and the second, do we have any kind of rational as how far we take this?
Yes, I second that motion because if the verdict is challenged and we prevail, there won't be any attorney fees. So I feel that if we make the effort to move forward and challenge the verdict, if it does not prevail, then so be it. But if we do prevail, because there is a possibility that we will, that there will be no attorney fees to even pay.
Follow up.
Yes, go ahead, sir.
I'm speaking of our legal defense, what it cost us to have an attorney to defend this is what I'm asking.
We're not defending. What we're doing is we're making a motion to be able to challenge the verdict. The plaintiff has to defend themselves.
Correct, but whoever we hire, I'm sure they're not doing pro bono. So we're gonna have to pay something, you know, to challenge this. I mean, we were the defendant, so I understand your point, but obviously somebody's gonna have to file a pleadings and, you know, make a statement or argument in court. I mean, at what point do we cut our losses and stop throwing good money after bad is my question. Not what the plaintiff stands to gain, but at least what it's gonna cost the taxpayers to further defend this.
Madam Chair,
Yes, go ahead.
I would have a question for our attorney. Do we or do we not have a $350,000 deductible?
We've met our deductible, Dr. Botel. And might I also, and I would caution you all not to discuss litigation strategy in a public meeting. If you want to, the motion and the second is on the floor, and if you want some discussion, you can have it, but I am cautioning you not to have discussion of litigation strategy.
Thank you for that.
Follow up.
Yes, go ahead, sir.
So members, as we do every September, we set forth a budget for, I guess, the 3 organizations that we serve as governing board members. This obviously is not a line item in the budget. And my question is very simple. How much or how long do we pursue overturning a verdict if what we're being asked is attorney fees in the amount of $255 plus $60 and a jury verdict? I mean, do we spend $400,000 in pursuing this?
Madam Chair?
Yes, go ahead. I'm sorry. You not finished?
Well, I guess that's pretty much what I'm saying. I just want to know if, before we take any kind of substantive action, the thought that I want members to consider is how much do we pursue this to the tune of us spending our own money? That's it.
Madam Chair?
Yes, go ahead.
I do believe if we have consistent communication and if the necessary closed executive sessions are provided, we will be able to monitor where we're going with it and determine how much we'll be spending or won't be spending. I think we have the safeguards in place behind the closed executive session, or at least communication from our attorneys to determine how far we're going, and we can monitor it from that point. If it's too far, then we know. If it's not, then we know we keep going. So I think if we continue to have that communication, we should be able to monitor that.
Thank you. Any other questions regarding this issue?
Madam Chair?
Yes, go ahead, sir.
And to that point, Attorney Nguyen, currently, what is our total invoiced cost for Attorney Stevens that we've spent thus far?
I don't know the exact number, however, I think it's somewhere in the mid-range of $300,000, including expenses.
Okay, because the last time we spoke was around 367, and that was prior to the last few meetings that we attended, where he was still charging us an hourly. So based upon this motion that's on the table, colleagues, I'm going to ask that this may be a little irresponsible of us to go into this arena, trying to question this settlement, the legal fees that we've already been settled by a judge and jury, to bring this back around. As our attorney stated, that we've met our deductible. The insurance company will be paying this and has put a letter on the table stating that they will not be held responsible for anything outside of this. So if we continue to fight this and go to court fighting this, now we're not going to be fiduciary responsible to our residents. And we have that responsibility. I do not see us continuing to fight this case and putting additional tax-paying dollars at risk.
Madam Chair?
Madam,
Yes, go ahead.
And I
If
know,
he's
I know
not
my
finished.
I'm
colleagues
sorry,
made this.
you're not finished, sir?
I'm sorry?
I'm sorry, you're finished?
No,
I didn't
Madam
mean to
Chair.
interrupt you. Are you finished?
No, Madam Chair.
Okay, go ahead, sir.
But, and I know my colleagues may disagree with this, and to that point, I understand that we want to make sure that we're fiscally responsible. One of our colleagues did mention that we set a budget every year. So staying within that budget and moving forward, even with constant communication, we're going to be asking our attorneys to defend this case and spending additional dollars starting from day one, which encompasses the attorney's fees and also the witnesses that are going to be coming to the table. So this cost is something that we're going to incur in addition to possibly losing this case, where if we've considered this a victory for the city, I say we cut our losses, take the victory, and move on. But now, I don't want us to continue to hold this over the city's head when we can move forward, when we have an amazing agenda of items that we need to discuss tonight.
Madam Chair,
Yes, go ahead.
I think we should take our attorney's advice
I
and
was
not
next.
discuss this
Okay, I'm
further.
sorry, hold on one second. Miller Anderson was next. Go ahead, sir.
While I do understand, and I certainly support the fact that we don't want to be irresponsible, but we do know, based on our closed executive session meetings and conversations we've had individually with our legal team, that some of us may not have been provided all of the information that we felt we needed in order to make a decision to move forward with anything, even as far as the settlement, the amount that was negotiated with the legal team and the judges and all of these different people were involved. There were a number of people involved except for the council. And so for my purpose, I do believe there were some missteps along the way that did not include the council, and that is why I am quite comfortable with moving forward, because I do not want to open the door or set a precedent for anyone else in terms of the way this played out. Obviously, we're not trying to go into great detail because this is still under litigation, but I can assure all residents, business people, and everyone that I'm sure we're all wanting to be responsible, but there were some things that occurred that did not provide, at least myself, with what I needed to know in order to move forward and feel confident that what we were doing in terms of going with that settlement was going to be the best thing. That's why I am in support of moving forward based on the motion.
Thank you, go ahead. Go ahead.
I'm fine. Let's just move on it.
Yeah,
And Madam Chair,
yes, sir.
and just in response to that, I'm quite confident and comfortable with the recommendation that our legal counsel brought to the table. I would be in support of not moving forward with this and settling this case. That was the recommendation that came to the table from our hired counsel. So I would not be in support of this motion, Madam Chair. Thank you.
Thank you. And we will go ahead and move forward.
I have a question,
Yes, sir, go
and it's
ahead.
rhetorical in nature for Ms. Nguyen. Matter of fact, let me just state this, more or less, it being a question. I'm not sure I understand if we have any basis in law or fact to even pursue this. And I just don't want to see us ask our attorney to go into court with something that is no basis whatsoever. We're setting ourselves up for failure. That's all I have.
Madam Madam Chair,
Yes,
we had a closed executive session the other day. I know Mr. McCoy was unable to attend, and I do know Mr. Lawson was only able to stay for the first 45 minutes. We were in there for 2 hours. So I'm pretty sure at some point, Ms. Nguyen, if she hasn't already provided you all with an update as to what occurred and the information that we were provided, she can certainly do that. So having been there may have provided a little more clarity as to why the decision to even put forth the motion is revealed. And that's pretty much where it came from when we had our closed executive session. We had a number of additional information that's come, so that's where we are, and that's where my support comes from.
Madam Chair,
yes, go ahead.
I did have a conversation with Ms. Nguyen, and in my opinion, I think moving forward at this point would be totally reckless and complete disregard of legal advice that's been provided thus far.
Madam Chair?
Let me say something. When you throw out words like reckless and disregard, we're moving forward with this item because, number one, the city does not want to set a precedent, and the city does not want to take a loss for what it did not do. It is up to a judge to decide that. The city basically won the lawsuit. And we're, I don't want to beat a dead horse of, $315,000 for a lawsuit that we actually won. We want to make sure that every avenue that we have to be able to challenge the verdict and to be able to move forward, knowing that we left no door unopened to be able to pursue that, to reduce those fees, or to set aside the verdict. And that is the reason why I'm supporting it, because I want to make sure that we have went through every legal avenue that we can. I don't see how we can make a settlement when we have not pursued every legal avenue possible to us. If we go through those legal avenues and it could or it could not, but we have to try for the sake of the residents, because this is their money. And we want to make sure that we have did everything that we can to be able to protect that for them.
Madam Chair,
Yes, go
can we
ahead.
please have a vote to call the question?
Yes. Let's take a vote to call the question.
And can you repeat back what the question is?
The motion is to direct our attorney to direct outside counsel in the Goldwire case to immediately file a motion with the court on the city's behalf, challenging the verdict, finding that the city retaliated against Goldwire by posting her unredacted personnel file online and targeted her for outside employment, and to raise all challenges that could be raised to the attorney's fees, including the rate. And if the judge eliminates the finding, that the outside attorneys file a motion for our attorney's fees.
And I seconded that motion.
Madam Chair,
Yes, go ahead.
before the board acts, since this was a different motion that was put on the table, it's staff's recommendation that the board allow for persons that put in a comment for this item to be able to have citizen comments, as this wasn't an item, or that action wasn't contemplated as part of the item. So if it's the board's pleasure, we also would like to afford those persons that have put in for item 23 the opportunity for public comments before the vote is casted by the council.
Sure.
The acceptance of public comment for item number 23 is now closed. Fane Lozman, number 19. Cindy March.
Good evening, Thane Lozman. I just wanted to share with you some thoughts, having been through the federal court process for 12 years with Riviera Beach over false arrests, some of the misconceptions you have. Number one, the judge ruled, he entered an order. Judge Cohn issued an order saying there was Title VII retaliation. So to say that the city won the lawsuit, that's not true. You can look online, go to PACER, the government website, you can pull up the order, Title VII retaliation. Now, when you look at civil rights cases, you only have to win $1, and that triggers your legal fees. In my particular case, I settled my case after 12 years. I went to the Supreme Court for $1, and I reduced my legal fees from $925,000 to $875,000. So my lawyers were paid $8.75. I got my dollar and the honor of upholding the First Amendment. But what bothers me here is that the insurance company is willing to pay the $255. I think that's low, because even though there was only one count she won, all the other counts were intertwined together. Because they're intertwined, my experience of working with some of the top attorneys in the country, including Stanford Law School, is that he is going to basically give those attorneys what they want because they won a significant count. So they're going to probably get $400,000. So I'm telling the council right now is that if you go beyond what the $255,000 that the insurance company is willing to spend, and he comes back and awards $400,000, the taxpayer should come after you individually for $145,000. Okay, because you're putting the taxpayers' money at risk now. Here it's the insurance company. We already paid for that policy. The insurance company will pay $255. If I'm Judge Cohn, I'm going to give Ms. Goldwire's attorney the $455 because all these claims were intertwined, and she still won Title VII retaliation. So it's ludicrous what you're doing. If it comes back at $400,000 or $500,000, you have committed malfeasance. You have, because of your vendetta, because of Ms. Botel's vendetta against Lady March, she doesn't want her to get anything. But I kind of feel responsible because I'm the guy that put in a building permit through Martin Fence. Ms. Goldwire issued the building permit for the fence and then got fired because Botel directed her former administrative assistant, who was the acting city council member, to fire Lady March Goldwire over a fence permit. So this is what this all has to do. A black woman gets fired over issuing a fence permit. Now she wins Title VII retaliation. Like, oh, well, we're just going to keep fighting this to the end of time. I'll tell you right now, if this goes to a judge and he awards more than $255, whoever votes not to give her the $255 tonight has committed malfeasance and should be recalled, thrown out of office, and there should be an independent legal action to go after the three of you because you're not acting as final policymakers. Okay, you're acting as the vendetta. At Botel, we know about your racist behavior, but the other two up there who would vote for it, it makes no sense. Thank you.
Thank you for your comments, sir.
Cindy March.
Good evening, council. You know, it's sad as a person of vendetta. When I get up here and speak, I don't only speak because it's personal with me, because she's my niece. You all sent her to jail. You all said she didn't have a building official license. She has two. Not only the regular building official license, she have an international license. You all hated her from day one. And Lanier, for you to sit up there and don't lost your job for not punching in and out of a time clock, because you be on so much other stuff till you can't even focus on your own job. Be careful how you knock down somebody. It's going to come back to haunt you. You all fired her just like he just reiterated. I'm going to reiterate, because she gave out a permit. She was doing her job. If she was that bad of an employee, why don't y'all give her why don't y'all take the $13 million back that she brought into this city and give it back to everybody that she got a permit for? If she was that bad of an employee, if you're not going to listen to Don Wins, and if you're not going to listen to Evans, who you all say y'all didn't care what it costs, just bring him back here. Not only is he our city manager, he is our CRA director, making over $400,000 a year. Let's speak about this outside lawyer you all have. Y'all talk about the questions of the hours. Talk about you paid Stephen $600,000 to defend you all in this case when you already have a sitting lawyer. Y'all are wasting taxpayers' money. The insurance company should drop everybody sitting on that goddamn board. Everybody, because enough is enough. She has been tormented with this city from the time she got to this city. And Botel, you are behind it 100%. I'm going to walk my heels off, Lanier, to make sure they ask to give you a drug test to make sure you can pass it before you sit on the board to do leadership. The worst kind of leadership is bad leadership. And you can lose a lot of employees. You sit there with that smirk on your face, but everything go up must come down. I'm speaking anger in me tonight because y'all had 3 closed sessions. I don't know how many opening sessions. You have never, since I've been campaigning, since I've been politicking for over 30 years, y'all have never had that many sections for a person settlement. Never. And if I'm lying, I want any one of y'all come back and rebuttal on my behalf what I'm speaking about. Don Wins, I have nothing but respect for you. Evans, I don't care for you, but right now, I got to respect you as a city person because you already done told them what they will be against. And if that's stupid, they need to be removed.
Thank you for your comments.
Madam Chair, members of the board, excuse me, that concludes public comment.
Thank you very much. Without any of the other questions for this item, Madam Clerk, could you call the question?
Are we calling the question? We're
No,
voting
we
to
were-
call,
we were
voting to call the
supposed
question,
to-
or are we just going to
We
call
were
it?
supposed to go back because the motion that was made earlier was not in its entirety what you
Right.
read the second time. So we need to take back that first motion, and so we can make that motion again. That was the issue. Am I correct, Mr. Evans?
No, the issue was that people didn't. it
No,
wasn't
Madam
on the
Chair.
agenda.
Oh, the issue was the agenda. Oh, okay. All right, very good. Go ahead, Madam Clerk.
Councilperson McCoy?
No.
Councilperson Botel?
Yes.
Councilperson Lawson?
No.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
That motion is approved with Councilpersons McCoy and Lawson dissenting.
Next item.
Madam Chair, members of the board, we are now on to item number 26. This item is 13A. Jesus, keep me this row. Sorry, Ms. Noel.
Madam Chair and members of the board, at the request of Mayor Felder, we are asking for the board to consider a proclamation from the Office of the Mayor declaring the month of October Domestic Violence Awareness Month, and Ms. Marcia Noel, Assistant to the City Manager, will be making the presentation.
Very good. Go ahead.
Good evening, Madam Chair, members of the board, and everyone that's joined us this evening. For the record, my name is Marcia Noel, Assistant to the City Manager, making this presentation on behalf of Mayor Felder. In addition, I would like to invite Dr. Marshall, and if Ms. Sandra Dawkins is also here from the Victim Advocates Unit. If not, then I will proceed. All right, so it is with great pleasure that the City of Riviera Beach recognizes this special month because of what it means to victims and survivors of domestic violence, including those that work hard every day to put an end to it through various services, making themselves available to those in need of assistance and support. Just before this meeting, a candlelight vigil was held to remember the victims and honor survivors of domestic violence, which was a collaborative effort between the city's police department, Victim Advocate Unit, the Florida Resource Center for Women and Children, and the law offices of Robin J. Sher. As a city, we are committed to increasing awareness on this issue through partnerships and opportunities like this. And so now I will read the proclamation. Whereas Domestic Violence Awareness Month was first introduced in October of 1981 by the National Coalition Against Domestic Violence, and later became a special week, and then afterwards observed in October of 1987 as the first.
I'm sorry, I didn't mean to interrupt you, but there is some chatter in the audience, and we can hardly hear her up here. It's like a phone or something that's playing. That's okay. That's fine. That's fine. Go ahead.
All right, thank you. And where I left off is,
Sorry, I didn't mean
it's
to
okay.
lose your place.
I'll just restart that. I apologize.
go
I
ahead.
want to
No,
make
you
it.
can restart. Go
Thank
ahead.
you. And whereas Domestic Violence Awareness Month was first introduced in October of 1981 by the National Coalition Against Domestic Violence, and later became a special week, and then afterwards observed in October of 1987 as the first National Domestic Violence Awareness Month. And whereas Domestic Violence Awareness Month was created to bring awareness to others and connect and unify millions of affected victims, victims across all walks of life, class, age, race, and religion, and whereas Florida experienced 105,298 crimes of domestic violence that was reported to the Florida law enforcement agencies, of which 66,069 resulted in arrests in 2019. In addition, according to the Florida Department of Law Enforcement, the city of Riviera Beach had a reported number of domestic violence arrests totaling 349 that same year. And in light of this reality, domestic violence occurs in our own backyard. And whereas the City of Riviera Beach recognizes the significance of raising awareness to those in the community to not only be cognizant of it, but to participate in the prevention of domestic violence as well. This month, we recognize the survivors and victims of abuse for their courage and resilience. And whereas we recommit ourselves to standing with them for safety, dignity, and justice. We also honor advocates and victim services providers who offer support during the darkest moments of one's life. Therefore, if anyone is in need of assistance, they are encouraged to call the National Domestic Violence Hotline at 1-800-799-SAFE. Now, therefore, I, Ronnie L. Felder, Mayor of the City of Riviera Beach, by the power vested in me by the residents of Riviera Beach, do hereby proclaim October as National Domestic Violence Awareness Month in the City of Riviera Beach. I call on all residents to speak out against domestic violence and support local efforts to assist victims of these crimes in finding the help and healing they need. Thank you.
Thank you for your presentation. Madam Clerk.
Now we're on to item number 26.
Yes.
Resolution number 108-21, a resolution of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving a site plan application from Seven Kings Holdings, Inc. to build and operate a 4,482 square foot restaurant on a vacant parcel of land approximately 0.35 acre, identified by parcel control number 5643 4228 00003 0090, located on the north side of Blue Heron Boulevard and east of Lakeshore Drive within the downtown general zoning district and providing for an effective date. Madam Chair, members of the board, we do have public comment on this item. The acceptance of public comment on this item is now closed. And Madam Chair, members of the board, this is a quasi-judicial proceeding, and I will ask that all members that intend to testify to come and stand to my right, your left, so that you can state your name for the record. You will have to be sworn in. Madam Chair, members of the board, we do have approximately 40 public comment cards on this item.
Madam Chair,
Yes, go ahead.
at our discretion, are we allowed to reduce the amount of time for each public comment so that we can get through today, by the end of today? Get through this meeting by the end of today?
Madam Chair, if I may,
Yes, go ahead.
I believe the City Attorney's Office would like to provide some comments and remarks about the proceeding and what some recommendations would be as a result of this particular item.
Madam Chair,
Oh.
would you like a motion on it first, and then we can?
Yes.
I move to accept the resolution or the ordinance.
Second.
All right. We got that out of the way.
Thank you.
Ms. Nguyen.
Yes, Madam Chair, I'd like to go through the procedures for a quasi-judicial proceeding for you. The City Council has been advised that the following resolution to consider the site plan review application from the Seven Kings Holding, Inc. to construct a restaurant on vacant property located at 386 East Blue Heron Boulevard is considered a quasi-judicial proceeding, and the City Code governs this process. On October 8th, 2021, the Director of Community Development received a notice of intent to participate as a party intervener in this quasi-judicial proceeding from Michael Weiner, representing the Marina Grand Riviera Beach Condominium Association. The City Code, Section 2-44, defines an affected party as a person, natural or corporate, who is the owner of the subject property or who owns property within 300 feet of the subject property, or who resides in or operates a business within 300 feet of the subject property. If an affected person or entity files its notice of intent to participate within 7 days of the hearing, as Marina Grand has done, it is permitted to present evidence, cross-examine witnesses, and be subject to cross-examination. After the city clerk has sworn in the party intervener and the city's witnesses, city staff will make its presentation, followed by a presentation from the petitioner, Seven Kings, and then the party intervener. During such presentations, only members of the City Council are permitted to ask questions. After all parties and party interveners have made their presentations, they will be permitted to cross-examine all parties and party interveners, including city staff and the petitioner, in the order of their appearance at this hearing. I'm recommending that the City Council limit cross-examination to 5 minutes each. After cross-examination is concluded, all members of the public who wish to offer public comment and who have filled out a public comment card will be permitted to make their public comment. Finally, all parties will be provided an opportunity for brief rebuttal and summary. Once the deliberations have begun, the City Council shall not question any of the parties further or hear any additional comments from the staff or the public. It is important that you get all of your questions out during the presentations. The council should decide how much time to provide to each party for its presentation. I recommend 10 minutes each, with 5 additional minutes for brief summary and rebuttal, including the 5 minutes discussed previously for cross-examination for each party. It is the board's decision how much time to permit. However, it should be shared equally between the city, the petitioner, and the party intervener. What is your pleasure?
Board?
Well, given that we have, did you say 35 or 40 public comments? I would think that we would want to, they probably are all going to, I shouldn't make a guess at what they're going to say, I don't know. But I think we should try to limit them to maybe 1.5 minutes or 2 minutes apiece. Otherwise, it will be a very long meeting.
Madam Chair, I think it would be reasonable for the board to modify the public comments to at least 2 minutes. I think that allows for persons to be able to make their point.
Okay. Then do I need to make a motion to limit public comments to 2 minutes?
Yes,
I
ma'am.
move that we limit public comments to 2 minutes.
For this item.
For this item.
Second.
Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
So where do we start, Ms. Nguyen?
Madam Chair, can you state the ground rules as it relates to the time, if the council agrees to the recommendation from legal? 10 minutes per party, 5 minutes for cross-examination per party, and 5 minutes for a rebuttal and summary per party.
Okay,
I'm fine with that.
I'm fine with that as well.
That's fine.
Yes, we need a motion for that?
Yes, ma'am.
I move to adopt the suggested timelines suggested by our attorney.
Second.
Madam Clerk?
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Madam Chair, next, I believe, should be the swearing in of the witnesses by the clerk.
So can the witnesses come forward,
Including staff, yes.
including staff?
I need for each person that will be testifying in this proceeding to come to the podium one by one and state your name.
Clarence Sermons, Director of Development Services for the City of Riviera Beach.
Next person, please.
Michael Weiner from Marina Grande, I swear.
Marty Perry, counsel for the Seven Springs Holdings. I swear.
George Gentile, planner for the Seven Kings Project, Crab Pot, and I agree to all.
Dan Seamson, landscape architect for the applicant.
Will each of you that have stated your name for the record, please stand and raise your right hand? Do each of you affirm to tell the truth in the testimony that you give? If so, please answer by saying, "I do." Thank you.
Ms. Nguyen?
I believe that staff has a presentation.
Madam Chair, at this time, I'll turn the presentation over to the Director of Development Services, Mr. Clarence Sermon, who also will be accepting a presentation or answering any questions Ms. Lina Bisbee.
Thank you. Go ahead, Mr. Sermons.
Thank you, Mr. Manager. Good evening, Madam Chair, members of the council, Madam Attorney. I am before you to present the city's presentation related to this application. Before I begin my presentation, I would like to bring up that the City of Riviera Beach Special Utility District has requested an amendment to the resolution read into your hearing to add a condition 9 related to conditions of construction to protect water lines during construction. Later in my presentation, I will detail all of the language that they are proposing for that amendment. This is the resolution header that was read into the record a moment ago. The proposed amendment does not change the header. Okay, on the slide here is the city limits of Riviera Beach and a red dot indicating the parcel for the proposed development. This view is zoomed in of the proposed parcel for this development. This is the proposed.
Go back to that last picture. Okay.
Before you is a view of the property in question from the service road in front of it. Views to the west from the property, views to the north from the property, views to the east and south from the property. The request from the applicant is to build and operate a 4,482 square foot waterfront restaurant with outdoor deck seating in the same location that a previous restaurant called the Crab Pot was once located, on the north side of Blue Heron Boulevard, east of Lakeshore Drive. The existing conditions are a vacant parcel, the parcel ID, which was read into the record. The lot size is approximately 0.35 acres. The zoning is downtown general, and the future land use is downtown mixed use. Before you is the proposed site plan for this property. Staff has reviewed the site plan and it does meet the parameters of our code. This site plan does include a contingent layout for it. The area circumscribed here is right-of-way owned by FDOT. The applicant is seeking to attain a lease to develop the property as depicted here. However, they also show an contingent layout here in the scenario of them not attaining the lease from FDOT. This application and the site plan in question shows both layouts in the event that they do get the easement and in the event that they don't. Staff has reviewed and both scenarios meet the code. This is the proposed landscape plan for this development. And here are renderings developed by the applicant for what the restaurant would look like. Staff review. Staff has extensively reviewed this application, and all legal related documents have been forwarded to the city's legal department for sufficiency as well. The proposed project is found to be consistent with the city's comprehensive plan, code of ordinances, and now ready for the board's consideration. And the table here depicts the areas that this project was reviewed against. Again, the future land use plan, which is in our comprehensive plan, the zoning regulations in the city's land development code, levels of service or concurrency available to this property, including water, trash service, roadways, etc. Compatibility. The zoning district is mixed use, which supports a variety of uses, including restaurants, and it is adjacent to a planned unit development, which is itself as well a mixed use zoning district. So we do believe it is compatible with the neighboring uses. The landscaping requirements have been met or exceeded for this property. The lighting standards of the city have been met. Parking, I will circle back to on the next slide. And then traffic. This project has also been reviewed by the county, and it does meet their traffic standards as well. For parking requirements, City Code Section 31-539B, Table A, downtown zoning district parking ratios requires 1 parking space per 300 square feet. The proposed 4,482 square foot restaurant must provide 15 parking spaces based on the calculations displayed on the screen. The site plan that was just shown to you, not including the square footage in the FDOT easement, includes 12 spaces on site. Again, those 12 spaces are not located on the FDOT easement. Because the requirement is for 15, this applicant must provide at least 3 additional off-site spaces to be in compliance with the code. They have provided this documentation. However, staff has become aware that the documentation is disputed. On this slide, I want to talk a little more in detail about the downtown parking code for the city. The intent of it is to provide a modified parking regulations for off-street parking within the downtown zoning districts. These regulations reflect the needs of the urban mixed-use downtown that our code is aiming to facilitate. In the downtown section related to parking in our land development codes, there's a significant reduction in the number of spaces required for properties developed in the downtown area. Parcels below a certain size and street frontage don't require any parking spaces at all. On-street parking, so parking on the street in front of a development, is also counted towards their required minimum parking, which is not allowed outside of the downtown zoning districts. Parking can also be provided off-site through agreements between property owners, which this developer has elected to do. So if they cannot provide enough parking spaces on site, they can petition any other landowner in the downtown district, and as long as they have excess parking, they present the agreement to the city, and if it's valid, that will count towards their minimum parking. And finally, additionally, the code gives the Director of Development Services the authority to waive the minimum parking for a development. And obviously, staff has not exercised that authority because of the nature and high profileness of this project. But I highlight all of these to bring to you that our code, when it relates to downtown, is very flexible, and it allows for many opportunities and mechanisms for an applicant to develop in the downtown and prevent parking from being a barrier to development in this district. It envisions a walkable urban setting with not a lot of parking lots, a one-park sort of development where persons can walk to different areas of interest. And there are many ways that parking has been removed as a barrier for redevelopment in our downtown area, and this list just highlights the intent of the code as it relates to parking. This application, as you all are probably aware, has been before the city for quite some time, and I will briefly go over the process by which this application went through to get before you. It was initially submitted in October of 2016. It went through multiple rounds of comments and review with city staff, and was eventually certified to move forward to the Planning and Zoning Board. It went to before the Planning and Zoning Board twice in 2017, and on June 8th, it was recommended for denial. Based on the information provided by the public at that meeting, the applicant worked with residents of the Marina Grand Condominium Association to execute an agreement for conditions of development, which outlines agreed upon terms for the operation of the restaurant, including hours of operation, parking, and noise levels. Subsequent to that, the developer held public meetings at the condominium association, as they were the primary voices of opposition at the Planning and Zoning Board meeting for this project. After that, they met with the CRA and they updated their application to reflect all of the public meetings and public input and the agreement with the association, and resubmitted that, and it was heard for the Planning and Zoning Board in January of 2019.
Time.
All right. So is it this time that the questions are done for the council? Or you go through the rest of the presentation? I said, do we take the questions now from the council for Mr. Sermons, or do we go to the next one to do their presentation?
You go to the next one.
Okay. So we're calling, who's next?
I believe the applicant.
I believe the applicant is next, and then the party intervener.
Okay, so we'll have the applicant come forward, please.
And so you all should be writing down any questions you have?
Yeah, I am, yeah.
Madam Chair,
Yes.
if we could give the applicant and the marina just a 1-minute notice, just so if they want to have any final comments, concerns to address during the presentation, so they're not cut off abruptly, just maybe a 1-minute countdown. Thank you.
Okay, thank you. Good evening.
Good evening, Marty Perry representing the petitioner.
Good
And
evening.
I have George Gentile, who's our planner, who's with me. In light of the restricted time period that's been granted here, I'm going to let Mr. Gentile proceed and make his presentation, so we get a full presentation to you of his PowerPoint. If there's time left over, I'd like to address the council for a few minutes. Thank you.
Thank you. For the record, George Gentile, President and Senior Partner of 2GHO, Landscape Architects, Planners, and Environmental Consultants. Thank you for having us here tonight. Hopefully I know how to use this clicker, but we'll attempt. We're here tonight to seek request, as we've been going through the process for quite some time, as you heard, for the 40,482 square foot restaurant, which is a permitted use in the downtown general district. As indicated by your staff and as a planner, reviewing all of the codes and regulations, we have determined that it meets all of the codes and comp plan provisions that you have in your regulations. We went through the site location history. The restaurant was originally 6,000 square feet, and I will tell you that as a resident of Riviera Beach, when I was growing up, my family went here. This was the gathering place on the waterfront, the only waterfront restaurant that Riviera Beach had in this location. It was damaged in 2004 and 2005, and that's significant because that's when the Marina Grand project was approved and was under construction, and I'm going to show you that in a minute. The downtown economy collapsed, and there was a downturn in the economy, and a lot of things happened, and so it was never rebuilt after the damage from the 2004 and 2005 hurricanes. It's currently vacant. This is the 2004 site plan. I'm very familiar with it because my company's name is on it. We did this plan. You can see that the restaurant in the bottom corner was there when this plan was approved by the City Council of Riviera Beach. And it remained as a 6,000 square foot restaurant on that site through that approval process. Again, this is the 2004 site plan, an additional document that was put in. You will also notice, which you can't see very well here, but in the upper left-hand corner was also a restaurant, a future restaurant that was approved in the Marina Grand project, because that is a mixed-use project and was required to have more than residential. It had to have a mix of retail, it had a restaurant, it had the marina operation, and that's how that project was developed. This is a shot of the 2005 construction. I know it's very hard to see, but you can see the restaurant there in that corner. It was there at the time of construction. Here's the further construction site in 2005, and the original Crab Pot restaurant was still there during that construction. That was the 6,000 square foot. Our footprint is smaller. It's 4,482 square feet, and that's the site plan overlaid on that project site, which includes the landscape and the development process. I won't go over this that much because of time, but this is our proposed site plan, and as Mr. Sermons indicated, this is a combination of the process that if the DOT provides a lease, which we have been in discussions with them on, that will happen. If not, we are still providing all the parking as required by your code, including the 3 additional spaces off-site, which we're permitted to do by the CRA code. So this is the a color version of the site plan. I want to acknowledge a couple of things on this, is that the parking has been kept on the side of the project per your code. It has provided either or, as required by your downtown development code, a sidewall and or hedge material to screen that parking from the front of the service road. And it also provides all the landscaping and buffering that's required by your code, access to the sidewalk out on the service road, which, by the way, has sidewalks on both sides, a bike lane, because we are not changing this road or providing new construction for this road, it will remain in its current condition, which the DOT has developed in the past. This is the site plan without the DOT version. We're just trying to provide you what it looks like when you take the lines off the site plan, and this, again, meets the parking codes with the off-site 3 spaces. And again, this is what it would look like with the DOT property not utilized at all for the project. I'm not going to go over all of this, but there's some important facts here. We're permitted to do an 80% lot coverage, and we're at 30%. The FAR is 2.0, which could be a lot more square footage on here. We could go up 3 stories. We're staying at single-story building, and we are at 30% lot coverage, which is substantially lower than the allowed. We have met or exceeded the setbacks on the project, again, per your code. The required parking is 15 spaces, and as Mr. Sermons indicated, we are under the Downtown Development Code, which supersedes any of your other development codes for these land development regulations, which is specifically indicated in the downtown and CRA development redevelopment plan. And so basically, we have to provide 3. We have the ability to use a lot more than 3 on the surface lot on the other property, but we're required for the 3, and we will provide the 3 as indicated. An interesting fact is that when the Marina Grande Inlet Harbor Marina PUD was approved, these were the parking requirements for that site: retail, office, dry marina storage. There was a total of 90 spaces. The outdoor parking consisted of 90 spaces, and the parking garage had 75, so there was initially 165 spaces. The requirement was 90. So currently there's excess of 75 spaces available on the surface parking and in the project site there, and thus the agreement was made back then to utilize that parking. We went over this. We have the TPS letter for traffic. I won't belabor that. Very quickly, architecturally, this is a fine dining restaurant. We have the kitchen area, which takes up a good portion of the building to make sure that it's serviced right. We have a service area, the dining area. It will have 162 seats in the dining area and 50 in the outdoor area. The elevations, it's a very attractive Florida vernacular architecture, very low profile. All the screening of the equipment is done, of the air conditioning equipment, which is in the roof area, and you'll see that in a minute when I go to it. Mr. Sermons showed these shots with the renderings. This is that same shot with the rendering of the building. This is the looking to the east. This is the project looking to the east.
2 minutes.
Thank you. The economic benefits, right now, the property is currently valued at $524,000 plus. It will be estimated to be about $5 million, so the city will see a tax revenue increase from $4,400 a year to almost $42,000 a year. I won't go into all the details on that. We are here to answer any questions. We have met all of the code requirements that you have. This is a use by right, permitted use. If you look at that top section graphic, you will see the area that's recessed in the roof that maintains all the air conditioning equipment, so it will not be visible from the road as your code requires. So I wanted to make sure. And we are here to answer any questions that you have, and we are ready to get started, and I'm ready to go back to the Crab Restaurant. Thank you.
Just very quickly, in the interest of time, we have a letter here because an issue was
1
raised.
minute.
Previously said time, I'm sorry. An issue was raised previously relative to the access to all the parking spaces. I have a letter here from a company called Empire Valet, which has been in business since 2010. They currently service somewhere in the neighborhood of 15 different restaurant sites, all of which are significant. And I'd like to submit that as part of the evidence that we can handle the number of cars that are anticipated. And secondly, we received a 15-page letter from Mr. Weiner. We only had a brief period of time to address it. We prepared item-by-item responses to it. I'm not going to take the time to go through these individually. I'm just going to submit copies of this to you for your review. Thank you.
Thank you for your presentation.
Madam Chair, will we receive copies of that document before we vote? Thank you.
Mr. Sermon? No. Oh.
I have a PowerPoint presentation I think is coming up. Able to put it in? Give me a moment so I know I'm operating this correctly. Okay. I'm Michael Weiner with a business address of 6111 Broken Sound Parkway, Boca Raton, Florida. I'm a land use attorney representing Marina Grand Condominium Association, whose property is immediately adjacent to the proposed restaurant. Glasses are fogging up, so I'll take it down. We are here tonight to discuss a site plan proposal for a restaurant that is seating between 212 and 250 people, depending on what statement is correct in the application. And we are here tonight to discuss a site plan that has 12 parking spaces. The parking lot is filled when the restaurant is about 20% full, if every employee finds a parking spot elsewhere. We are also here to discuss a site plan with more than 600 pages of backup and a 5-year history. Time is limited, but let me start by indicating who is in the picture and who is not. So, Riviera Shores is the owner, Seven Kings is the tenant. Gentile is, Seven Kings called themselves agent for Riviera Shores, nothing outrageous about that. Gentile is called agent by Seven Kings, nothing outrageous about that. But as you've seen discussed again and again, you have seen that property also includes property owned by the Florida Department of Transportation. They are also an owner. There is no lease. We heard the word discussion. That's it. So they are not here. Further, Florida Department of Environmental Management, actually DEP, they have something called a right of reverter. That's very interesting. It says if they don't approve it, the land goes back to them. They're not here either. Even after we go through these people, there are other people who are not here. All right, so we had a development agreement, there was a discussion, and you know, it's 2021, whatever was going on in 2004, Riviera Beach has made some tremendous progress. 2004 doesn't dictate what we're doing now. But back in 2004, Marina Grand Associates made an arrangement with Inlet Marina Palm Beach. Names you haven't heard yet because it's not there yet. This is the agreements we were talking about. They weren't assigned yet. Nobody really talked about this particular piece of property. It didn't include this piece of property. Now, the second agreement was a reciprocal easement agreement, and then finally, the 75 parking spaces they talked about were allocated between parties. Again, notice these agreements do not include Seven Kings. They did not include Riviera Shores. There is actually a third agreement called an agreement for conditions of development. That's between Marina Grand, my client, and between Seven Kings. At one point, there was some kind of consideration between the parties as to what could be planned for this property. However, that was contingent upon the plan being approved. The plan that you've discussed for almost 4.5 or 5 years has been withdrawn, and what you are looking at tonight is a contingent plan. Why? Because they could never get DOT to give them the 4 parking spaces. Why is there an argument about the situation with who should be able to have the 75 parking spaces? As I showed you, neither Seven Kings nor Riviera Shores was involved in those documents. And so these documents gave easement rights. Easement rights aren't ownership, we all know that. It's a right to go onto somebody's property. So the easy way to classify the lawsuit that's going on right now is this way. You want to be nice to your neighbor. You tell your neighbor, you can park 1 car in my driveway. Next morning you wake up and the neighbor says, you know what? I gave that right to the neighbor a couple streets down and his 2 16-year-old children who happen to have cars. You don't care, do you? That's what we're arguing about. You'll notice in those documents that they did not mention Seven Kings, they did not mention Riviera Shores, and yet all of a sudden, now we're looking at the fact that there is a new owner, new property associated with a 2004 development order. We don't think, and we think Florida law is on our side, that they get a chance to just divvy it out to whoever they please. But you don't need to decide this tonight. That is not in your forum. In your forum is whether or not this site plan meets certain requirements. But at this point, they cannot rely upon any of those rights. And quite honestly, as far as we're concerned, the ACD is dead. They substituted a different plan. They promised us one plan. Now they want to do another one. Why is that important? Well, let's see. The plan that we originally considered was 25% larger. That's about the size the FDOT property is to this whole site. The one that we considered had about 25% more parking spaces. Now they're down to 12. 12 for a 200-plus seat restaurant. Now, after we get done with that, we have to look at the fact that at this point and in this time, the proper parties are not in this room. They're not a party to the application. They haven't joined it. They aren't involved in it. And you can't have conditions that basically say, you know what, I'll grant you your rights. Go out, get your neighbor, even though he's not here tonight, even though he doesn't have a signed lease, even though he's not involved, even though you're just discussing with him, round him up, bring him back in here, and make sure he does what we approved. Because that's what you're going to do. That's where you're going. So, even if for a moment you could say they could get past that, and they can't. You don't want to go there. You don't want all your applications all of a sudden to be that somebody else is saying, I don't really care about my neighbor. I'll just come and give you a site plan. Just give it to me, and when I round up my neighbor, everything will be okay. You certainly can't do that when we know your code says 15 spaces, which Mr. Sermon says is reduced already. And now we want to go down to 12. Why? Because they're having problems with their neighbor. They still need their neighbor a little bit. They're going to make improvements, permanent improvements on that land that they don't have a right to do yet. They don't have a lease. But they think that they might have a slightly better chance because at least they're not putting permanent parking spaces there. So they haven't met the code. If in fact somebody wants to do something about this, there's waivers and variances, yes, but there's no application on waivers or variances. There's no discussions with the directors about what this might be. No considerations whatsoever. Moreover, if you take a look at their plan, by their own admission, they have told you that certain things can't be done. Look at what the streetscape is already in by FDOT. They are supposed to improve things and make things better. They can't meet that section of the code. They've talked about screening the mechanical equipment. Yes, they've screened it from the street, but they haven't done what your code says, which is has to be totally screened. Likewise, with respect to street design, it's not there.
2 minutes.
Let's take a quick look at your comprehensive plan. You know, you've got a great comprehensive plan. You're moving there. It is so good to see the city on the march there. But that comprehensive plan has a concept called park once. And that means that you put your car away. You're burying this down underneath a bridge at a service road with very little parking. It does nothing with park once. It does nothing to give you a chance to create a pedestrian bicycle-friendly environment. It does nothing on street details. It does nothing on traffic calming. It does not create a walkable block. The only place you can go from here is about 5,000 feet up to Publix. That's the vision for downtown? Now look, this land does not have to stay vacant. You do not have to believe that somehow or another we're denying the city $42,000 in real estate property taxes, not all of what you get, but $42,000. No, that's not the case. Good development will, in fact, improve that property, make it better, be compatible, carry out your comprehensive plan, do what you want to do under your code, and do it for those people who are at the table, not those people who are being forced to do something because maybe you can give an approval that is not really meeting the requirements of law. Let us go do what we have to do with respect to finding out about these easements. Different court, different place, but they can't be banked on now. And under those circumstances, I'm hoping, seriously, we were once pretty close on this thing. There was once cooperation between the sides. It's too bad the rug got yanked out from under us and a different plan is now before you. But I am sure that the best thing will happen for this property that doesn't violate your code. Thank you so much for your time.
Thank you for your presentation.
Madam Chair,
Yes, go ahead.
now you can allow for cross-examination.
If I may approach the microphone.
Yes, go ahead.
So after this and the public speaks, we'll have no opportunity to return to the microphone regardless of what the public says. I was thinking that maybe the public speaks and then we do cross-examination and our rebuttal. But just a suggestion, and obviously Mr. Perry should weigh in.
The order is cross-examination, public comment, then rebuttal and summary. So you will have an opportunity to come back after the public comment. Then there will be council questions.
So we're only finishing cross-examination now, yes?
Yes.
We have no cross-examination, thank you.
If I might, I'd like to ask a few questions of Mr. Sermons.
Go ahead.
Thank you. First of all, thank you for all the work that you're doing in the city of Riviera Beach. I appreciate it. I am a fan of emerging neighborhoods, and you are making neighborhoods emerge, so I appreciate that. I know you have some vast experience in this area of land planning. Can you tell us a little
Hold
bit
on
about,
I'm sorry, let me stop you right there because we got to get the time right for your,
I think we're at 5 minutes.
5 minutes.
can we do 5
You
minutes?
can take a few seconds off the clock since I,
I have it going here, Madam Chair. Thank you.
just tell me when I can begin again.
Go ahead and begin, sir.
Could you tell us a little bit about the variance procedures and the waivers procedures, under the City of Riviera Beach zoning code?
If an applicant desires a variance, it is a separate application that they must submit to this department. It must meet sufficiency review and be heard by the development special magistrate.
When would you, if somebody came in, and when would you recommend to them that they look for a variance? Maybe when their lot isn't too big or they don't have sufficient frontage? Tell me some of the circumstances where they might.
My department almost never recommends that someone go for a variance. We look for developers to build to the code in Riviera Beach.
And if they don't meet the code, what happens from there?
They can redesign their project. They can request amendments to the code. And if they are not interested in either of those, they can pursue a variance. However, the standards for being eligible for a variance are very high. Most applicants do not meet them.
So if an applicant said that they couldn't do things under the code, would you tell them to rewrite the code or not do what they're doing or go for a variance?
We would notify them of their options.
Are you familiar with this particular document? It's in the backup. Let me present it to you. 600 pages. You may not be. That is a narrative produced by the applicant.
It appears to be.
Okay. There are some underlined phrases there. This is a very specific question, and then I'm done. Would you just read the underlined phrases? That is all. I think there are 3 of them.
I see shielding visual impact from adjacent buildings is not possible.
Not possible. And the second one?
The site is located on a one-way service road and therefore it can not comply with any of the standard design examples shown in the code. A combined 8-foot pedestrian walk cannot be accommodated per section 31536. Due to grade differences facing south elevation, the right-of-way is unsafe to comply with section 31-536B3B.
2 minutes.
That's all that I have to say. You can cross-examine. Thank you very much. I do appreciate it. We'll be back for our rebuttal, and thank you very much for your time tonight.
Thank you.
Good evening, Chair. Good evening, Chair. Lina Busby.
Yes, go ahead.
For the city. I do also have cross-examination, and I would like to
Okay.
exercise my right to do so.
Yes.
Madam Chair.
Yes.
So the item that he just had Mr. Sermons to read, because this is the quasi-judicial, somebody should have entered it into or made specific reference to what that document is. If we're relying on that as factual testimony, someone needs to point specifically to what that document is in the code section or whatever that is. And that's, I think, quite frankly, that's fundamentally procedural. So perhaps he can come back or someone can elaborate on it. But obviously, if we're receiving evidence, I want to know what the source is of that evidence that he just read.
Mr. Weiner should come back.
Yes, he's gonna come
Since he
back and do
presented
that. I'm sorry, go ahead, Ms. Wynn.
Mr. Weiner should come back since he presented it as part of his evidence.
So this is both part of the backup and the history provided for by the applicant. It is called the Crab Pot Site Riviera Beach, Florida, site plan application narrative. And it was prepared by the applicant. And I only have one copy. It is in the history, so it's already part of the record. But I'll be more than happy to share it with you. The applicant has also asked for it, even though it is their prepared document. So whatever you would like. This is quasi-judicial, so.
You can give it to the clerk. She can make some copies.
Madam Chair?
Yes, go ahead, sir.
Actually, I believe, if I'm not mistaken, that is in the backup. I just didn't hear the name.
Oh, is it?
It's in the backup.
It is in the backup. I didn't hear the name of what the document was that he was asking.
Okay, we can give it back to him then. We have it in the backup. I know that he said that when he first introduced the document, that it was a 600-page document.
Madam Chair, before we go further though, so this is a 3-page document, and quite frankly, there's a voluminous amount of items from P&Z minutes. I don't know exactly, and I'm sorry to seem like I'm not understanding, but is there a section that someone can point to? Because these aren't exactly identified like a code section, and there's not a sentence or a paragraph.
You're asking to point to the section that Mr. Summers read?
That's correct.
Okay. Sir, the narrative that you had, what page is that of the document? The second page of the document?
Which paragraph? And which bullet? Madam Chair.
I do apologize for not having multiple copies. I didn't know that Mr. Sermons was going to say that it complied with each and every provision of the code, and I thought it was important to bring to the attention of the commission that the applicant had said they had not complied with the code. So that's why it is that I only had one copy. If you give me some time, I can find the exact page. I know that you've got almost 80 minutes of public comment, so I'll find the page for you.
Madam Chair, it's on the second page of the final item in the backup, and at least one of the things he mentioned is bullet number 3 in the bottom paragraph. For example, the rooftop equipment shielded from the ground view. Do you see that? Could you just, for my benefit, please repeat those 3 items? The rooftop was one of them.
Thank you. There's actually four altogether. Then at the top of the next page is the site is located on a one-way service road, therefore it cannot comply with any of the standard design examples shown in the code. And then a combined 8-foot pedestrian walk cannot be accommodated per section 31-536B3A2. And then due to grade differences facing the south elevation of the ROW right-of-way, it is unsafe to comply with section 31-536B3.
Is the board clear on the?
I have the location, thank you.
Okay, very good. Thank you, sir.
Thank you. I'm sorry that I put you to that trouble,
That's
but I
fine,
did
sir.
not know that I would be using this. Thank you. Madam Chair, may I?
Yes, sir.
May I clarify? That document, while it doesn't have our name on it, those items, just briefly looking at it, because we did not, it was done in 2017.
Just 1 second here. Madam Attorney.
Yes, I didn't realize that's what you were doing. I thought you were going to identify the document. You have to wait until the rebuttal. Ms. Busby, I believe, had cross-examination, if you're all ready for that.
Yes.
Madam Chair, so we can make sure that we have that under control. If they're referencing something, they can point to it and we know exactly and can follow along.
Okay, go ahead.
Thank you. My cross-examination is for the witness representing the non-applicant Marina Grand HOA. So Mr. Weiner, please. Mr. Weiner, You are currently involved in litigation against 7 Kings in the 15th Judicial Circuit, correct?
Correct.
In which you are disputing the easement and dedication agreement that was recorded in the Palm Beach County Public Record, Book 29033, page 363?
Well, we're not disputing that it's recorded. We are disputing what it means and
Okay.
those people who might benefit from it.
But you are disputing the validity of the easement?
I don't think that's a fair way to put it. We're disputing the way in which some people would like to utilize the easement and to whom they want to grant it.
Okay, so you are disputing that the easement and dedication agreement is permitted to be assigned as it was assigned to 7 Kings?
Well, this litigation has lasted for many, many months. The pleadings speak for themselves. I am not a litigator in the office, so I do not have firsthand familiarity with it. But as I understand it, the attempt to assign this to a portion of property that was not originally included in it, and to a tenant, has raised questions with respect to how it can be enforced. If,
Right,
if I might say, if the 15th District and the public
Sir,
record
let-
is
let her-
different than that,
sir,
that's what's correct.
Sir, hold on a second, let her.
Thank you.
So the portion of the property, though, is the actual Marina Grand Garage. It's not the 75 spaces that is on the surface parking lot that is owned by Loggerhead Marina.
The litigation has to do with whether or not 7 Kings can have any rights within it,
Within the garage,
within the property owned by Marina Grand.
okay, which is the garage. Okay, so if the judge determines in that particular matter that 7 Kings does not have a right to the garage parking, there is a severability clause, correct, in that easement and dedication agreement that provides that if any provision of the easement dedication agreement is held invalid or illegal, that there is enforceability for the remaining provisions and application thereof of the easement agreement. Isn't that correct?
You seem to have more familiarity with this document. It's before you. I do not have it memorized. So I take you at your word, but I cannot confirm it.
Okay, thank you.
If you like that to be your testimony, it can be. Okay.
The 3 surface parking areas on Loggerhead Marina property, they were owned in fee simple by Inlet Marina. Is that correct?
Originally, this ownership was all in one company.
2 minutes.
Okay, with no restriction on Inlet Marina's right to grant an easement or a sign?
I do not know that for a fact.
Okay. And the surface parking is comprised of 75 parking spaces?
I don't know that for a fact either.
Okay.
I apologize, but I'm only familiar with those things that are pertinent to this particular site plan.
Okay.
And
Correct.
as I say,
And the
that is a matter of
easement-
litigation conducted by other attorneys.
Okay, and the disputed easement then is not in front of the city council this evening? Okay, thank you.
Madam Chair,
Yes, go ahead.
so question for the senior assistant city attorney. This easement you're questioning him on that. Is that something that you plan on submitting to evidence? Because obviously you're asking him his knowledge of it, and specifically brought up the severability clause. Is that something that you have, can be provided, or something of the sort, or is it in the backup?
Councilman McCoy, no, it's not in backup. It's not before you this evening. Before you this evening is a condition of the site plan that the applicant provide parking. And I was also asking those questions to preserve some issues for other proceedings.
Okay.
Madam Attorney?
Madam Chair, next is public comment, and you allocated 2 minutes per person.
Very good. Madam Clerk?
So while they're coming, I guess I have a legal question. Would it be appropriate for me to ask you, Ms. Nguyen?
Sure.
Okay, so the cross-examination that was just performed by the senior assistant city attorney, we're not to accept the existence of this easement agreement as fact, only what the, I guess, the inter-party intervener was able, his knowledge of it. Because, I mean, it kind of seemed confusing that she was referencing an easement agreement, but that's not a part of evidence. So I guess what I'm to take is only his knowledge of it.
Correct.
Okay.
Madam Clerk?
Bob Sykes, Margaret Shepherd, Daniel McGueron. Bob Sykes. DG Sykes. Ms. Shepherd, someone is speaking before you. That's okay.
Good evening, Madam Chair, council people, city attorney. My name is B.G. Sykes. I'm a happy resident of 333 East 24th Street. I live, work, and play in Riviera Beach. I've known Ray, the applicant, since 2004. We actually had the same council at that time. I've seen him do very, very well with Loggerhead and do very, very well with all of his projects. I'm a business owner here in town. I have a yachting company. I own Blue Heron Advertising, which is the billboard at the base of the bridge. And it seems that the intention may be to disrail or disrupt something that has tremendous momentum and is incredibly welcome here, which would be the return of the Crab Pot Restaurant. The restaurant I was a patron of. I live at 333 East 24th, which is only the second row to the south of where this restaurant would be located. I would appreciate having a restaurant here in Riviera Beach that we could go to. I do support the Tiki here, but it would be wonderful to have a waterfront restaurant here in Riviera Beach. I know I have 48 seconds, but let me say, being a fellow business owner, if it's 3 spaces that are standing in the way of your giving an approval to this, I own the billboard, I own the property below it. Ray, if you need some help with that, I'm sure we can work something out. But if that's going to stand in the way, I know that I would help him. I know the Cromwells would help him. There are plenty of neighbors, the Nagels. If it's 3 spaces, I'm telling you, they're going to go his way. And please do something that would be very good for that immediate area. I love Riviera Beach. I've invested millions and millions here, and I'd like to see it happen. Thank you very much.
Thank you.
Margaret Shepherd, Daniel M. Tika Sullivan.
Margaret Shepherd, Riviera Beach. I got several calls, maybe about 9, and they were asking me questions. I tried to get a hold of planning and zoning. No one called me back. I think I did it 4 times. But I want to go on record by saying I love the Crab Pot. I like to see it come back. But after you heard everything, the biggest thing that's going on now is the parking. And I think if we can kind of settle the parking, I think we could kind of gravel through this. I think it's a wonderful place. When I first moved here, I mean, I had a good time. My family was here, but we have nowhere to go here in Riviera Beach. The main thing that the residents over at the condominiums was saying that they are in fear for their life of going to the parking lot to get their cars. Or I think one lady was saying about the vagrants under the bridge. Another one was quite terrified because it is, I heard him say it was okay for the traffic. That's not true. I live right there at the base of the bridge. I used to walk to Publix. I no longer trust myself to walk. That's the only thing that I think that the Maria Grande is talking about, parking. Do we allow parking to get in our way? Well, I lived down in West Palm Beach for a year, and I'm telling you, anybody been there going to the movies, Cheesecake Factory, Publix, I live right there across from Publix, the traffic is horrendous. We have learned how to adapt to traffic. So what are we going to do? This is the third time I heard this project. And I'm so glad it's coming before council because you all would put the icing on the cake. And with this, I want to say one more time, I like the crab pot. Don't hold me accountable. But
you.
hold me accountable for the public.
Daniel M., Tika Sullivan, James Almack.
Once she's called your name, could you please go up to one of the microphones so that we won't lose too much downtime in between people? Who's after him right here?
Tika Sullivan,
Go ahead to the next one.
James Almack, Mary Beth Coffer,
All right, go ahead, sir.
Okay,
Go
thank
ahead.
you. First of all, I want to thank the council for giving us the opportunity to speak. My name is Daniel McGilvery. I'm a resident of Marina Grande. My address is 2640 Lakeshore Drive, Unit 2012. The issue I want to address is the Planning and Zoning Board. I've spent the better part of the last 2 weeks trying to get a better understanding of how the P&Z interacts with developers. I've been in contact with all or most of the representatives of the P&Z board, and my conclusion from that process is that if I'm a developer and I go to the P&Z board with a site plan proposal that's rejected, I can just turn around and bypass them and go to the city council. Now, I can't imagine that that's the way it's supposed to work, but if it does, it seems to me that it sets an unfortunate precedent, because if Seven Kings is allowed to do that, then how can you turn away any other developer? So the Crab Pot site plan was presented to the P&Z originally, or the last time it was presented was in January of 2019, and the vote at that time was 3-3, and the motion failed. Those last three words are important because they're not my words, they're the words of a senior staff from the P&Z. A previous presentation to the P&Z board by the Crab Pot personnel resulted in a 5-2 vote against the project. In both cases, key issues were identified, and I don't know that we have any assurance that any of those or all of those issues have been addressed. I'm not an expert on this process, but I did look up the ordinance in the Riviera Beach Code of Ordinance.
Thank you, sir.
Oh.
Next, please.
Mary Beth Coffer, Jimmy Coffer, Joseph Soletto.
Mary Beth Cofer, 2460 Lakeshore Drive, or 2640 Lakeshore Drive, number 909. I fully support development here in Riviera Beach. We have a need for more restaurants in Riviera Beach. We have a need for more jobs in Riviera Beach. What we do not have a need for is things that don't meet the code or things that don't fit. This is not the Crab Pot. This is not what people remember from long ago. This is a restaurant called the Salty Mermaid. That's what it's proposed to be called. Now, I remember places I went as a child, and I have fond, fond memories of those places. But things change, circumstances change, and you don't go back. So this is what I think about the whole thing. The restaurant doesn't fit in that 0.35 acre spot. It doesn't have adequate parking. We don't have a walkable downtown. Maybe the city would like to build a parking garage somewhere, but we don't have that yet. I think that the Salty Mermaid belongs at the marina. At the marina, there are 3 viable restaurant pad sites. They all have water views, they all have access to docks, they all have ample parking, and they would provide a great, great opportunity for the city. In addition, I think most residents at Marina Grande would accept something smaller So why not build the Salty Mermaid at the marina and then a smaller off-site restaurant on the smaller parcel of land, using the main restaurant as a commissary?
Thank you for your
Jimmy
comments.
Cofer, Joseph Saleto, Deborah Saleto.
Jimmy Cofer, 2640.
Let me stop you right there, sir. The next person who's behind him, could you stand up so that we can kind of, come to the front so that you're the next person? Okay, all right.
Marina Grande.
What you can do, sir, the next person come to this podium so that we can just keep it going.
Thank
And then
you.
as soon as he's finished, you can go into your,
Jimmy Cofer, Unit 909 at Marina Grande. You know, the 2,000-pound elephant that's in the room that nobody wants to talk about is that on a realistic day, this restaurant's going to have about 230 maximum participants. You're talking 100 people at the restaurant probably every day. That's a minimum of 50 cars. And we're not talking about a variance here of 3 parking places. The 2,000-pound elephant in the room is declaring this the downtown parking model. There is no downtown parking. There is no high-rise garage under construction or even being considered for construction. So now you're talking about shuttling anywhere from 50 to 75 up to 100 cars. That's assuming you get 2 people per car, and most people, a lot of people will drive by themselves. So the traffic is going to be horrendous. Just because the CRA wants development and declared this a downtown parking area and built a code to that, that doesn't make it so. You're going to find it that the sidewalks are not walkable, they don't meet the code for wide enough, and you're going to be shuttling anywhere from 50 to 100 cars back and forth. And now you put the marina in jeopardy. The marina, as on Saturday and Sunday, it was absolutely full last weekend, with the last nice weekend we had. Where are the marina people going to park? Where are the people that are paying for their boats to be there every month going to park? So we're really kind of focusing on the wrong thing here. We need to change the narrative to the downtown parking model doesn't fit for this situation. Thank you.
Joseph Saleto, Deborah Saleto, Alejandra Cardona.
Go.
yes, go ahead, sir.
My name is Joseph Salito. I'm a full-time Florida and Marina Grande resident. It is understandable that members of this council would be reluctant to vote against any proposal that had future development attached to it. So my take on this restaurant project isn't to repeat what many Marina Grande residents have correctly offered as concerns, but to introduce another thought. I believe what should first be approved is a new municipal parking garage to service this restaurant and all future development on Blue Heron Boulevard from Broadway to the bridge. Build the garage first, and all else will fall in line. Thank you.
Thank you, sir.
Deborah Saleto, Alejandra Cardona, Kent Pollock.
Mr. Alejandro?
Deborah Saleto.
Hello, I'm a resident at 2640 Lakeshore Drive. I'm a full-time Riviera Beach resident. I am concerned for the safety of pedestrians. Due to the additional vehicle traffic, which would result if the planned site is approved for a restaurant. The intersection of Blue Heron and Lakeshore Drive is extremely busy already. The entrance and exit for both Publix parking garage and the Marina Grande residence creates a huge amount of traffic. Please consider the neighborhood's safety issues first. Before voting for approval of a site plan that intends to accommodate a restaurant with a capacity of over 200 patrons, operating 7 days a week. The CRA's mission is to expand the tax base by creating a welcoming environment that eliminates blight and improves the perception of safety in an area. Redevelopment is a good thing, but not for the proposed use of this particular site. Ask yourself, Will this project enhance the community or endanger the neighborhood? The Marina Grande residence is truly one of the jewels of Riviera Beach. Please do not jeopardize it. Thank you.
Thank you. Alejandro Cardona, Marcia Goldberg, Edward Glatzmeyer.
Yes, who's the next person? Wait, ma'am, who's the next person?
Alejandra Cardona, Marcia Goldberg, and Edward Glatzmeyer.
Well, it's clear Mr. Alejandro is not here. Who's the next person after her?
She's back there, go ahead.
Marcia Goldberg,
And who's after her?
Edward Glatzmeyer.
Where is he? You can come up to this podium here, sir. Okay, who's the next person?
Stephen Wallace.
Okay, come to this podium here, sir. You can go ahead, ma'am.
All right. Good evening, everybody. My name is Marcia Goldberg. I'm a resident of Marina Grande. I live in Unit 808. It's 2640 Lakeshore Drive. I'm concerned for the school children. There is a bus stop on 27th Street, and I oppose the crab pot, or whatever the name is, because of the alcohol content. People, the crossings, there is a lot of traffic already there from Publix on Lakeshore Drive, and I've seen people coming off of the Blue Heron Bridge from Singer Island wanting to make a right turn, and I've seen people on the access road not obeying the red traffic light, making a left-hand turn or making a right-hand turn. It makes it very hard for pedestrians. I'm not a great public speaker, sorry.
No, you're doing fine, go ahead.
And I've seen information that the FDOT has a proposal that they're going to be making an expansion or moving the bridge. So they need their land for themselves, and the crab pot, I don't know how it could be leased for all that. And that's not going to happen until 23 or later. Thank you.
Thank you. Sir?
Stephen Wallace.
I'm Stephen Wallace. I'm a resident of 2650 Lakeshore Drive, Marina Grande, Unit 1104. I was a member of the Board of Directors of Marina Grande at the time that then Chairman Rick Mocha negotiated the conditions of development with Seven Kings, and in doing so addressing many of the concerns that were expressed in my community, including hours of operation, parking, noise, security, garbage and dumpster location, and after-hour dock usage. I'm here to say that I support this development. I think it is a win-win for the Marina Grande community by way of an added amenity, and for the city in terms of economic development. Thank you.
Thank you. Michelle Van C., Michael Kennedy, Tamara Fitzgerald.
I am Michelle Van Cleve. I also live at the Marina Grande. I think this is let me just say, there's dozens of people who want this restaurant that are not here this evening. I have given Mrs. Botel a list of 100 people, which she requested months ago, and she called me saying there was 25% for the restaurant, and she was very surprised by getting that reaction from all the people that are not here this evening. They couldn't be here. As far as the parking and the seating, there's 396 units in our condo. We're going to be walking over. We don't need all the parking. The majority of us are going to be walking through the gate and walking to the restaurant. So I just think it's going to be a welcomed addition to Riviera Beach. Thank you.
Thank you. Michael Kennedy, Tamara Fitzgerald, Ryan Cordero.
Thank you, councilors. We appreciate the opportunity to speak to you tonight. I'm here on behalf of the marine industries of Palm Beach County. We have 400 members, many of which are in your community. We are here to ask for your support and urge you to approve this restaurant. It's a needed economic benefit to your community. It will attract people that are going to do business with our businesses, which are located around the waterway and in the western part of the city. It's a well-needed boost to tourism. You don't have a waterfront restaurant that you can look at today and say, that's in my city. This is your chance. I used to eat at that restaurant. It's a golden location for a restaurant. People can walk to it, people can look at the water. Hopefully they'll be able to get a dock. We can have a water taxi service which will not require vehicles. People will come in their boats. They will not require vehicles. This is a good fit. It is a historic use of that property. That restaurant was there, and it was there when this development was built, and we need that for our industry. It'll add some vitality to your waterfront, something you lack right now in that particular area. It'll add a good tax base. It's a positive addition to your community, and on behalf of our association and our members, we urge you to approve this application. Thank you very much.
Thank you.
Tamara Fitzgerald, Ryan Cordero, Lou Daniel.
Hi, my name is Tamara Fitzgerald. I'm coming at this from a totally different perspective. I was a business owner in Riviera Beach for 27 years. I owned 2 buildings on 15th Street. The reason I left Riviera Beach is because the development never happened. We kept talking about it, it never happened. When we took the Tiki Bar down that was here at the marina, there were no waterfront restaurants to go to. There was really no place to go and eat. I think this is a restaurant we need, a restaurant on the water. I was reading, Mr. Evans wrote in the Sunday paper, you said your staff is embarking on an effort to rebrand Riviera Beach and redefine what it means to live, work, and play here. It says we're the best waterfront city which to live, work, and play, he wrote. We have some natural amenities that rival some of the best destinations in the world. Who wouldn't want to live here? We're Palm Beach County's best kept secret, but now the secret's out. We're the best waterfront city without a waterfront restaurant on the mainland. It makes no sense to me. And the parking issue, I moved up to Jupiter. You want to see restaurants with parking and valet and people walking. Riviera Beach is never going to move forward if they let people stop because of one issue that's not even an issue because they have the 3 other spaces.
Ryan, thank you. Ryan Cordero, Lou Danielo, Mary G. Brown.
Good evening. My name is Ryan Cordero. I am the son of Wayne Cordero. My father started the Crab Pot in 1968 in Dixie Highway. He scraped together every penny he had, mortgaged his house to put that restaurant there. Luckily, it survived, which allowed him to open the Riviera Beach Crab Pot, which this community obviously has resonated with, and they love it. I think it's shocking, though. I was watching the news and saw Bring Back the Crab Pot. I knew nothing about it. There was never any contact made to me or my family in any way, shape, or form regarding this. What they're trying to do here is not the Crab Pot. It will never be a Crab Pot, period. My family is the Crab Pot. And I saw my dad's logos, which he drew with his own hand, emblazoned on all these T-shirts. They'd never asked permission to use our logos, our trademarks, our copyrights. And beyond that, I met the marketing director tonight. She said, oh, I heard your dad died last year, and just thought, okay, we could use the Crab Pot and it would resonate with the community and get something going here, get them behind it, start a movement. So then, the billionaire fat cats of 7 Kings Holdings, J.C. Solomon II, Mr. Graziato and company, would be able to make this move that they've attempted for a long time to happen. Well, it will never be a Crab Pot. They offer, Mr. Graziato I met tonight and said, I've tried to get a hold of myself a dozen times. We also own the old Key Lime House in Lantana, Florida's oldest waterfront restaurant. I actually live above it. have for over a year through this pandemic, shortages in labor, supply chain issues, so on and so forth. That being said, I've tried to get a hold of you. Well, people get a hold of me all the time. I get messages that my car warranty's up. My billionaire uncle in South Africa wants to leave me $1 million if I send him 100. So I have no problem getting messages, Mr. Gratiato. I think you saying you were trying to leave me messages is, call it what it is, bullshit. And, make your own restaurant, call it what you want, but it will never be a crab pot. Thank you.
Lou Daniello.
Yes, my name is Lou Daniello, and I am in favor of the crab pot returning. I've lived in this community for over 50 years and remember many good times at the crab pot. It was a great family restaurant. And again, we need more venues to go to by boat as well. The parking will not be as much of an issue because of the people that will be coming by boat. And this area definitely, we've lost so many restaurants to condominiums, and we need to get them back so that we can have more venues to go to by boat. Thank you.
Thank you. Mary G. Brown.
I'm Mary G. Meg Brown, and I want to continue on Dan's statement about the Planning and Zoning Board of December 2019. He was reading that the comprehensive plan is not detrimental to the neighboring land use, that an efficient pedestrian and vehicular traffic system, including proper means of ingress and egress to the street, is provided, and that the proposed project should be viable addition to the community. So I'm opposed to this because McCoy even noted that with a tight ingress and egress to the service road and without a valet plan, and you said you found somebody who's going to do the valet, but you don't have a plan, and last thing I heard was that you're going to have little scooters or little golf carts taking you across Blue Heron Boulevard. That's not so great, and so it's lacking in the current proposal. In addition, I sent some pictures of the Department of Transportation, what they had done in the last time they used that property, and someone pointed out earlier today that they're going to use that property for building the bridge. That's 2022, and 2023. And they took up the entire land use right there, not just their little strip of land, but they had vehicles all over the place. So if they're repairing the bridge or they installing Riviera Beach pipeline for the water, they're going to take up the whole property. It's landlocked. 2 sides are DOT and 2 sides are Marina Grand. So when they bring in all these people on those 2 sides, and you don't have DEP approval for boats. So you don't have all the approvals that you need to have. Thank you.
Thank you.
Jackson Fern, number 6. Edward Payne, number 11. Brian Gibbons, number 12. Kimberly McCarter, number 15. Jackson Fern, number 6. Edward Payne is number 11. Brian Gibbons, number 12.
Go ahead, sir.
My name is Jackson Firm. I've lived in Marina Grande since 2010, and I've been coming to these meetings since 2016. You don't have enough parking with even 15 spaces. You got 12. You don't have city parking. If you did, it'd be great. If you went to Delray, that would be cool too. They got city parking. This thing would work great. I'd love to see Riviera Beach be Delray. This is a beautiful town. I love this place. I said, I love the water. I'd love to go to a waterfront restaurant, but this won't work in 1,000 years. That's why it's been denied so many times. Look at the history. How can you vote on it now when you couldn't ever vote? Nothing, he lost. He doesn't have an FDOT lease. He's missing 3 spaces. 3 spaces isn't the problem because he doesn't have enough parking. our community is in a lawsuit for the 75 spaces. The 75 spaces is anywhere on the site, not only in our garage, and it's under lawsuit. Wait till the lawsuit's settled if you think he's going to be able to use the 75 spaces. That still creates all the other problems the rest of their neighbors are talking about. So this has been denied or tied or pushed down the road so many times, it should be simple for your elected officials to just vote no. Thank you.
Thank you, sir.
Edward Payne.
Yes, my name is Edward Payne, and I reside at the Marina Grande Condominium Complex, Unit 1915. The city in the past has not given its approval to a site plan for a proposed restaurant. And once again, the city council, I'm asking once again that the city council reject this proposed site. There seems to be significant issues and concerns which remain unresolved and at a minimum in need of clarification before the city council renders its decision. It's an emotional issue, I understand that, but there are serious concerns that need to be dealt with still. Number one, as has been articulated, there's an ongoing litigation still in process versus Seven Kings regarding a parking easement. In addition, there is no signed FDOT lease. They have not signed a lease on their property, and the developer has not presented any signed documentation to the contrary. FDOT has stated in writing that they will not enter into any long-term leases for this property. They would only consider a short-term lease, and even at then, it can be canceled within 30 days' notice without cause. Additionally, the FDOT, as has been articulated again, has indicated in its plans and its budgets to use the property as a staging area for future bridge improvements, which further supports the situation that no lease would be signed by the FDOT. Additionally, it's come to my attention, and I was not aware, but Riviera Beach's new water line onto Singer Island goes through this property. And if that happened, I don't know what you would do. In addition, the FDOE and the FDOT have not agreed to lease any lands submerged under the water for the site's planned proposed boat dock due to the concerns about the FDOT losing its rights to land under the Lake Worth Lagoon needed for future Blue Heron Bridge expansion and operation.
Sir, that's your time.
Okay.
Thank you.
Obviously, I object to this.
Okay.
Brian Gibbons, number 12. Kimberly McCarter, number 15. Brenda Cooper, Bob Smith.
Go ahead, Mr. Smith. No, who's that?
Hi,
Mr.
my name
Gibbons.
is Brian Gibbons. I also live in Marina Grande, and I've also been attending these meetings since about 2016. During those first meetings, by the way, at that time, I had indicated that I had been involved with building restaurants all over the U.S. and Canada. And when I heard this thing was going to be built without any on-site parking for the restaurant, I thought it was the most ridiculous thing I could ever dream of. Over the last couple of years, while things have been going or not going well for them, I had some of these people that I was building restaurants for come and take a look at the property and take a look at where the parking was going to be. One of them made the comment, these guys must be looking for a write-off. However, that's not what I really came here tonight for. I saw on the board up here that they were talking about or touting how there was going to be a tax increase. Obviously there would if that was built. But I would venture a guess that the Marina Grande complex pays more in taxes than this restaurant will ever do. Now here's my problem. We've already had people leave the Marina Grande project thinking that this restaurant was going to be built, particularly those who live in the building that is closest to where this restaurant's going to be. If that continues and people are just willing to give their unit away just to get away from this ridiculousness, the property values are going to go down, and it's going to affect the city of Riviera Beach's income that they receive from the Marina Grande complex. I think in addition to looking at all the other problems there are with this complex, the restaurant complex, that you ought to consider what the city might lose in revenue by doing this silly building that's not going to work to begin with. Thank you.
Thank you, sir.
Kimberly McCarter, Brenda Cooper, Bob Smith. Kimberly McCarter, which is number 15.
Sorry?
Brenda Carter, Bob Smith, Sarah McKenna. Dion Topper, I believe that is. I may be messing it up. Whoever was assigned the pager for number 7. And Dr. Becky Keshmiri.
Sarah?
Okay. All right. When I say crab, you say pot. No, we're not there yet. Okay, so looking around the room, I'm the most hated person here because I have something you don't have, and it's called youth.
Could you speak into the mic, please?
Yes, I have youth and you don't. So that's a problem. You need to look into the bigger picture for Riviera Beach. What's going to be here in years? I think the bigger picture here is that West Palm Beach is becoming a growing hub for international business. I used to work on the City Place account, and I worked with GoPal. Is West Palm Beach not expanding and welcoming international business and welcoming new technological companies that are internationally renowned and making West Palm Beach a destination similar to Fort Lauderdale, which was years ago like Miami? So I believe that the Palm Beach Post recently also let out an article that shared that they're going to try to reimagine the space between West Palm Beach and Riviera Beach as a Wynwood-style area. And I think that just brings more growth to the area, and we need to very much capitalize on that as much as you can, making this a welcoming area and making people want to come here. Riviera Beach is beautiful. I grew up here. I love this spot. I grew up going to the Crab Pot. I helped with the conservation for the Blue Heron Bridge. It's a #1 world-renowned dive destination. People come from all over the world. I don't think that resonates with you guys. People come from all over the world to come to the Riviera Bridge, and that is amazing. And we could have a restaurant there that is also a destination that people can recognize. And the poverty rate here is 22%. I'm from here, and I remember taking my family to the iconic Crab Pot, and I worked at the Tiki Bar that used to be in this marina as well. And I think that we should bring jobs to Riviera Beach. We should give people an opportunity to capitalize. I'm friends with a bunch of the homeless people in my neighborhood, and they all say they work here and they want jobs. And I think we need to give them the opportunities that they want.
Thank you.
Thank you.
Brenda Cooper, Bob Smith, Dion Topper. Okay, whoever was assigned pager number 7. Dr. Becky Keshmiri. Madam Chair, members of the board, that concludes public comment.
All right, somebody back there. Artie Williams.
I have a card from Mr. Artie Williams, but it's marked as public comment. It's not marked as for item number 23.
Okay.
I don't know how y'all skipped all those people.
I got a list of some members that have pagers that did not want to speak. Number 5, number 18, number 9, number 13, and number 14.
Okay, well, my name is Artie Williams. I'm here on behalf of the Youth Recreation Association, the Dan Calloway, and all of the thousands of people that's behind him, and the Mothers Against Murders Association. Now, we always say that Riviera Beach is the best waterfront city to live, work, and play. And I believe that, but it's time that we live up to that. It's time that we get a restaurant of our own on the west side of the bridge. And why not have a quality seafood restaurant that's family-oriented right here? I mean, we can't let growth stop happening here in Riviera Beach. And always going to be people that oppose something that's going to bring progress. We can't let 400 units determine what speaks for thousands of people in this community. We cannot do that. And I'm kind of appalled to feel that they feel that that's the only thing that matters. What matters is that thousands of people in this community want to have a restaurant of their own. We don't have any restaurants in Riviera Beach that we can sit down with our families and go to. And for us to sit up and go through this time and time again is ridiculous. It's time that we sit this and put this to bed, bring in the crab pot, give Riviera Beach what they need, but most important, give the citizens what they deserve. And what they deserve is a quality restaurant of their own. Let's bring back the crab pot. We need that.
Madam Chair, members of the board, there are members of the public that have pagers. However, their cards are marked as public comments. There is no agenda item that is indicated on their public comment card. So,
Yeah, okay, what you can do is mark it as this.
Say that again?
Mark it as for this issue. Mark the cards for this issue. If they want to speak, it'll be marked for this.
Okay, Bessie Brown and Cindy March.
That's public comment, or is that for?
It's marked as public comment. It doesn't have an agenda item number on it.
Madam Chair,
Yes, go ahead.
if I might, when they come to the mic, they have to be speaking on this issue. Otherwise, she can move the card. The clerk can move the card back to public comment.
Okay. Yes, go ahead. Are your comments in relation to the crab pot?
Yes.
Thank you.
Hannah Gravino, I live at 2640 Lakeshore Drive, and my concern is the traffic, which I sit and watch the traffic. I hear the traffic, the motorcycle speeding, everything. I'm concerned with people getting hurt. I'm also concerned with everything that the people have said, and I thank them, my neighbors, for all the research they've done to bring us to where we are. And I just hope that you don't approve this, and I hope that they'll just go away and leave it. Period.
Thank you.
Hi, I'm Toby Payne. I live at Marina Grand, Unit 1915. And I agree with everyone who said about the parking and the traffic. I don't want to go through it again. I do think it's dangerous. I don't think it's helpful to Riviera Beach or to the people who live there. And I also want to say, when I was a young girl, I used to go to the crab pot with my father. And this is not the same crab pot. It's not the same area that it was when I went. There was nothing there when I went. It was the bridge, and there was the crab pot. And so you can't compare apples and oranges right now, and you can't say, we want the same crab pot back. It's not going to happen, and it's not going to be the same thing. And I hope you realize this. Thank you.
Thank you.
Bessie Brown, Cindy March,
Are these,
regular comment?
okay,
Madam Chair, members of the board, that concludes public comment.
thank you. Madam Attorney?
Yes, Madam Chair, next would be, I'm sorry, the rebuttal and summary. 5 minutes.
We have to limit, there is no such thing as limit, but you have to be quiet in the audience because the sound travels straight here and we can't hear anything anyone is saying if there's too much chatter in the audience. Go
Just
ahead,
a
sir.
comment, if I may. I mean, as a matter of procedure, normally the applicant gets the last word on the subject. This is a little unusual to have the applicant have his rebuttal and then be rebutted again by somebody else. I'd like to request that that be reordered and that Mr. Weiner come up here and present whatever rebuttal he wants to make and let me conclude.
I'm fine with that. Initially, the city was supposed to go first, and you all jumped to the mic, so.
No, I
I'm
wasn't
fine
sure the
with that.
procedure. Thank you.
Mr. Weiner, you have 5 minutes for rebuttal and summary.
I was going up to make my statement with respect to that particular remark. Please give me a moment.
Madam Chair, members of the board, while those that are testifying are preparing themselves, there's a member of the public whose name was called, but they did not come up. I do believe the officer is checking now.
Well, let's make sure, Madam Chair.
Yes.
Because of the nature, can we make sure that we don't exclude anyone before we go further?
The cards have been gone through, Madam Chair, members of the board, and we do not see a public comment card from that gentleman. Nope, that says Joe Barr. That's not Joel. I don't see one for Joel.
Are we clear on the public comment?
Let me check and see if they put the wrong number on it, Madam Chair. Say that.
For the record, Michael Weiner again at the microphone. And,
It's not, okay, go ahead, sir.
For the record, Michael Weiner at the microphone. Attorney Perry showed his skills, but I want to place on the record that I object to this. The procedures were described in a letter to me. I relied on that, and I believe that this is a violation of due process to change them in this procedure, in this manner. Let me get to the
Madam Chair.
rebuttal.
So
Yes.
let's pause on for a second. So obviously, if he set forth the rules of quasi-judicial hearing that obviously laid out the process, he's just basically warned us that this is a procedural due process. Ms. Nguyen, can you please confirm what's the proper order in which we should be going in so that we don't, all this is not in vain?
I will, and Mr. Weenie is correct. And the rules that I read to the council were that it would be a presentation by staff, then a presentation by the petitioner, Seven Kings, and then the party intervener. And so the cross should go in the same order.
But
the rebuttal and summary should go in the same order.
Okay, well then I think that's where we need to go.
Yes.
That's the defensible option.
Thank you.
So the city wants to make its rebuttal and summary?
Good evening again, Madam Chair, members of the council. Just in summary, the staff will continue some points that weren't quite made earlier. Staff has, as far as the timeline with the Planning and Zoning Board, this item failed to garner a positive recommendation for the board. However, our code as it relates to public hearing does not require a positive or negative recommendation from the Planning and Zoning Board. It only requires that that body hears the matter in a public hearing and that they provide a report to this body to advise your decision on the project, and those aspects did take place with this. Since this item was advertised, there were dozens of emails and calls received to the Development Services Department. In support, there were 28. In opposition, there were 16. Of those comments coming from the community, several regularities occurred amongst them for what the major concerns were, and I think you heard a lot of them in public comment. Again, I will touch a couple of them. Ongoing litigation. Again, because of the contesting of the parking easement submitted for this project, staff has removed it from the resolution. Therefore, the condition states that they must provide evidence of 3 parking spaces before any development can take place on the site, so that the applicant has the option of continuing to pursue the spaces in the easement document, or they can go to another property to satisfy that requirement. But either way, the city is removed from the dispute between those neighboring property owners, and it can be handled at a civil level. Once it's resolved, they can bring back a court order to utilize that easement, or they can bring back a document for another property to fulfill the requirement for the remaining 3 spaces. The FDOT easement, again, it's a contingency. We have spoken with them. They are in talks with this applicant to establish that easement lease. FDOT will not finalize that lease until the city makes a positive vote on this application, stating that we would approve it. Once the applicant provides this resolution to them, that will be one of the prerequisites for FDOT to issue a lease. So based on our conversations with them, they have displayed or communicated no high-level concerns with what's proposed here. Additionally, the previous restaurant at this location was in the easement, so there were no significant issues for the instances when FDOT needed to do construction in their right-of-way. There were questions from the public related to the water main on the site. We have statements from the utility district stating that the proposed development would not cause any issues with the underground water main running along the south side of the property. They have brought up the water main.
2 minutes.
2 minutes? They have brought up the water main that is in the Lake Worth Lagoon, and that is why they proffered the condition number 9, which I will read into the record. So staff recommends approval for the project because it's consistent with the comprehensive plan policies 1.214, 1.2.19, downtown mixed use land use district. It's consistent with the community redevelopment plan. It's consistent with the land development codes. And the project meets 4 out of 7 of the purposes and intents of the downtown district's code. As far as the conditions for approval of this resolution, they are the standard conditions except for 8 and 9. 8 I've discussed with them having to come back with the 3 additional spaces. 9 is what was communicated from the district, and it reads, the location of the existing 16-inch CL water main shall be shown on the pending construction plans during building permit submittal for the project. The building permit application shall show how the proposed dock will not conflict with the existing water main located in the Lake Worth Lagoon, and shall include a statement signed and sealed by a licensed professional engineer certifying that the proposed dock construction will not cause any damage to the existing potable water main located in the Lake Worth Lagoon. The pending construction plans shall also include the following notes, and notes A, B, C, and D will be provided to you so that you can read over the full language of the condition. And that concludes the staff rebuttal.
Thank you.
Marty Perry again for the record. Mr. Gentile is going to respond to the comment, the cross-examination of Mr. Sermons.
Yes, very briefly, the statement that Mr. Weiner provided was one of the original staff, our site plan application narratives, and very briefly, what needs to be, what is taken out of context is that there's a specific line written because there was questions by the planning staff at the time, who was Mr. Gagnon and other staff members. If you look at it, the rooftop equipment, we meet the code provision. We were asked, can you screen it from an 18, 20-story building, and no, we cannot. That is not possible in any condition with any project. The code requires only from the roadway view of any direction. The other thing is the site is on a one-way service road, so there is no one-way service road shown in your code to provide the street project, what's required. So that was made the statement, just the statement that is not in your code. The other items is the grade differences in the front were accommodated by putting the entrances to the project in a front which came from the sides because we couldn't meet handicap requirements. We do now. We meet the ADA requirements, which your building code requires. Didn't read the items in full context. That's all I have. Go ahead.
Thank you. To add to that, just briefly, you've got a professional staff that services the city. They have reviewed this project thoroughly. They've given you a recommendation. We believe their recommendation is correct. The reality is that, in fact, the project as presented does meet the comprehensive plan of the city. It's consistent with the plan. Secondly, we meet all of your codes. The issue that's been focused on by everybody, and it's an emotional issue, there's no question about it. We've got a number of people in Marina Grande that from the beginning of this thing have objected to the construction of a restaurant. Keep in mind, however, that this restaurant was in place even while Marina Grande was being constructed. We have photographs that were shown to you that reflected that. It was a vested restaurant, it was there. Unfortunately, it was torn down in the hurricane of 2004, one of those 2 hurricanes in 2004. But the fact is there was a restaurant there. All we're seeking to do is put a restaurant back there again. We think it's a needed complementary thing for the city of Riviera Beach. You've heard that from a number of people tonight. The reality is that you don't have any significant waterfront restaurants in the city. You've got a little restaurant here at the marina area. There was a restaurant, another restaurant that was here, a cocktail lounge and restaurant for a number of years. It's not there any longer. The reality is that for a city that's basically a waterfront community, you're lacking in that kind of space. Here's an opportunity to put it back again, but we do in fact meet your codes, and that's what's important here. You need to focus on that. Now, it's an emotional issue, I'll grant you that. The fact is, however, that we have met with the Marina Grande people. We negotiated an agreement with them. You had a gentleman from Marina Grande that came up here and spoke in favor of us, said that he was part of the negotiations on that. We attempted to address all of the issues that they raised, and we did, and we will still comply with those. That's a fact that we're willing to do. We're not looking to be bad neighbors. The big issue that's been thrown around is the issue of parking. Your staff reflects that we can meet the parking requirements of the ordinance, and we do. But in addition to that, it's important to note, and Mr. Gentile, when he made his presentation, went through this, that site originally had 75 additional parking spaces that were not required. Now, why, I asked you, did they have those additional 75 spaces? The fact is, there was a restaurant proposed on the north side of Marina Grande, on the other side of the marina. That restaurant never got built. Those 75 spaces were for that restaurant. Those 75 spaces, notwithstanding efforts to litigate against that and say that that easement is no good, notwithstanding that, that easement is going to be proven to be good. We're entitled to use those 75 spaces. We don't need to use the spaces in the parking garage. But out of concern for their fears about security, we agreed to limit our use of spaces in their parking garage to only personnel, specific management personnel that would be identified for the restaurant. If that goes away, that's not a problem. We don't need that. I showed you a letter from a parking company that's a well-regarded parking company. They're at 1000 North. There are a number of other places, okay? They're well capable of handling parking. The issues concerning traffic and all that have been vetted. They've been vetted by the County Traffic Division. They've been vetted by everybody. They've been vetted by your staff. There are no issues like that. What we have is an emotional response here. And I suggest that from the standpoint of meeting your requirements, we've done that, and your staff acknowledges that. Thank you very much. And we agree with all the conditions.
Madam Chair?
Yes.
Now is the time that the council gets to ask all of their questions. Please keep in mind that once you say that you have no more questions and you begin your deliberations, you cannot ask any additional questions.
This when?
You have one more.
Oh, I'm sorry, Mr. Mayor.
Again, for the record, Michael Weiner here on behalf of Marina Grande. I'm just going to say some facts and read some statements. 15 is more than 12. Code requires 15. Your code says, just reading it, street walls are required on both primary and secondary streets, 539E. Required. Just reading the code, pardon me, the number is 531, 535, 9. Mechanical equipment necessary to the operation or maintenance of the building, etc., shall be enclosed, screened in such a manner that the enclosure is an integral part of the overall building design. When the submissions were made, it was actually admitted it couldn't do those things. How can we, based upon the facts, not my statements, their own statements, and the clear indications of the code, say they do? We can't. They don't have 15 spaces. It's not fully enclosed. And they haven't turned in the screening walls. But here's the most important issue that everybody wants to dance around. They don't want to talk about, so let's talk about it now. Even in their response to my letter, and this is their own writing, the applicant agrees there is a reverter. The applicant has been continuously engaged, well, I guess now for 5 years, with FDOT and FDEP about the reverter and its release. The applicant is currently obtaining sketches and legals of the applicable area 5 years later, here's where we are. We're getting legals. We don't know which direction we're going. We don't know whose land is going to be included. We don't know if it's going to be under the billboard. We don't know if it's going to be on the FDOT. We don't know if it's going to win the lawsuit. That is not the floor that the city of Riviera Beach should be setting for approval of a site plan application. Are you really going to let people walk in here and say, I've got something, but I don't have the other people who own the rights that are important to me, but I just want to do it? Give me an order so I can go back and tell them I already won with the city of Riviera Beach. You got to do this. It's not the way land planning goes. And I'm sure some courts would agree with me. I was looking. There's a case called Porpoise Point Partnership versus St. Johns County, 532 SOD 727, decided in 1988. There was an unpopular landowner. He got his land rezoned, wanted this, wanted that. They didn't really like him. So one day they decided, okay, you know what, I'm going to rezone your land.
2 minutes.
And then I'm going to give you a site plan on it. And he said, I don't want that. So the court came back and said, although a zoning authority generally could rezone property, a planned special development by its very nature must be sought by the property owner. Do I need to read that again? A planned special development by its very nature must be sought by the property owner. And it cannot be imposed over the owner's objections. At this point, what do we know about FDOT? They don't like it. It goes on to say, the Board of County Commissioners, by approving this procedure, encroached upon the private property rights of the owner. Look, I don't want this to go off to litigation. I also do not want to see the city of Riviera Beach set its standards so low. No one is saying this land had to be a park. None of the people who came from Marina Grande said, no, you can't build on it. All we're asking is to do it right in the proper order. Get FDOT to sign that application. Get the consent. See what the lease looks like. And if it's not there, find out how this litigation ends. While your assistant city attorney may have an idea of what the outcome is, quite honestly, we don't know what the outcome is. And under those circumstances, for you to go forward and to make a decision would be putting yourself in jeopardy with respect to the ultimate development of that land. Because you'll only be giving them an approval that somehow or another is not proper or not correct. Look, what's planning? It's planning. So get the facts in and let's plan. Not kick it down the road until such time as people who have significant property rights are finally at the table. It's such good sense. You will do wonderful with your waterfront. Just let's do it in the way that it should. So thank you very much for your time and the effort you've spent on this in the last 5 years. I do appreciate it, and so does Marina Grande. Thank you.
Thank you.
Madam Chair,
Yes.
we got a lot of information, so I want to go back to Ms. Nguyen. Procedurally, you said we have 5 minutes to ask questions?
No, I did not put a limit on the council's questions.
I'm sorry?
There's no limit on the council's questions.
Oh, okay.
It's just that once you decide that you all are finished with your questions and you start to deliberate, you can't ask additional questions.
Okay. So, are we at that point?
Yes, sir.
Do you have questions?
I would ask the chair if I could go first, and I mean, I have others, but I want to directly respond to the case law that Mr. Weiner just responded, since it's pretty fresh. So, Madam Chair, can I?
Where are we here procedurally?
Now is the time for your questions of any of the parties, including staff.
Okay, so does that fit within? Okay, go ahead, sir.
Mr. Weiner, please. Thank you. I believe the case you cited was Porpoise Point Partnership versus St. John's
Porpoise
County.
versus Partnership, I can bring it back to the...
1998. I'm sorry, 1988. Okay. So you specifically said the Board of County Commissioners, by approving this procedure, encroached upon the private property rights of the owner. Is that correct?
That's correct. That's a sentence from the case.
But I'm not sure that that actual case describes the same situation here, because the sentence just before that one says, although a zoning authority generally may rezone property without the owner's consent, a planned special development by its very nature must be sought by the property owner. It cannot be imposed over the owner's objection. That's not what happened here. Even further, it says, and this is what I think is the very much different situation, it says the county zoning staff basically stepped into the shoes of the owner and prepared the application for the planned special development. That's not what is occurring in this situation, Mr. Weiner. Wouldn't you agree?
I would agree that the staff didn't do it, but I would also say that the applicant did it. So, look, the case is slightly different in that the county took the initiative. Here, an individual is taking the initiative. In a way, it's a worse situation. Imagine, at least a county might act under some cloth of having sovereignty, of having sovereign powers with respect to property. This is a worse case, and so I'm glad you brought it up. Here, the applicant is saying, without ever the FDOT being here, except for one letter where they said, we don't want it, we don't want the parking, you got to come back and see us, we'll only give you a 30-day lease. Except for that, the applicant is taking rights. So this case is demonstrably worse than Porpoise.
Okay, I hear your response, but I got a follow-up question for you. In your time as a land planner, well, let me start with this. The very first slide of presentation, you gave us a chart saying that FDOT did not grant authorization. Have you ever seen a case where the Florida Department of Transportation or the Florida Department of Environmental Protections has went to a municipality or to a Board of County Commissioners and submitted an application in conjunction with an applicant that chooses to lease their land? Is that something in this?
I haven't seen it with FDOT. I have seen it with other government agencies where they own the land. Don't forget, this is a different situation.
Right, but my question
This is not roadway. This is land owned by FDOT. I have seen it, for example, on Fine, where there has to be first an agreement before they will allow the land to be subject to site plan or to move forward. It may be just my lack of experience, and I didn't have a case on point, but I can tell you that other government agencies, when they own land, as a landowner, not for any particular governmental purpose at this case, they have in fact required that they be involved in the applications.
Okay, and I thought, maybe I'm not sure where I got it, but we received some communications from AFDOT that they were exploring, but I guess, in fact, I received a communication saying that they would consider the lease so long as the site plan was not contingent upon, FDOT's property to fulfill the parking requirements.
FDOT's not here. We're only trying to interpret their words. I think they were slightly different. The important point is that you do not know at this point what FDOT will allow to be built on that property. It's permanent improvements.
And I get it. So that's another follow-up question. So I thought I seen one of the conditions was that they had to secure the actual lease with FDOT in order to move forward with getting any kind of building permits. So that would actually just diminish that concern, wouldn't it?
Look, in my experience as a zoning attorney, there isn't a chicken before the egg. You have definitely put the egg before the chicken. You would have that lease in hand before you gave an approval.
But you just testified that you've never seen a situation where that occurred.
I've seen it with other government agencies. It's only my lack of experience with respect to an FDOT. It's very rare that FDOT owns land that is not otherwise utilized for a roadway. This is an unusual situation. They don't often have land which is surplus land like this.
Okay.
So I'm sorry that I didn't have an experience like this before, but I have had it with other government agencies, and we have been farther down the road with respect to that agency than you are with FDOT today.
Okay, another question I have for you, and this was cited by Mr. Sermons, this section of the code is 31-539, subsection E10. Within the CRA, off-site parking arrangements may be provided in lieu of on-site parking as long as sufficient documentation of the location and number of spaces is provided to the review authority. So would this be the barrier that you believe that they haven't provided the lease or any kind of documentation?
I think you've answered the question with the way you have phrased your question. Precisely. Right. I mean, precisely sufficient documentation. Your own code requires sufficient documentation. What documentation do they have?
Right.
We're working on a survey. We're working on some information. And we also have some documents, but they just happen to be in court, and we don't know who really has the rights under them.
And Mr. Weiner, that takes me back to my previous question. So if that is true, I guess subsection 10, wouldn't the condition and the contingency of having an approved lease be the requisite before they can get any kind of building permit? So I guess we're still in that phase. So are you suggesting that we have to actually have an executed lease before we even begin that process of submitting the site plan?
This is a specialized area designed by your code. You have to decide whether or not there is the ability to do this. There isn't any documentation that allows you to do it. So you aren't going to enter into a site plan approval that says, you know what, when you buy the property next door, thanks very much for laying out where it is, but this is going to be subject to you buying the property next door. That's precisely what you're doing here tonight if you vote in favor of it. That is precisely what you're doing. Now, those kinds of, buy the property first. That's what should be done. We are not close enough to be able to know what the design should be at this stage.
Okay. All right. Thank you, Mr. Weiner.
You're welcome.
Mr.
Thank
Perry?
you for your interest.
Thank you, Madam Chair. If you can indulge me for a couple more questions.
Okay, any other questions from the board in regard?
Indulge me for Mr.
Okay.
Perry.
Okay, go ahead.
Thank you. Mr. Perry, starting with one of the same questions, have you in your experience seen Florida Department of Transportation or some other, well, I guess Florida Department of Environmental Protection to enter into giving someone a preliminary agent authorization to submit a site plan?
I can tell you my personal experience with the Florida Department of Transportation is they don't do that, period. You know, they won't grant you approval to do anything subject to the city or the county doing something after they do it. They wait until you've got site plan approval, then they'll consider it. In this particular case, we've already vetted this through FDOT, and although we don't have approval, they're waiting to see whether we get site plan approval from you all. If we get site plan approval from you all, then we'll submit to them. And the reality is, I believe that they will do it. They indicated they would do so. But whether they do or not, we don't need the FDOT parking spaces in order to meet your code.
I understand. My next question, Mr. Perry, is has the easement agreement that you know of provide for rights to be assigned or transferred?
The easement agreement?
Yes, the one that's in dispute.
Yeah, absolutely. I believe it does. I think we've got two other counsel here tonight that also agree with me.
Okay.
I mean, and we previously vetted this through your prior city attorney, and he agreed with us.
Okay, thank you, Mr. Perry. Last question, Madam Chair, to Ms.
Yes, go ahead.
Busby, I believe. Same question, Ms. Busby. In your reading or understanding of the easement agreement, does it provide for, I guess, a transfer and an assignment of those spaces?
Okay, well,
Councilman McCoy, let me just say that it is the city's position, representing the Department of Community Development, that we have made this a condition of the site plan approval. Whether or not the applicant provides the 3 spaces from their easement agreement through a lease agreement, through a lease agreement with an abutting property owner that was expressed this evening, the city will not issue any permit until that is provided to city staff, and city staff reviews that as being competent and substantial evidence of satisfying the code provision.
Okay.
Now, I have reviewed that litigation and the easement and dedication agreement on my own, and I do find, in respect to the surface parking spaces, I do find that Inlet Marina had the ability to assign the use of those parking spaces to 7 Kings.
Okay, Mr. Sermons, I think you started off alluding to the condition for UD that's not in here. Can you speak to that?
I'm sorry, could you repeat the question, please?
You said utility district had another condition relative to perhaps the docks or the water main. Can you
Correct.
speak to it?
The district has stated that although there is no issues with their underground water line to the south of the property, they are, and I want to clarify that this is noted on the site plan as well as in the proposed condition. The dock that they have depicted is not approved by the site plan. The dock has to have a separate permit from the city as well as a permit from the Department of Environmental Protection. But it does show that they, in the future, they would like to have a dock. The utility district has stated that if they do secure approval for a dock, that those conditions for construction need to be met, and that is the language that's in the proposed amendment for condition number 9. Would you like me to read the entire language of it?
I'm sorry, you said it's in condition number 9?
Correct.
Is that a?
He added it.
Is that a new condition?
Yes, they are proposing to amend the resolution to add that condition number 9.
Okay, well, that's all I have as far as questions. I didn't see that amendment, so I think I'm done, Madam Chair. I'll take a look at it. Thank you.
Madam Chair?
Yes, go ahead.
Thank you. I have some questions for Mr. Perry as well, and for Mr. Sermons. Will there be any additional meetings with Marina Grande residents to discuss the noise issues, the safety issues that they've raised this evening, the security issues? Does the applicant plan on having
Just to
additional?
stop you, Dr. Botel, but we cannot have crosstalk in the audience. We cannot hear at all up here because the sound travels to the front. Please refrain from talking in the audience because we cannot hear at all. Go ahead, I'm sorry.
Thank you. I wondered if there would be the potential for any additional meetings. I know there have been several, but could there be additional meetings with Marina Grande residents to discuss the noise issues, and particularly the safety issue? I wonder if the safety issues with regard to the parking, or not the parking, parking is the big question tonight, with regard to the roadway between Marina Grande and the Publix, those traffic pedestrian issues.
Could we have more discussions with them? I'd be honest with you, Ms. Botel, we would prefer to finalize this thing. It's been 5 years in the making.
I'm just asking if you would consider, if we approve it tonight,
We're not beyond having further discussions with them if you go forward and approve this tonight.
And I think it was already answered about the FDOT lease. It's not really necessary to meet the parking requirements. It's something that would be, you can meet the parking requirements, I think it's your explanation, by using the 75 spots on the land behind the marina. Right?
Correct. There are surface spaces.
The surface spaces. Could you explain to me the issue of the boat dock and FDOT? I know we're not voting on the boat dock this evening, but just for my own edification, something was raised as to whether or not you couldn't possibly build a boat dock there. Explain that to me.
There's some issues that we'll need to address with the Department of Environmental Protection, but I believe that we can address those. We've looked into that significantly, and there's a condition that deals with that. If we can't meet that condition, then we won't have a boat dock. But the reality is we believe we can.
Okay. I have, then I think the rest of my questions are for Mr. Sermons. Thank you. What's the issue of the screening of the maintenance units on the roof? Are they in violation of anything by not screening them from above, which is probably impossible?
No, they are not in violation. That code refers to screening from the street level.
Okay.
So in the example mentioned, and even in the applicant's application, which they brought to our attention, they state that, you know, when you have a high-rise building next to your property in a one-story building, the screening rules aren't built to shield it from that type of vantage point. But for a person driving or walking by, they should not be able to see mechanical equipment on the roof based on how our codes are constructed, and this site plan does meet that.
And what I didn't understand, the quote, due to the grade differences facing the south elevation to the right-of-way, it is unsafe to comply with section 31-536B3B. What is that section, and what is it that they weren't able to comply with?
They're referring to the distance between the end of their property and the actual roadway. Because the design of the road there's a considerable amount of land between them and the actual pavement, and because of that grade change, it would not be safe to put a sidewalk that slopes to it wouldn't work, and it's not the intent of the code for them to try to do what was mentioned there.
Okay. We've already spoken about this, but just to confirm, the surface parking lot next to the marina, it's your belief, and I guess maybe this is for Ms. Busby, that Seven Kings has the right to park there, that the applicant can use those parking spaces on the ground level, on the surface parking?
Councilperson, it is my determination in reading it. However, I will, advise you, it's still an item that is being litigated in circuit court. I think there's a pending motion for summary judgment on that very issue.
Thank you.
And the applicant can probably, if you need additional details, it would probably be best to hear from the applicant's counsel regarding that interpretation.
So the litigation is not only about the garage parking, you're saying it's also about the surface parking behind the marina?
Well, my reading of the pleadings and the amending complaints is that the surface parking has not been disputed. It is the primary dispute is with the garage.
Right, that's what I thought. So this question about the surface parking, then, that's not an issue of dispute?
I think Mr. Perry is best to answer that, Councilperson.
Mr. Perry? I mean, it's just very, very important, because it seems to me that most of this question and most of the concerns on the part of the Marina Grande people and their attorney relate to parking. And if the parking issue can be very clearly explained, that those 75 spaces in the surface lot are available to them, it sort of puts to rest that issue of whether or not they are going to have sufficient parking.
The answer to your question, Ms. Motel, is that I just spoke with our litigation counsel who's handling litigation. The surface parking area is not an issue in the litigation.
Right, so to be clear, the applicant has access to 75 spaces on the surface parking lot behind the marina.
Correct.
Thank you. Mr. Sermons, did the staff do any analysis of the pedestrian accidents or crossings from the Marina Grande property to Publix?
There was traffic reviews related to this by Palm Beach County, and the city engineer also looks over those reports, and all comments or issues were resolved.
So there, to your thinking, there's no issue with safety with pedestrians crossing the street there, or with people making a right-hand turn off of Blue Heron coming over the bridge?
To my knowledge, no more than any other intersection that has a lot of pedestrians and vehicular maneuvers.
Okay, thank you. I think that's all I have.
Madam Chair?
Yes, go ahead, sir.
Thank you so much. Mr. Sermons, did the applicant ask for any waivers or variances when they submitted this application?
They did not.
Okay.
Well, let me preface it. I was not on staff when this was originally submitted, but in the application files for this project, there's no evidence that a variance was requested.
Okay. And staff has recommended approval for the site plan?
Yes.
And the 3 additional spots that are being requested, they have to be secured prior to what happening to proceed with this applicant?
Prior to any construction permits being issued, all conditions of the site plan must be met, consistent with what we do with any other project that has a site plan. We review it to make sure everything is in compliance and any conditions are met before building permits would be issued.
And if we can address the parking as well, those 3 additional slots or spots that need to be secured, is there a difference between what the CRA code says, the city code? Can those spots be within a certain vicinity, with a certain distance of the restaurant, of this proposed restaurant?
The downtown parking district regulations state that if there are any conflicts between it and the regulations for the rest of the city, that the parking district code trumps and it controls. So in this situation where there is a conflict with the proximity, the downtown code would control, and it would not be a item that we would check for. So it does not apply.
And our downtown code states that the parking can be with any vicinity in the CRA district, correct?
Yes, as long as the other property is within the district.
Okay. Were there any discussions with the applicant in regards to job creation, career paths, development of the restaurant, using local minority women businesses to actually build this restaurant?
There are conversations related to that in the records of this project's files, yes.
Can you recall what was discussed in regards to creation of jobs, opportunities for our residents?
I don't recall details of that at the moment, but if the applicant can respond to what they expect to take place here, I'm sure they will be willing to do so.
Because we've sat on this dais and we've talked about developing eateries in our residents, providing opportunities for our residents, but our number 1 priority is actual jobs and career opportunities, is development opportunities for restaurants in our city. So if the applicant could address if any of those discussions have been had, Mr. Jensen.
Point of clarity, Madam Attorney. So I guess I want to raise a point of clarity, because I don't know if that's relevant or even pertinent to the review of the site plan. And I think including that is going down a slippery slope that I'm not about to sit here and allow, and I'm saying this respectfully, a board member to perhaps ask a question that's out of bounds within, I guess, the nature of what we should be deciding on. And I don't know that that's pertinent. Ms. Wynn, could you give us some direction?
Well, to that, Ms. Wynn, before you answer that, to that point, we have had these identical discussions in regards to site plan approval, in regards to job creation, in regards to usage of local and minority participation with development. So this is actually completely in line with everything we've discussed prior to site plan approvals.
Rebuttal?
Go ahead, sir.
Never have we ever had these conversations when it came to a contested public hearing. And I don't want to give anyone the impression that we're using any other decision outside of the 4 corners of the site plan application in the backup. While I think that's a noble gesture, I certainly don't want that to be a deciding factor on whether or not we decide to follow the specific, I think, 2 memorandums in our code as it relates to us reviewing site plans. It has no impact or any consideration of whether or not there's a local desire to hire, or even, as far as who's going to be doing the building. And I respect what you're doing. I just don't want to get in a situation where you're opening the door, just like one of the, I guess, parties have already suggested that there was some procedural concerns until we got it corrected. So if you want to defer that, I don't know how that's going to be impactful on your decision, but I don't know that that's relevant to the standards that we have to decide.
Thank you, Madam Chair. And point taken, I will retract that statement and request from the applicant, directing staff to continue conversations moving forward with the same discussions that this council has requested in regards to opportunities within our community. One final question, Madam Chair.
Go ahead, sir.
Thank you, Madam Chair. Actually, I'm sorry, two follow-ups. The Crab Pot that was previously there, the restaurant that was in the location, have we any changes to the code after that location was actually demolished?
Yes, there have been since it was demolished. Yes.
Do you recall any of the changes offhand that we've had?
If my memory serves me correctly, it was demolished around 2005, and our land development codes, our comp plan, our downtown redevelopment plan was redone or updated around the 2010 period.
Okay. Okay, thank you, Madam Chair.
Thank you, sir.
Madam Chair?
Yes, go ahead.
I just wanted to ask the applicant, I know it came up in some of the public comments about possibly putting this restaurant in the marina area. Can you share why this area is where it needs to go, or you're wanting for it to go there versus the marina?
I think I'd need to bring Mr. Graziato up here, to be honest with you. My only contact really has been relative to the use of this particular site when Mr. Graziato first approached me on the issue. And frankly, the prior owner had approached me also relative to the use of the site. So that this site has been the only one that's been in contention. Whether he's ever considered the aspect of coming down to the marina, I don't know how to answer that. George?
Madam Chair, if I can just
Yes,
respond.
go ahead.
This property, the entire parcel, was originally owned by Mr. Graziato, who's here is our client. And his intention to build this restaurant through that whole process was there. When that plan was done in 2004, we had the restaurant on the corner was located there. We didn't know it was going to get damaged by 2 hurricanes through 2004, 2005. And they also had another restaurant, a smaller restaurant, actually proposed at the marina facility, which has not been built. So this was his desire and goal to do this restaurant in this location, or to have a restaurant there. And so that's why he has continued to do that. And I don't want to have him come up here. He wasn't sworn in, so.
Okay, that's fine, thank you. And then as far as thank you. Mr. Sermons, were they required to submit a valet plan?
No, they are not. The code only requires the minimum parking, and anything beyond that is optional for them. And I believe because of the concerns of the community, they inserted their plans related to valet service.
Okay. That's it for me, thank you.
Are there any other questions in regards to this question and answer session? I have a couple of questions. I know it's a tight squeeze in the area that it's placed now. What would happen if a boat anchor hits the water main? Has that ever been discussed? This is for the applicant.
Madam Chair?
Yes.
That is a submerged water line. It's actually under the subsurface below the water in the ground going across to the island. The conditions that we do agree to, we discussed it with Mr. Sermons and his staff, will protect that line, and we have to provide exact location of that underground, and we have to make sure that we don't interrupt that line at all. And we feel very confident that that will be done both in our permitting and your building permitting and your review of that submerged line. So it's not a visible or in the water portion of it. It's actually even deeper into the soil below the water.
Right, and that's the reason why I asked about anchors.
Right. There is an existing dock piling that is there, because there was a dock that went out right from the south property line. But we will be working to meet that condition, to make sure that we don't interrupt that line and nothing happens to it, and we're taking responsibility for that, and providing all the documentation that your utility directors have asked us through this condition.
Okay, you know, there has been some conversation around the traffic and the impact, and I think that with the new influx of permanent residents that we have here now because of the pandemic, that there will even be more traffic in that area, and I'm kind of concerned about that as well. I'm also concerned about, you know, talking about walkable communities when the primary walkers will be Marina Grande residents. And I really have some heartburn with the fact that the Crab Pot's family member whose father built the Crab Pot said that you basically stole their logo. And I really have some real heartburn with that because of the fact that this has been marketed as a Crab Pot. It was going to be called the Crab Pot. It was going to be the Crab Pot, and it's not. And I just don't like the fact that, you know, because, you know, one of the attorneys said that, you know, you don't want to judge on emotion, but that's what you did with this. You basically said that the Crab Pot will be coming back. That was the marketing piece, but the family member, the guy gets up and says, you stole everything. So I just really have problems with that, you know, because he's like, his father was the one who designed the logo that's on the t-shirts. And those are the kind of things that give me pause and give me heartburn in terms of how we are proceeding with this, because it's not supposed to be emotional, and it's supposed to be about the site plan, but to market this as something as if the family had, you know, was involved in, that's what I thought. So for that to come to light, you know, I just have some problems with that.
May I answer
Yes,
two
go
items
ahead,
on
sir.
that you asked? One is the pedestrian and the safety issue. You have to also realize that this is a service road that actually provides sidewalks to both sides of Blue Heron Boulevard. There are a lot of commercial uses, charter fishing boats, other retail facilities, and residential units that have the ability from the south to not cross Blue Heron Boulevard, but to get on the sidewalk and walk under the bridge and come to this restaurant. So it's not just the Marina Grande people who will have the benefit of their own gate access to the closest point to the restaurant, but everyone else that will be able to walk to it from the south to this restaurant. I can't answer any question in regards to the logo or the aspects of that. This project has been in front of you for 5 years, I guess. It's been in the press a numerous amount of times, and this is the first time I've heard of an issue. I don't believe there's a existing Crab Pot restaurant anywhere. That is no longer, I think, the issue, but I can't answer that. That's a legal question that Mr. Graziato will have to deal with. So, okay.
Thank you for your
Yes, ma'am.
comments. And the only other thing I just wanted to point out was that you know, I really would like for a lot of the contingencies that are being put into this plan, a lot of the contingencies, the caveats, to be taken care of before we move forward. Those are my questions.
Madam Chair, if I could have, just in an abundance of caution, Mr. Sermons to read in the new item number 9 into the record.
The proposed condition number 9 would read as such. The location of the existing 16-inch CL water main shall be shown on the pending construction plans during building permit submittal for the project. The building permit application shall show how the proposed dock will not conflict with the existing water main located in the Lake Worth Lagoon, and shall include a statement signed and sealed by a licensed engineer, professional engineer, certifying the proposed dock construction will not cause any damage to the existing potable water main located in the Lake Worth Lagoon. The pending construction plans also include the following notes. A, the existence, exact locations, and depths of utilities depicted on drawings and plans provided by the City of Riviera Beach Utility Special District, CRBUSD, shall be field verified by the contractor prior to construction. The CRBUSD assumes no responsibility for any potential utility conflicts. If it is determined that the utilities depicted on the drawings and plans are provided by CRBUSD are non-existent, partially existent, incorrect, the CRBUSD assumes no responsibility for construction of these utilities. Subsequent to receiving a building permit, the contractor shall provide adequate documentation to the City of Riviera Beach Utility Special District, or CRBUSD, that the existing 16-inch CL water main in the Lake Worth Lagoon has been field located. The contractor shall not commence construction until the contractor obtains separate correspondence from the CRBUSD indicating the field location is adequate and that the contractor may proceed with construction of the proposed dock extension. C, the contractor is responsible for any damage done to CRBUSD utilities as a result of this work and claims from the CRBUSD's customers as a result of damage to the aforementioned utilities. The proposed dock design submitted for construction must comply with all applicable codes and regulations, and approval of this site plan shall not be construed as approval of the dock design.
Very good. Madam Chair, if you all are finished with your questions, you may begin your deliberations.
Madam Chair and members of the board, as you begin your deliberations, let me remind you of the time. It is 9:47.
Move that we continue and finish the agenda this evening.
Second. Madam Clerk?
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
That motion is approved. You may proceed.
In terms of deliberations, are there any other issues from the board that you want to bring up, you want to ask your other board members, or whatever at this point?
Madam Chair?
Yes, go ahead.
I just want to say a few things. I was elected in March of 2018, and right after I was elected, my legislative aide had to make this book for me, Seven Kings Crab Pot Restaurant, because I knew it was going to be one of those issues that I want to keep right on my desk and not in a file. So it sat there for quite some time. I met on many, many occasions with Sarah Goodman, Mary Beth Kofer, Joe Barr, members of the Marina Grande board, some of whom I consider friends, close friends, in fact. And for a long time, I was convinced that this project was not a good fit for that site. The residents were concerned, as you've heard this evening, about the traffic, the smell, the noise, the safety, and the parking. And had this item come before us as recently as a couple of months ago, I would have voted against it. It's such a difficult decision that I was still debating with myself as recently as last Saturday when Joe Barr came up to me at the Singer Island Garden and we spoke about it. And it's really a difficult decision. I think we've all spoken about how emotional it is. The young lady who gave me the phone numbers knows, as does my legislative aide, that I did my due diligence with regard to this question. I actually did call about 120 Marina Grande residents, and I don't know where she got the idea that it was 25% liked it. I think it was more like 25% were opposed to it. So I know that there are people in the Marina Grande who really do want to have this restaurant. Their concerns, the concerns of the people who were against it, were the parking. As we've seen tonight, it was the parking that was the primary concern, that somehow Marina Grande did not, Seven Kings did not have the right to use the parking. But it seems to me, after listening to this evening, that they do have the right to use that surface parking behind the marina. So that sort of puts that to rest. And in fact, Mr. Sermons was smart enough to put that item number 8 in about prior to the issuance of a city building permit for the project, the applicant must provide the city with proof of 3 additional off-site parking spaces. So I think that we're safe with regard to the parking. I know that the developers have made several concessions. They've limited the hours of operation. They've limited the use of the parking garage itself, if they even use it, to just 8 key people. They agreed to limit live entertainment. They agreed to only let Marina Grande residents have direct pedestrian access from the Crab Pot directly to the Marina Grande condo building. They agreed to install security cameras on the Crab Pot site to be monitored by Marina Grande Security. They agreed to close the dock at night when the restaurant closes, and they agreed to have the restaurant dumpster emptied 3 times a week. I know this because I've had these conversations both with the applicant and the Marina Grande board, and so I know that many concessions were made. And I think that there is still time, although we're going to vote on this tonight and it'll be done, I think there's still time for there to be that good neighbor policy back in place that the gentleman mentioned. You know, I think the Seven Kings people really do want to be good neighbors, and I encourage them to continue to meet with Marina Grande residents and to continue to have that dialogue and find out what the rest of these issues are. We know that the parking is probably not an issue, but what are the rest of the issues, the security and so forth? Let's be sure that we have a good partnership here. In addition, I don't think that we can prohibit an applicant who has met all the code requirements from using the land that he owns for this purpose. As I guess it was George said, Mr. Graziano has had this land in his ownership for many, many years, and this is something that he wants to do with his land. I think we would risk being sued by the applicant, by the developer, if we prohibited him from using the land in a manner in which he sees fit. So I am going to vote in favor of this project. I know I'll probably lose. I hope I won't lose friends over it. I may lose votes, but I hope I don't lose friends over it. So that's my statement. Thank you.
Madam Chair.
Yes, go ahead, sir.
I'm just very excited because we have this organization that's been here wanting to develop this parcel of land for so many years here in the city, wanting to bring a waterfront restaurant to our community and going through all the hoops and hurdles. So we have to decide we're at a pivotal and critical moment in our city's history, and tonight our agenda addresses critical items that we haven't even got to yet. We're going to be looking to spur economic development in our designated downtown area, where we're going to really be addressing our additional housing, crumbling infrastructure, but most important, our sit-down eateries. We've been talking about this, and the residents have been crying out for a sit-down eatery on this side of the bridge since I've been a kid. And this is an opportunity for us to actually move forward with that. I'm excited at the endless possibilities and what's on the horizon for this great city, and truly creating a substantial and everlasting legacy in this community. This restaurant that's going to be going back to this waterfront location is a staple here in the city, and I'm excited to support it and move forward with it, and hopefully we can move forward in unison with it. Thank you, colleagues.
Thank you. Any other comments in regards to?
Madam Chair.
Yes, go ahead.
Well, being the councilperson who has definitely been around from the very beginning, I've been here since 2015, and so I've had numerous meetings at the Marina Grande. I've talked to numerous residents. I've talked to the developers. I've talked to residents that live on the west side. I have heard from the positives and the negatives. I know and I won't repeat everything Dr. Botel said because I think she summarized everything pretty good in terms of the developers wanting to work. Well, initially it didn't start out that way, so let me be clear. It didn't start out that way. With the sound, with the music, with the parking, there are a number of issues that were being addressed. I know we asked for them a few years ago to go back to the residents and try to work out something with them. They made those concessions. As we are noticing tonight, is more about the parking, and of course we just heard tonight that nothing will move forward unless they can prove that they have those additional 3 parking spaces. One of the things was, the concern about the safety, and if we move forward with this, I certainly want to make sure that the owners hold up their agreement in terms of making sure that it is an area that we don't have to worry about additional crime taking place there, and it's something that we can be proud that we move forward with. You know, I really, because I try to put myself in the shoes of the people that live there as well and truly understand their concerns, and I want to make sure that we're not adding to a problem. I definitely believe we need a waterfront restaurant. I go to Guanabana's, I'm sure I'm probably saying it wrong, but I go there quite frequently in Jupiter, and there is no parking there. You know, you rely on valet parking almost 100%. And so I understand that, you know, restaurants can still function, but they can utilize other areas for parking. I just, you know, of course, it is not always very easy when you're having to make a big decision such as this, when you have people on both sides. But I do believe that in the long run, the entire community will benefit from this restaurant. It is definitely something that is needed, but at the same time, I want to make sure that the residents are not going to be negatively impacted on the decision that we make. So I'm certainly putting my wholehearted trust in making sure that you do hold up with the responsibility of making sure that it does not negatively impact them in terms of any additional traffic or crime or anything that's going to impact them that way. And so because of all of that, believe me, I've thought about this many, many nights. And I appreciate all of the emails that we have received, and I certainly have read every one of them. But I certainly believe that it is needed, and we have to show that we're not against progress, and so we're trying to make the progress that the community has been dying for a while. And so with that, I will be supporting this project, but I promise you, I am going to make sure that the residents are not negatively impacted. And I hope those of you that are in the condo are able to see the positive in this. And please reach out to me if you feel that it is not going in the way in which we're hoping that it will go, because this is my district that I cover, and so I have a great responsibility, as we all do, because you all vote for all of us, but people do like to make sure they point out whose district it is. And so I'm going on record and saying it is mine, and I am taking that responsibility. Therefore, I will be making sure that this stays the way that we're hoping that it goes. Thank you.
Any other questions, comments?
Madam Chair?
Yes, go ahead.
I don't know what else needs to be said, but Doc, I'm not interested in whether or not somebody chooses not to vote for me because I make a decision. I mean, as long as I got my 7-year-old, that's conviction enough. And quite frankly, my time on P&Z, there were a number of items that were questionable and uncertain, right? And I can have a personal opinion, but I always, and I've gotten this from a former council person, that reminds me I have to make a decision on what's in the best interest of the city, right? And more importantly, on facts, aside from, how I really feel. That's why, respectfully, Councilman Lawson, I didn't want to cloud the discussion with perhaps the mention of, who's going to be the minority person. That's a conversation I think, obviously, a good partner coming into the city would love to have. But I got to, make my decision based on facts. And I think many of the concerns that we had was resolved. I mean, you even got someone, I don't know if it was expected or not, to even declare they would, provide the 3 spaces if that's what it came down to. So I'm here and I'm going to support it. So that's all I have as far as the debate is concerned. Thanks.
Thank you. If there are not any other questions in regards to this item, I would like to say that this item before us is something that I've thought about, but I certainly, hearing the discussion tonight, hearing both sides of the argument tonight, hearing from the Crab Pot family, and I just really feel I don't want to say duped, but I feel like this was used, the crab pot stand was used to kind of drum up some sentiment for the project. And I really think the project would work best at the marina. I think that the water main location is too risky for the building, and I think that the residents in that area will be greatly impacted. So I am not, I've often been on a 4-1 vote because I always vote according to what the residents tell me, what the businesses tell me, and what my heart tells me to do. And looking at this project, I cannot agree to it. And I will be voting no. If there are not any other questions or issues about it, Madam Clerk?
Councilperson Lawson,
Yes.
Councilperson McCoy,
Yes.
Councilperson Botel,
Yes.
Pro Tem Miller Anderson,
Yes.
Chair Lanier.
No.
That motion is approved with Councilperson Lanier dissenting.
We will have a brief recess before our next item comes up for about 5 minutes.
He doesn't care.
Yeah.
Well,
no, he doesn't care what any of this.
We're gonna do public comments and then we work the land.
We are going to get started with the continuation of our agenda. We have at our agenda a time certain item for public comment, and it states that should know it by heart. Please be reminded, the City Council has adopted rules of decorum governing public conduct during official meetings, which has been posted at the front desk. In an effort to preserve order, if any of the rules are not adhered to, the council chair may have any disruptive speaker or attendee removed from the podium, from the meeting, and or the building if necessary. Please govern yourselves accordingly. Public comment shall begin at 7:30 p.m. unless there is no further business of the city, which in that event it shall begin sooner. In addition, if an item is being considered at 7:30, then comments from the public shall begin immediately after the item has been concluded. Any person who would like to speak during public comments, please fill out a public comment card located at the front desk and give it to the staff before the public comments section is announced. Madam Clerk?
Madam Chair, members of the board, the acceptance of public comment cards for this particular section of the agenda is now closed.
Madam Chair,
Yes.
given the lateness of the hour, I would like to move that we limit public comment to 2 minutes per speaker. This is the general public comment, excuse me. This is the general public comment, not the public comment. I'm making a motion. There will be a vote. Excuse me, Mr. Yeah, never mind. Thank you. Do I have a second?
Second?
Madam Chair?
Yes, sir.
I'm sorry, I missed the number. How many public comments do we have, Ms. Anthony?
If everyone is still here, Madam Chair, members of the board, we have 18 public comment cards.
Yes. There's a motion on the floor for 2 minutes for public comment.
Follow-up question.
Yes, sir.
So that's general public comments?
Yes, sir.
So that's 94 minutes if everyone takes 3 minutes.
Yes, sir.
And it's 10, 18.
I make a motion for 2 minutes.
It's already on the floor and seconded.
Second it.
Now, Madam Clerk, are those also same, I guess those are the same to be heard for the public hearing?
For item number 18,
If that's the number. Let's see.
as it relates, Madam Chair,
Yes, sir.
as it
I'm
relates
sorry,
to
yes, ma'am.
item number 18, we have 1, 2, 3. We have 17 for item number 18, which is to come after this particular section of the public comments on the agenda.
So as much as, Madam Chair, I'm sorry.
Yes, go ahead, sir.
So as much as I want to say, I would like to give people 3 minutes, legally, we can't move forward with public comments in an hour and a half and then be able to hear these other items that are scheduled for a public hearing on the 20th. That's going to put us way beyond midnight. So I don't know if it's a real whole lot of discretion that we have in this situation. Ms. Nguyen?
I think because we started the meeting on the 20th, we can continue over, but it will put you into the wee hours of the morning.
There's a motion and a second on the floor. Any other comments in regards to the item?
He was making
Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
And so, that's just public comments, that's not on the item?
Yep.
Okay.
Joel Goldberg, Margaret Shepherd, Cindy March. Joel Goldberg. Margaret Shepherd. Cindy March. Jimmy Coffer.
I'm going to finish where I left off. I'm sorry. I'm going to finish where I left off at. With all the anger in me, I kind of don't calm down now, but I have some questions, and I know, Ms. Williams, you might not be able to answer. Mr. Evans, you might not be able to answer. But I'm going to leave you with this. How many times you all request for Stevens itemized pay for $600-something thousand? If I'm not mistaken, I'm due to be corrected. He's already been paid $300,000. And you all worried about not paying Lady Goldwire and her attorney fees? Botel, Lanier, you called the insurance company and told them don't pay them. Mr. Evans, do y'all have anywhere where you can give a drug test to the people we put in office, especially when they didn't pass the drug test twice? Now they sit on the board. Where they do that at? Nowhere but in the city of Revere Beach, where we love to work and play and have a drug record and still give a second and third chance. But then you want to keep your neck down in Lady Gold. Why? Why? All because of y'all three there has always been personal vendettas. I'm going to say it again. What goes around, comes around. And it's not going to come from Lady. It's going to come from the people you least suspect. Look what happened to you on September 9th. I can't stop saying it because I lost my job too. But guess what? I don't have hate in my heart for no one. That's not the way we was brought up in my family. So whatever substance you own, you need to ask for some forgiveness, because God is a God of a second chance. And you don't have two chances. Both of your tests came back dirty when you was Lynn Hubbard aide. And then they voted you into office because get rid of Lady March and bring back Evans, who's making over $400,000 a year.
Ma'am, thank you for your comments.
Jimmy Coffer, Henry Salter, Doretta Polk.
Good evening, Jim Cofer of Marina Grande. Two quick issues. One is for Mr. Evans. I know we don't own, the city doesn't own MLK, but when it comes dead ends into the port, when the trains
could you speak into the mic?
when the trains are backed up at the port, when they're switching cars, it never gives you a left turn. Even so, what happens is everybody that's in the left turn lane turns right illegally, goes down there and does an illegal U-turn and comes back around. And there's no reason why the light couldn't let you do that left turn, because you're not going into the port. Like, only the big trucks go into the port. Second quick issue I have is I'm in support, a total favor of workforce affordable housing. We need that in Riviera Beach. We don't need to have low-income housing. We don't need Section 8. We need to have people that have a job, that are working. They need to be able to have a place to live and be affordable. So I'm in favor of us trying to spread out and make every project a certain percentage of it, a low percentage, but a percentage of letting people be able to have a job and live reasonable. Thank you.
Thank you for your comment, sir.
Henry Salter, Doretta Polk, Dolores Williams. Henry Salter, Doretta Polk, Dolores Williams, Amon Israel.
Come up here, miss. Come to the podium. Sir, go ahead, Ms. Paul.
Do you want to go ahead and go?
Ms. Paul, go ahead.
Good evening, Council. My name is Doretta Park, and I just want to congratulate the Riviera Beach Detective Jamal Haddings. He was a recipient of the Top Cop Award, and he received this award in Washington, D.C. Hats off to you. We do have some very good female and male police officers, and also firemen and women. Now, getting dressed to come to the meeting tonight, I was a little late getting here, but I was looking at the meeting. I was very, very disappointed and surprised of some revelations that came out concerning the Miss Lady March trial, where it appears that some council personnel wasn't aware of certain things that was going on. Now, in my career, as I brought up before, our professors always told us chain of command. You can't change a narrative without going through chain of command. That's when you run into trouble. That's when you can possibly get your license revoked. The CNO and the CEO will take this to the state boards. And I don't know what's going on here, but something is certainly not right when you have board members not aware of what is going on. If they give you a narrative to do certain things, that should be carried out. Because in my career, if I didn't follow and do chain of command, and I write my own narrative, I would be fired. I would be
Thank you
fired.
so much, Ms. Park, for your comment.
And I thank you very much.
Thank
so
you.
I wish every detail come out concerning this.
Thank you.
However it goes. I thank you.
Dolores Williams, Kent Pollock, Lloyd Brown.
I haven't been here in a while, but I'm here tonight. But I would just like to say, Mr. Evans, I hope you don't take it wrong, but this was said to me. Mr. Chairman, you did a traffic calm. I did a traffic calm on my street and 10th Street, and these are all the people here I got. I haven't will speak to Mr. Bailey. He told me, Mr. Evans, and all you that's in authority, that you couldn't do nothing for my street, for the traffic calm, or for the school signs or flashing things till y'all finish Broadway. But you had a kid to get killed last year trying to run to the bus. I had one to get hit right in front of my house about a month ago. That lady hit that kid, he went into that windshield, cracked that whole windshield up. I didn't know, it sounded like a bump. And I just want to know, Ms. Evans, I don't know, you were telling me that y'all couldn't do nothing for me, for the traffic calm. You saw these papers I got here. I went up and down the street, hard, trying to get some help. Mr. Bailey told me, y'all council and Mr. Evans, y'all can't do that until y'all finish up the imaging for Broadway. You got more over on that side for the imaging than over here. I need something to be done. That kid got hit right in front of me, and you had one to be killed last year. So who's gonna help me? They told me, this is just some of the list, they just took out all what I had and say, well, you need to go to those 3 or 4 houses and get them to sign up. I don't think I need to go to get nobody to sign up when you did the whole street, 2 streets, and a kid got hit just a month ago. Please, I want somebody to call me,
Thank
come
you
see
so
me,
much,
and do
Ms.
something,
Williams.
okay?
Yes, ma'am.
Kent Pollock, Lloyd Brown.
Good evening. My name is Kent Pollock. I am the Community Development District Chairperson as well as the Homeowners Association Vice President over in the Marsh Harbor Development. And I want to say this is probably the longest meeting I've ever been in, except in my house, because I watch them all the time. However, tonight, I thought it was very important that I stay here to do this particular item. For the past 5 weeks, I've been requesting documents from the clerk's public records office, as well as the police department's public records office. And tonight I'm here to acknowledge employees of the city who've done exemplary work and outstanding efforts in helping me to retrieve documents. And I'm gonna call them out by name because I wanna go on record. Ms. Tawana Smith and Ms. Deborah Hall over at the clerk's office. I also wanna recognize from the police department office, Mr. Jarrett, Ms. Brown, Ms. Kirk, Ms. Seifert, and Mr. Montiel. Not often you get people who are willing to do what you ask them to do, especially as public servants. And more often than that, we as residents, guests, we're not the nicest people when we go in and ask them for stuff, and sometimes we demand. Not me, I am patient, I understand that. But these folks have done a great job putting together documents for me, so my 2 minutes is going to go out for them, and it was worth my while to sit here and wait and share that. And Mr. City Manager, if you would you let them know that I did call them out? Thank you very much. I am very pleased to see that the city has outstanding employees working for them in that capacity.
Thank you so much, sir, for your comments.
Lloyd Brown.
Now,
Dan-
before I started, I was listening to a lot of things that Malcolm say, so don't get me wrong. I'll record this.
I'm Lloyd Brown, and as you see, I'm black. And I'm for black individuals that I grew up with who had homes in Revere Beach that their kids have neglected, mainly because of the drug situation that these kids are in. And they have lost their fathers and their forefathers' homes. So I'm for black people that I grew up with, not those that just are coming in from across the water or wherever, not anyone coming in across the water. I'm for black individuals I grew up who fathers toiled every day going to work to make these homes suitable for their kids to have, or supposedly to have. I'm not for black politicians. Black politicians like Bobby Powell, Mac Bernard, Annie Green, and the Taylor lady, they're just there. These are figureheads like on a boat. They're tokens. They were just tokens used by the white man just to make sure that we're quiet. Oh, we got you somebody in here. But they're not going to function in your benefit. They're not going to function for your benefit. And you know what makes it so bad? I had a home that was built to a county, and I went to these individuals, the Annie Greens, the Taylors, and the Powells, and the Mac Bernards, and you know they didn't do anything. But now, my windows won't even go up and down. The house is not even 15 years old. The windows won't even go up and down. And I mean, I done seen houses that's been here 20 years, the windows go up and down easy. I told him that the contractor, when he died and his son did the work, he did a terrible job. These black individuals, politicians, oh, they got friends down there, so they're not going to say nothing to these white people about what's going on. They're not going to, say anything where their white bosses will say, well, hey, you know what, we're looking at you. You can't be out here talking up for your people. We put you in here so that you can manipulate them, not to help them. So if you don't want to manipulate them, then you don't need this job. But these black politicians, they needed the job, so they manipulated us into thinking that they were benefiting us when they wasn't benefiting us at all. Now, I'm not ashamed of what I say. And then another thing I have to say, well, I'm not really interested in what Lozman talked about over there, but what Lozman said, I'll tell you this, Ocean Reef, that was an area with a wetland where Ocean Reef Park is, where you have all those parking spaces going up in there.
Thank you, Mr. Brown.
Daniel McGilry, John Peels, Mary Beth Coffer. Daniel McGilry, John Peels, Mary Beth McCoffer, Fane Lozman, Artie Williams.
I think Daniel left. Mary Beth Kofer, 2640 Lakeshore Drive. I got it right this time. Number 909. It was a tough decision, and I understand that, and there are no hard feelings. We have to do what we have to do to move the city ahead, and I am in support of development. And I hope the Salty Mermaid, not the Crab Pot, will be a good neighbor to Marina Grande. I do think it would have been better at the marina. But it brings 2 points to mind. One, we kept talking about those 3 parking places. It really isn't 3 places. If they're full, and I think I sent you all pictures the other day from the surface lots at the marina, there were only 17 surface spaces available mid-afternoon on a beautiful day when people might have chosen to go to that restaurant. So my point is this, is I would like to see the city manager, the chief of development services, and the CRA director get together and look at what is the reasonable test for this downtown area, this so-called downtown area, which I believe we are being too lenient with respect to parking, the proximity of parking, the safety of pedestrians. And we look at that, and if the answer is we need to build a parking garage, then we build a parking garage. So that is very important to me, and I'm going to stay on that. That's my new calling, I think. And then the other thing is, I just wanted to remind you that when people come wearing those T-shirts, they are not necessarily people from our community. They don't work here, they don't live here, they came by social media.
Thank you so much for your comments.
Artie Williams, Fane Lozman.
Fane Lozman. By the way, it's 7:30, time certain, and for 3 minutes. I am disgusted this evening that you're going after Lady March Goldwire. Lady March Goldwire is one of the 3 black building officials in the country. She was fired because she gave me a fence for property that I own on North Point Road. I own 51 acres of property along Singer Island. And I blame Miss Miller Anderson, Miss Lanier, and Miss Botel for that. I've been fighting public corruption since 2003. A half a dozen elected officials have been removed on investigations that I've done, mainly in North Bay Village. I am not going to tolerate Ms. Lanier being the chairperson anymore. Mr. McCoy, you need to make a motion tonight to replace her as chairperson for the following reason. The Palm Beach Post wrote a story about her a couple weeks ago that she was fired from the county for misconduct. Somebody forwarded me her personnel file. In there, she committed perjury on her application with Palm Beach County, where she did not disclose that she worked in the city of Riviera Beach. She was fired from the city of Riviera Beach as an administrative assistant. That letter, Mr. Evans, had been removed from her personnel file. The results of her testing positive for cocaine twice is not in her personnel file. The exit interview done by councilperson Lynn Hubbard, who was Ms. Lanier's supervisor, is not in that personnel file. It is a crime in the state of Florida to destroy public records. Where are those public records? I requested them. They were not produced to me. I was told they don't exist. You were familiar. You fired Ms. Lanier when she tested positive. Why is that information not on the file? Why did she lie on her county form and commit perjury? Mr. McCoy, you can independently corroborate she lied on the county thing, that she was fired. You need to make a motion or a lawsuit to replace her. She's an embarrassment to the city.
Thank you so much, sir, for your comments.
Mariela Vega, Pamela McCall, Bessie Brown.
Hi, my name is Mariela Vega. I currently live at 3000 North Ocean Drive, and I'm about to close on an apartment at 3040 Lake Shore Drive. My 2 minutes, I want to give it to the attorney. We have counsel to represent us. We're not allowed to do that? Okay. The reason I am here today is that I'm about to close on an apartment at 3040 Lake Shore Drive. When I purchased this apartment, I did not know what was going across the street. I am totally against this low-income housing. I'm afraid of the crime that it's going to be bringing in with the Section 8 part of it also. I don't want to be a prisoner living in my apartment. We have a beautiful city. We have beautiful waterways. I think we need to progress. We need to build more restaurants, cafes, and things where we can feel free to be able to go out and walk around and not have to be worrying of what is going to be being brought in. So I am asking the city of Riviera Beach to please listen to the residents and vote no on this project. Thank you.
Pamela McCall, Bessie Brown, Mary Bram. Who, Ms. McCall? Okay. Okay. Bessie Brown, Mary Bram.
First of all, can you hear me? Because you know I wear a lot of gear. So
Yes,
can you
ma'am.
hear me?
Yes.
Mary Bram, Riviera Beach. I'm going to touch on some things here. See, like I say, so often we spew out our mouth, and that's our amendments. Attorney Stevens, he represents various cases in this city here. About 2 weeks ago, when I made mention about that $60 million lawsuit that was pending against the city, he was also an attorney on that case and other cases too. So if that is not just one combination of pay for him, the attorney has litigated other cases that would add up to his summation. So I wanted to put that out. Avenue O residents, I was over there yesterday. I've gotten with the chief, so we're gonna try to come up with a plan for O Avenue over there, all those speeders over there. Meeting tonight. When a meeting is like this, it should be dialogue on its own setting time. I was in here 2 weeks ago to 12:30 that particular night. So I think that when it's a hot topic and you know that you got other clients and stuff, this is the procedure that we should conduct our business. The pictures of the rock pit and sand pit is blowing all everywhere. You all better get on that now, because we're not playing about that. And another thing, homeowners. See this intimate domain here, when we did this here. Mr. Lozman often says that he did this. No. It was Prince Wells, that I know very well, Mike and Nora Mahoney, and Otis Reeve. And Governor Jeb Bush signed it, May 11, 2007.
Thank you so much, Ms. Brown.
So
for your
I
comments.
just wanted to kind of clear up some things
Yes, ma'am.
with documentations and stuff, and continue to serve.
Madam Chair, members of the board, that concludes public comment.
Thank you. Our next item?
We are now down to item number 18. Ordinance number 4181, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving the application from Berkeley Landing LTD, requesting a zoning map amendment from a downtown residential district designation to a downtown general district designation for approximately 2.23 acres of the property known as 3100 Broadway, identified by parcel control number 5643-4228-00-002-0020, providing for severability, repeal of laws in conflict, and codification, and providing for an effective date. Madam Chair, members of the board, we do have public comment on this item. The acceptance of public comment on this item is now closed.
Motion to approve the ordinance.
Second.
Mr. Evans?
Madam Chair, members of the board, if I could have the Director of Development Services, Mr. Clarence Sermons, make this presentation along with the applicant.
Go ahead, sir.
Thank you. Good evening, Madam Chair, members of the council. I am for you to present the zone change application associated with the Berkeley Landing project. As you heard, the associated items related to this project at the last council meeting, I will skip through many of the non-relevant slides in my presentation and focus on more general aspects of the development, a quick recap, and some development since the first reading. So to quickly summarize the request here, the applicant project is requesting approval of 3 items associated with these parcels in order to construct 2 3-story residential housing apartment buildings, including live-work units with associated parking, landscaping, and amenities on approximately 4 acres of land located at 3100 and 3124 Broadway Avenue. The application for a vote before you tonight is application ZA 21-02 for the zone map amendment. Depicted on the screen now is the project location from a zoomed out distance. A closer depiction of the site shows the properties in question circumscribed in red, as well as the neighboring developments and some sites that have already been identified for proposed development neighboring this. The zone change application would change a portion of the site from downtown residential to downtown mixed use. And here is another depiction of the property from a closer view. Again, the rezoning is for a portion of the property to have one zoning designation of downtown general for the entire property instead of the current split zoning of downtown residential and downtown general. This will provide ease of development and review and other aspects of the project. Just some general aspects of the project. It provides civic open space on both the Broadway and Lakeshore Drive frontages of the site. The project will provide on-site amenities for the residents. The project will provide an easement to Palm Tran for a bus shelter, and the developer will also construct the bus shelter for the project. This project also anticipates development to the north, so the applicant has agreed if and when a traffic signal is installed just north of their property to make adjustments to the entryway to ease and reduce conflict points in the roadway. Again, staff's analysis found the project in compliance with our code, future land use, zoning, which would be updated with, if you approve this ordinance on second reading today. The plat is in place. The levels of service we found adequate for this project. It is compatible with the neighboring uses as this is a mixed-use downtown zoning district. Landscaping requirements have been met or exceeded. Lighting standards have been met. The parking has been exceeded for this project based on the minimum requirements, and the traffic concurrency letter has been submitted from the county, and the city does find it acceptable. The site is proposed via Lakeshore Drive access and Broadway. Palm Beach County issued the Traffic Performance Standards Review letter, and it is in the TCEA area. Parking, again, is provided at the rate of 1 space per unit, and also has 46 additional parking spaces for visitors, as well as 2 spaces for management, for the management office, and 8 handicap spaces. The parking provided exceeds the code's requirement. The CRA has provided a letter of support for this project, which can be found in your backup material. In addition, the CRA is providing a financial contribution to the project. This is the site as it is proposed to be developed. These are some visuals of the proposed civic open space, and again, that you saw these at the first hearing of this item. These are some elevations of the proposed project. Again, I will skip through these as it's not the first time you've seen them. Again, this is a rendering of the proposed bus shelter on the site. Pool amenity area. And at the first hearing of this item, council made it clear that they wanted to ensure that the community had adequate opportunities to be heard on this item. So at the Homeowners Association meeting last week, I attended to observe the developer's presentation and better understand the concerns of the community for your consideration for the second hearing on this item. The primary concerns were related to parking, and as mentioned a moment ago, the parking requirements have been met for this project. There was conversations related to crime. The staff has no reason to believe that this project would increase crime in the area. However, because they mentioned concerns about existing crime along the roadway in front of their development, those concerns were forwarded to the police department for follow-up. Properties values was another issue of area of concern mentioned by residents. This is an area that's very subjective in the development services staff's opinion. Removing a vacant parcel from a neighborhood always helps to improve the property values, especially when it's replaced with new construction. So we believe it would result in improvement of the property values in the area. And then sufficient public notice was also brought up as an area of concern for residents, and this directly relates to activities of my department. So I wanted to make sure it was made very clear the steps that were taken to ensure that we perfected notice for this project. The first thing we do when there is in terms of notice, when there is a project that requires a zone change of this nature, is ensure that a individual mail or postcard is received by all property owners within a 300-foot buffer of the proposed site development. That's what the image before you depicts. This boundary here shows the edge of the 300-foot buffer, and this is the site here. There are 2 condominium buildings that are within the 300-foot buffer, but there are some that are beyond the bounds of the 300-foot buffer, so those residents would not have gotten a postcard, and we believe that explains a lot of the comments of persons that said they believe they live very close by but did not get a notice for this project. And again, it's because of the 300-foot buffer does not touch their parcel boundaries.
Madam Chair,
Yes, go ahead.
when was that mailed? Roughly, I mean, like weeks, months, years?
It was back in September. It has to be sent out 15 days prior to the public hearing. So
Thank you.
Make sure we met that requirement. So in addition to the mailer notice, the applicant is required to make sure a sign is posted to the property. It was done on first reading. The applicant is required to send an affidavit to our department showing the picture and a picture of the sign on the site with the date included. This was the sign that was posted for first reading of this ordinance. This is the sign posted for second reading of the ordinance. And again, we were sure that a notarized affidavit that the sign was in place and a picture was provided to our office for both. And then the legal ad. These are the dates that the Palm Beach Post ran the ads for first and second reading in their paper, as well as how long it was on their website. So in terms of public notice, we are very confident that everyone in the vicinity of this project had the opportunity to be aware of the council hearings related to this item. And again, as far as recommendations, staff recommends that the City Council approve the ordinance of the City of Riviera Beach, Palm Beach County, Florida, approving application ZA 21-02 from Berkeley Landing LTD, requesting a zoning map amendment from an DR Downtown Residential District designation to a DG Downtown General District designation for approximately 2.23 acres of the property known as 3100 Broadway, identified by the parcel control number read into the record earlier, and providing for an effective date. And that concludes the staff presentation on this item.
Thank you. Madam Clerk, do we have any public comment cards?
We do, Madam Chair. Edward.
No, we didn't. We have to make a motion to do that. Sorry?
How many cards do we have?
18 or 19, you said?
So is it
17.
Okay, I make a motion that we do 2 minutes for these public comment cards for this item as well.
Second.
Any discussion? Madam Clerk?
Councilperson Lawson,
Yes.
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Pro Tem Miller Anderson?
Yes.
Chairman Neal?
Yes.
Motion approved. Edward Glatzmeyer? Margaret Shepherd? Jack Ware?
Just a point of order, Madam Chair. Would the applicant have a few minutes to give their presentation?
You have a presentation?
I will, yes, ma'am, and I promise you, it is 11 o'clock at night. It will be 2 minutes for me and 2 minutes for Mr. Crowley.
Madam Chair,
Yes, go ahead, sir.
you have to allow for the applicant to make a presentation if they'd like to.
Go ahead, sir.
Yes, ma'am, and I commit to be very quick. If we could get it up on the screen. Good
I
evening.
need to,
Well, we didn't establish one. We would have to give them the same amount of time that we gave the staff, but we didn't know that the applicant wanted to. And so I don't know how much time we gave the staff, but he is saying 4 minutes?
Madam Chair,
5 minutes?
yes, we will be done very quickly. My presentation is about 4 slides, and Mr. Crowley is going to come up and do a quick summary. Just very quickly, again. Oh, yes, and yes,
Could you-
also for the record, just because it's a quasi-judicial matter.
It is the same.
Okay, so are we going to handle
this is a
Correct, Ms. Busby?
quasi-judicial process as well?
Correct, Ms. Busby? We didn't realize.
Yes, correct, Chair. The only difference is we don't have a party intervener in this particular matter. Therefore, the rules are a little bit more relaxed. However,
Was this a part of the agenda packet that told us this?
well, all of these types of land use proceedings that we have done in the past, they are quasi-judicial. It's just when a party intervener has filed a notice of intent to participate, we stick a lot more strictly to the code.
I see. Go ahead, sir. We can do 4 minutes for you.
Thank you, ma'am, and good evening. My name is
Sir.
Ken Tuma.
Good evening. Wake up.
Wake up, everybody. It's 11 o'clock at night.
Wait a
What else
minute.
is there to do?
Wait a
Chair, we
minute.
got it.
Madam
I
Chair.
swear to tell the truth, the whole truth. and nothing
Hold
but
on, hold on.
Thank you.
Let me, I was not aware this was a quasi-judicial proceeding.
Me.
So anyone that is going to be testifying, please come to the podium and give your name, individually.
Oh, good evening, Ken Tuma.
Wait. And those coming to the podium now with you are,
Would you like me to read them all?
are they part of your?
If you can read them
Team?
off, or
I'm Jamie Crowley for the applicant. Tim Wheat for the applicant.
Dwight Stevenson. What happened?
Chris Rogers for the applicant. Kevin Kroll with the applicant.
and staff, could you state for the record, please?
Clarence Sermons, Director of Development Services.
Okay, I'm gonna ask that all who will be testifying to raise your right hand and repeat. Not repeat after me, just say I do at the end. Do each of you affirm to tell the truth in the testimony that you give? If so, please answer I do. Okay.
Thank you. Good evening again, Ken
Good
Tuma.
evening again, sir.
At 11 p.m., so I'm going to be very quick.
Make sure that our timekeepers are aware of the time.
So
Oh, all right, very good.
the good news is the scope that is in front of you this evening is a second reading of the rezoning only. So my presentation is just going to focus in on the rezoning that's in front of you this evening, and then Mr. Coley is going to close it. We have our whole team. They've already introduced themselves, so I'm going to jump right through that. The item in front of you is a subject site. The site is 4.01 acres. The request today, it has 2 zoning districts, downtown general and downtown residential. Our request on second reading is to amend the entire site to be downtown general. When we look and submit these applications in our office, we review certain items to look at to make sure that what's being proposed as a rezoning is consistent. Some of those standards are, is it consistent with the comprehensive plan? The downtown general is permitted within the downtown mixed-use future land use designation. Therefore, it is consistent with your comprehensive plan. Is it consistent with your code? The rezoning satisfies the CRA downtown regulations and provides for consistent development on this site. These are also articulated in their justification statement. Is it compatible with surrounding uses? The downtown general allows for residential development, which is compatible with surrounding residential uses. Effect on the natural environment. This is a redevelopment site. There's no negative effect on water, air, stormwater, or natural vegetation or wetland environments. Development patterns. Does this consistent with the development patterns? This rezoning furthers the goals of the city and the CRA for redevelopment in the downtown area with commercial and residential uses. Are there changed conditions or circumstances? The CRA downtown regulations zone the property with 2 zoning districts. Redevelopment requires a single zoning designation. And I have just one quick summary, and I will be done and ask Mr. Crowley to come up. The reason why we're requesting this rezoning is to create a consistent zoning district on the property. It has 2 zoning districts today. This change does not allow for any additional square footage. It doesn't allow for any additional density or height. All it does is create a consistent zoning district. What it does allow for is live-work units along Broadway, which meets the vision of the CRA and required by the CRA plan. Ladies and gentlemen, I ask Mr. Crowley, who's the attorney on this, to come up for a minute, and we will be out of your hair for this evening. Thank you.
Go ahead, sir.
Mr. Crowley.
Thank you. With your permission, Madam Chair. Jamie Crowley on behalf of the applicant. Ken did a good job summarizing why we're here tonight and the limited scope of what we're presenting. I just wanted to add a little bit to Mr. Sermon's remarks about the meeting we had with the community. The big issues, as we understood them, were property values and crime, which are not criteria that should be considered on the rezoning tonight. Some of the residents asked, why should we build this project here? There's a lot of land in the city, and I would call to your attention policy 1.5.6 of the comprehensive plan, which provides that the city shall consider its CRA as the last, largest, and best opportunity for new construction sites to address the city's multi-income housing needs by piloting mixed income developments in order to achieve a healthy cross-section of household income categories. That is exactly what we're doing. There was a concern about why now, and there was a recent article in the Palm Beach Post which cited the census data, which showed that while the housing supply has increased in the city, it has not kept up with the population increase and the demands for affordable housing. If you look at your housing element of your comprehensive plan, strewn throughout your housing element is the need for diverse housing. You want to mix these incomes. You don't want to separate one class of citizens from another class. Your comprehensive plan calls for this exact type of development. The only development issues that we heard were concerns about traffic. And of course, we submitted our traffic study with our plans. This is a TCEA, but we did get a letter from the county. DOT also reviewed our access, and the project did not even trigger a traffic study through DOT because of the minimum impact on traffic. Parking has already been mentioned. We are over parking this. We provided a study showing that this is the appropriate amount of parking, and of course, our team has a tremendous amount of experience parking these sorts of housing communities. Access, it was brought up during the meeting whether or not we could close the access off on Lakeshore Drive, and I think we heard from city staff that that's not an option because the city does not allow for developments such as this to close off access to one of 2 streets. And finally, notice, I think Mr. Sermon's addressed that better than I ever could. I would just say that we were here August 26th at Planning and Zoning. We were here September 23rd at Planning and Zoning. We were here October 6th for City Council. Each one of those meetings was noticed, and there was a different sign put up for each meeting. And when you walk down Bayshore, when you leave the community we visited, that sign is right in front of your face. So if you did not know these meetings were occurring, I don't think that you were trying to understand what's going on. So those would be my comments. I would request a brief 2 or 3 minutes for rebuttal after public comment, if it would please the council. Thank you very much.
Thank you. We will have public comment now.
Edward Glatzmeyer, Margaret Shepard, Jack Ware.
Good evening. I'm Ed Glassmere. I was the former president at Lake Harbor Cove. On September 23rd, I attended the zoning meeting and I spoke that it just needed to challenge the city to do better. October 6th, that meeting, I spoke again, and we discovered that the development had never contacted the people directly across the street. We pointed that out. The council asked them to meet with us. I set that up with my building, and they came. And I think the people that were there, some of the city people, they overwhelmingly saw that there was definitely, they were against the project, really the zoning of it, and that's what we're asking for. So we're so committed to this that we've got legal counsel now representing us, and that person will speak. But the big thing that I wanted everyone to know is that the presentation of the development is fine. It doesn't need to be where it's at because it doesn't match the values of what we want as a property. You know, whether it has mixed income in it or not, we want the value to actually be a proponent of what Riviera Beach is trying to do, such as what you did at Blue Heron with this restaurant now. That's not going to draw that type of clientele. There is likely, I think it's also going to add even more traffic to our area. So in our development discussion, they said that 17% of Lake Shore would be used for this development. That's completely untrue. It's based off of their opinion. But if you think people go shopping, emergency vehicles, the things that you've got going down at this restaurant now, and other new developments with the Nautilus, that Lake Shore is going to be used and become heavily trafficked. So I'm asking the board to delay the vote.
Thank you so much, sir, for your
okay.
comments.
Margaret Shepherd, Jack Ware, Mary Bram.
Margaret Shepherd, Riviera Beach. I try not to talk too much with planning and zoning, how we operate. We've been told we're one of the best. And we sat there and vetted it out, and I think we did pretty well, so the people say. I got many calls. And I'm so tired of people coming here and say, affordable housing, Section 8. If you go down to Congress and see the Heron Estates, there has been no murders over there. Nobody got killed. And the majority of those people are paying over $1,000. Some of them have vouchers. I live right there on 23rd Street. It's a Section 8 house. If I didn't tell you where I was at, you would never know where I was at. You go over to 28th or 29th Street, they got 2 more pieces of property. If I didn't tell you that it was Section 8, you would not even believe it. Nobody bothers nobody. The majority are Caucasians. We don't bother anybody. You keep affordable houses, $400. It does not work that way. They go off your income. And to sit here and say, you're afraid, move. I did. I went to West Palm Beach. It was worse down there. I came back home. I am proud of this building being built. I am proud of the Heron Estates. If you build it, the people will come. If you build it, it'll be a nice home, and then people come here and put restaurants here. They will put something here to bring us together. But when you continue to come here and hammer it out, you're no good, you're not going nowhere, the city's going down, I'm afraid, leave. I came back home, and I stayed in City Place with my voucher in a decent house. Publix is here, I say right across the street. Nobody bothers you to come here to this city and continue to haggle it out that you are afraid. This is going to be a good apartment. This is going to be a very...
Ms. Shepherd, for your comments.
I got to say one more thing. No.
Ms. Shepherd, we have 2 minutes. And
No,
I'm so sorry that you
Madam
want
Chair,
comments, but
I want to say one more time.
Madam,
I want to see
Ms.
our
Shepherd.
city grow.
Ms.
Thank
Shepherd,
you. I
thank
just
you so
had to
much.
get it out. I
Okay, very
apologize. I held it in.
All right, very good. Thank you, ma'am.
Jack Ware, Mary Bram, Laura Crosby.
Good evening. I'm Jack Weir. I am the chairman of the board of the Housing Leadership Council of Palm Beach County. It is a nonprofit dedicated to promote workforce and affordable housing throughout the county. I am here to speak on support of Berkeley Landing. So my day job is I'm an attorney, residential developer, so I know how hard it is, and I appreciate the effort the developers have gone through in order to bring it to this stage. A couple of general points. There is a severe shortage of affordable and workforce housing in the county. Overall, we're not even keeping up with the population growth, and it's particularly acute as you move down below 60% of AMI, which in Palm Beach County, high-income county, is 50,000 a household. The Business Development Board has listed as their top priority increasing the supply of affordable and workforce housing, not only to attract new businesses to Palm Beach County and diversify our economy, but to retain the businesses that we have now. If we don't build more housing, quality housing that's affordable to the workforce, we're going to start losing jobs as well. Revitalizing the Broadway corridor is very important, not only to the city of Riviera Beach, but also the surrounding region of North Palm. What you do here affects Lake Park, Palm Beach Gardens, North Palm Beach, and West Palm. You have a quality development team, you have a proven management company, you have an attractive design, and you have an investment of over $25 million that is going to help revitalize the Broadway corridor. Those people that say leaving a lot vacant, having tumbleweeds blow across will increase the curb appeal of their own residences are wrong. Real Estate 101, build a new quality project on what's now vacant land, and others will follow with that. It's an important step. It's, the business community is watching. This is a simple zoning reconciliation.
Thank you so much for your comments, sir.
Thank you.
Mary Bram, Laura Crosby, Fran Zamita.
Hi, good evening, Laura Crosby. I've been a 29-year resident at Lake Harbor Cove. The problem I have is not the construction of this building, it's because it's rental property. I'm sorry, rental property does not have pride in ownership, and I'm afraid that there's going to be problems with any type of rental. I've owned rental property, and I know what happens. We've got management company, they said they do management. I mean, what guarantee do we have that they're going to upkeep this and maintain it to be what they're projecting it to be? It is better than the vacant land, I agree, but the project that they're putting there is not the project we need. They have housing, affordable housing on the west side of Broadway in Riviera Beach. That would be much better than what they're proposing now. I ask you, please, do not pass this. Give it some more consideration. They bought this property, the developers, without the zoning, so you can say you can build what you want on the property you own. Well, they bought it hoping to gamble that they get it. So that's not your problem, that's not our problem. Our problem is to make it a better community, is going to flourish, and with rental people, we're citizens, we're the taxpayers, we're the residents. You're actually giving housing to people who probably are transient people who are going to move in, move out. They're not all going to be from Riviera Beach. Take care of your residents, the people who care about the area. I've stuck by here for 29 years, hoping for better improvements. The redevelopment committee had said they were going to improve it. This is not an improvement. We're going backwards. Thank you.
Thank you.
Mary Bram, Fran Zamita, George Aubrey.
Mary Bram, Riviera Beach. I was in here on October the 6th, and the concerns with the residents, you all were supposed to get with the residents to make sure that those kinks were ironed out. I've spoken with some of the residents, and they said they have not been worked out. Some of them have not been worked out. It was stated from one or two of the board members. It's a certain thing that says that when we get down the road, and we get down the road a little bit too far, and this project here is down in the rabbit hole now. So the decision is whether we like it or not. Here we go, right back with the crab pot. These are some things that you can consider. It's not what we build, but it's how we build to incorporate our usage. So we as a city too, we must take that also into consideration. That not just this project, but any project. Who will maintain this property? Who will maintain this property to assure that these residents will get the quality care that they need in maintenance of that property? We know that parking is always the elephant in our city here because other leaders did not see the true vision of this city here. So this is why we are sandwiched in and baked in, and we are having to build and impact in where we can. It does not match the value. So we as a city, if we build it, yes, we want them to come. But like I say, but it's how we build and what we incorporate to meet our surrounding neighborhoods in our areas. Ms. Shepherd made mention about Section 8. Everybody that's on Section 8 is not a bad person. It's just who you get. And that's who you have to screen. So I say that.
Thank you so much for your
work
comments.
with
Ms.
the
Brown.
residents.
Thank you so much.
Thank you.
Fran Zamita, George Arbery, Don Lehman. Fran Zamita, George Arbery, Don Landman. After Mr. Landman, William Sia, attorney for Lake Harbor Cove, Alex Hill.
Good evening. My name is Don Lamon. I've lived at 3040 Lakeshore Drive for 25 years. I love Riviera Beach and serve the community on boards like Palm Beach State College, Florida Veterans Foundation, Palm Beach Film Commission, and even the former Riviera Beach Zoning Board of Adjustments. So I applaud your service and thank you for that. With this background, I fully support the Riviera Beach vision of improving our community. Completely support it. I'm speaking tonight, however, along with hundreds of others, homeowners, in opposition to the Berkeley project because it fails to meet the city vision of lifting us all up. Palm Beach has an abundance, despite what we heard tonight, Palm Beach has an abundance of low-income rental housing available per CRA, negating any reasonable argument or rationale for more rental housing of this nature. Alternatively, and consistent with the city vision of all of you, Riviera Beach could encourage developers to build affordable condominiums, medium-priced condominiums that could be purchased by city workers, professionals including police, fire responders, healthcare professionals. As our community became more and more aware of the scope of the buildings, you saw overwhelming opposition that you saw at the meeting the other night to this project because of the traffic and the other potential issues associated with it. So I encourage you to vote no on this project, or at least push it down and get more public content. Thank you for your time.
Thank you, sir.
William Sia, attorney for Lake Harbor Cove, Alex Hill, and William Rose.
Good evening, members of the commission. William Sia, Becker Polyakov, 625 North Flagler Drive, West Palm Beach, Florida. Becker Polyakov was just hired today by the association after the meeting, which was just 6 days ago, which was the very first meeting between the developer and the residents. And as a result of that meeting and the questions the residents have, they've sought legal counsel. We just got on board today, and the attorney that would be handling this, Jeremy Shear, was already committed to a different public hearing, and you can imagine just being hired today. We need time to look into this. We need time to vet the concerns of the residents, and we're asking that this be deferred. It's second reading. As I sat and listened to the restaurant deliberation and hearing, obviously that was going on for an extended period of time, many moons, many years even. Here, the developer just met with these residents last week. and they've now just had a chance to get counsel. And the other point I think that's important is you're not here just talking about a particular site plan or a particular development. You're talking about the change in zoning. So if they don't build that for any reason, or there are changes made, you're not just talking about the housing project that they're proposing. You're talking about an increase in density on that other area, which may not be consistent with the Lake Harbor Cove Condominium Association right to the east. So all I'm here to ask you for is some time. We just got hired today. The land use attorney that would be handling this can't be here today and certainly hasn't had a chance to meet with the residents and get up to speed. So we're asking if you can please defer this, because I think it's not just a matter of the buildings, but it's a matter of the zoning change and whether this will or will not have an adverse impact down the road. So that's what we're asking for, some more time.
Thank you for your comment, sir.
Alex Hill, William Rose, Suzanne Cabrera.
Mr. Ambassador, could you make sure you spray that mic? Mr. Ambassador? Yeah, I got it. Okay.
Thank you, Council, and appreciate everyone staying late. I'm Alex Hill, Treasurer of the Board, Lake Harbor Cove Condominiums, address 3040 Lake Harbor Cove, Apartment 504. Proud new owner, just bought my unit at the end of March. My girlfriend and I lived for many years just up the street on Lakeshore Drive in the Marina Key Apartments in Lake Park. I bought that unit in Riviera Beach because I do believe there's great opportunity in Riviera Beach. I'm in the marine business. My company, Maz Ocean, is based in Fort Lauderdale, and I have opened an office at 1905 Broadway, right across the street from Rybovich, because again, I see what is going on here. I just would say, as our council has said, our biggest issue is just simply been the process. A sign went up August 26th about the zoning meeting, but there were no mailers that were sent out that any of our residents would say that they received for that August 26th meeting. Two of our residents went to that meeting and were not allowed to go into the room or speak at that meeting. They filled out comment cards, which they were told would be read into the minutes, and that does not appear to have happened based on seeing the minutes of that meeting available online. Our resident Ed, who spoke, did attend the subsequent meeting on the 6th, and when it was disclosed that the developer had not yet met with our community, that meeting was organized and happened just 6 days ago. October 14th is when we first saw the nice glossy presentation has been shown here. We certainly want to encourage the development and growth of Riviera Beach, but as the city manager himself was quoted in the Palm Beach Post on Monday, we want to grow home ownership. We have enough renters. Thank you very much.
Thank you, sir.
William Rose, Suzanne Cabrera, Fane Lozman.
Hi, William Rose. I also live at 3040 Lakeshore Drive in Lake Harbor Cove. One of the things about notifications that we need to bring up is that when the city asked the contractor to have a meeting with those residents that they felt like they hadn't been had the information yet, they didn't give it. The contractor never sent out any notification for that meeting. We graciously allowed it to happen at our condo, but there was no notification that went to the other people in that 300-foot radius for that meeting. And that meeting was called because the city determined that not proper due diligence was done by the contractor to let the people know what was going on. You people have been working on this project for over a year now. We just found out about it when you're about to have the meeting for the approval of the project. Would have been nice if some due diligence had been done, both on Pinnacle's part as well as on the city's part, to find out how the residents in the area felt about having this project put across the street from us. We probably could have worked something out and maybe come up with a different type of project, as mentioned before, condominium or townhomes as you've done on Broadway a little bit further up. But we feel like that we've been not railroaded, but quick pathed to this, and not, even though you have been able to manage and do the legal part of it by your 15-day notification, it would have been a lot better had you taken the neighborly approach and asked us what we felt about this project before you started your design process. Thank you.
Thank you, sir.
Suzanne Cabrera, Fane Lozman, Mariela Vega.
Hi, I'm Suzanne Cabrera. I'm the CEO of the Housing Leadership Council, and as our chairman mentioned, we are here to create workforce for all residents. And this means everybody. The heroes, we all celebrated. The teachers, the childcare workers, the people that were out there during this pandemic really making things happen. And we have to make sure all of them have a place. And I stopped and got some Aleve at the Walgreens, and that cashier who served me, he deserves a nice place to live. I don't think he's gonna be a homeowner, but I really respect him, and your community needs people like that. And who hasn't rented? I mean, I don't know many people that just are lucky enough to be plopped into home ownership. And a lot of millennials don't want home ownership right now. They saw what happened with the crash. That's not what they desire at all. So to say, you know, you got to take those people and put them somewhere else. Those people deserve to be able to walk to their work every day. And it's $400 a month to $1,600, which will accommodate all the people I mentioned are very low income people. Not just low income, a teacher is very low income in Palm Beach County. And there's a rumor that it's Section 8 housing. And I think people are thinking of the old project-based. That's not what it is. Although I have no problem with that. I lived in public housing. I turned out okay, I think. But those vouchers can be used anywhere. And it could, as someone pointed out, you could be living next to a Section 8 voucher holder and not even know it. And all these folks are criminally background checked. So you're gonna have a safer place to live. You can't go tell your neighbor to get a background check. So I think all the concerns here frankly have appalled me. You need to provide housing for all your residents, and renters are nice people too. So please provide
Thank you so much for your comments.
housing for everyone.
Fane Lozman, Mariela Vega, Pamela McCall.
Fane Lozman. I'm a believer in affordable housing. I have a container home that floats. I actually own half of a container home manufacturer in China. We're bringing one of our container homes here in the next few months. Anybody in the affordable housing business wants to see what it looks like, you're welcome to give me a call. The problem I have with this project is the density. It is just overwhelming, that site. I mean, we're the 2.44 acres and you got 110 units on it. I have a problem that, is that going to fit? Certainly residential should be built there, but the point is we can dictate what is going to be in the best interest of that northern part of the city as far as what should the design be. You know, just because you can jam something in there doesn't mean that's necessarily what it should be. Maybe it should go higher, maybe it should be individual units, but I don't think that's the best use of that density on that property, and that's what I have a problem with. I don't think it's a very attractive building. I know other places, all they're worried about landscaping. I didn't see much landscaping around this building. I don't know if that's in the best, just to have that big blob stretched out there. I don't really think that's the best use of that design element. Now, certainly you can squeeze anything in with the right setback and the right this and the right that, but I thought the Treasure Coast Planning Conference had some ideas as to what type of residential should go where, and that's basically my concern. Not the income level, the people that are going to live in this building. I have a problem with the actual design of the building as far as how wide it is. I think it should be not as wide, maybe go up a floor or two, but I have a problem with the way the building looks and is set on that site. They're just trying to get every square inch out of there, and I think it could be done in a better layout.
Mariela Vega, Pamela McCall, Arthur Atkins.
Hi, good evening. I'm Pamela McCall, and I'm actually a new resident to Riviera Beach, a new resident at Lake Harbor Cove as of June. Earlier it was mentioned about needing places of residence for those who are like frontline workers, and I, for one, have been one for close to 30 years. I have a staff of almost 50 people who have a variety of income levels in the healthcare profession and the hospitals in Wellington. I drive back and forth. I chose that. I chose that after living in Royal Palm Beach for 6 years because I had seen and heard about all of the development opportunities that were due to be coming to Riviera Beach based on the signage and what I hear through the restaurants and in Singer Island that I experience. I enjoy that. I look forward to what's coming to Riviera Beach and hearing the dialogue with regards to the Salty Mermaid or what have you, that restaurant that's going to be. That sounded exciting to me, but likewise, I have the concern with the traffic. As a new person in the area, I've witnessed many opportunities for accidents going right there at the red light in front of Publix, trying to get in and out, and pedestrians as well, almost get run over. And in the meeting the other night, when we had the presentation, that was the first I had heard of that experience. But what was concerning to me was the outcry of the community that I am now a family of, that was experiencing the crime with the muggings and all just within recent months. So my plea is for recognizing that and being able to provide opportunities for other home income.
Thank you so much for your comments.
Arthur Atkins, Patty Roll.
Nice to see everybody. Arthur Atkins, Lakeshore Drive. Only problem I have, I moved in here in 2004, and I have even the papers from those years where Riviera Beach is going to move US 1. Great, I'm moving there. It wasn't a very nice town then. It's really not all that hot now, but it's getting there. I want to see it get there. I'm sticking it out. I voted for you guys up there all the time, but Jonathan over here says, we need to get some small condos, little townhouses in there. You don't need $400 rents in there. It's not going to be a tax basis for you guys. I come from Asbury Park, New Jersey, too, where we were just like Riviera Beach. It was down and out. They put beachfront property. They got property starting to build up there, and now those homes are selling up there for over $1 million when they're bought for like $7,000, $8,000. You can do that in the city if you put your minds to it. We have a project in Lake Park, right down a block down the street, where they're putting $2 million condos, same kind of area, right on Broadway. Nothing to do with the renters or anything like that, but put something in there where people can buy a small condo or a townhouse. I'm not for this project. The project is going to be a mess. They're going to have over 300 cars in this place. They're recognized for 1.7 cars. There's going to be 3-bedroom units in there, 2-bedroom units, and 1-bedroom units. And I guarantee in the 3-bedroom units, you're going to have maybe 6, 8 people living in there too. 2-bedroom units, 4 or 5 people. They're going to have plenty of cars, and it does flood on that street too. But it's a mess now. Thank you for your consideration.
Thank you, sir.
Patty Roll. Madam Chair, members of the board, that concludes public comment.
Thank you. Madam Attorney?
Madam Chair, may I just have 2 minutes for rebuttal, please?
Go ahead, sir.
Thank you. With respect to the upkeep and maintenance of the community, I think you've heard at several of our prior meetings the commitment that Pinnacle and Wendover make to these communities and taking care of the people that live there and working with them and maintaining their property. With respect to the zoning change itself, this This community is permitted under either one of the zoning districts. This is a very unique circumstance where you have one piece of property with two different zoning designations. They're both residential zoning districts with 3-story height limitations. The FAR is the same, so we could do this community under either one, but we're just cleaning this up so it has one zoning designation going forward. I don't know how the oversight happened. I think it was just an oversight that one property had 2 separate zoning designations. And then for the very nice gentleman, with respect to the planning and zoning meeting, those comments were actually read into the record. I think that the ladies that were there left because the meeting ran so long. I think that there was a controversial item before us. So they ended up leaving, but their entire comments were read into the record. And I don't know whether the minutes reflect that or not. I have not looked at them, but I can assure you that they left on their own accord. They were not kept out of the meeting. And their comments were read and considered by the Planning and Zoning Board. And Mr. Tooma, I think, wanted to comment on the density issue.
Yeah, just one more second here. In regards to specifically, gentleman brought up density. Density is not the measurement for this site. It's actually something called floor air ratio. The subject site is 4.01 acres, and our floor area ratio is a 2.0. This site is only using 38% of its capacity that's allowed under that 2.0 ratio. Thank you, and thank you for having us this late. Good evening.
Thank you, sir.
Mr. Sermons, did you have rebuttal as well?
No, I do not at this time.
Does the council have questions of staff or the applicant?
Madam Chair,
Yes, go ahead.
questions of the applicant. If there were no live-work units, would you need the zoning amendment? Is that why, is it because you put market rate units in there that are going to have a potential commercial component that you need to change it from residential to general?
We're actually, the request to
Speak directly into the mic.
I'm sorry, yes, ma'am, sorry about that. The request to change is actually on the east side of the property, though live work is on the west side, but to have one consistent zoning district, which would allow those live works, it needs to be the requested zoning district.
Okay.
Yeah, go ahead.
And just to add to that, your CRA plan calls for this sort of mixed use. That's a very good question, because if the downtown residential is not consistent with the CRA plan, which really calls for this sort of, and that's why we decided on the DG as opposed to the DR, because then we would be meeting both the spirit of the zoning code and the CRA plan.
How many workforce units are in the project and how many affordable?
Germanity, Madam Chair. Point of germanity. I don't know if that's germane to the zoning.
It's germane to the issues that were raised by the residents across the street, because
Right, and-
they're calling it Section 8 housing, and it's not.
Right, but that shouldn't be, and I'm going to ask legal
Okay,
to weigh in on it because
I'll withdraw it then, that's fine. And I guess that it's not germane to ask if these units are Section 8 either. And I guess it's not germane to ask what happened with Pinnacle in 2017 that was reported in the press.
exactly,
And it's not germane to ask if the units will ever be market rate or will they stay workforce forever, or to speak about the property maintenance concerns. But all these are issues that have been raised by the community, and I, for one, would just like to have answers before I vote on this.
Madam Chair, and Madam Chair, I just want to kind of ask a question of, we just went through this process and I read a 14-page document about our standards of review. And I don't want to be in a meeting because, quite frankly, I'm not like some of these attorneys that's earning $350 an hour to sit here, but the rules of engagement was laid out. And if you insert something that is not a standard of review and it becomes adverse, this can be very much reversed and we be brought back here. But when you bring up questions, I mean, we're here for a simple zoning change.
I understand. I'm withdrawing all those questions.
And please understand that I'm only saying this because
I do understand.
I don't want to get brought back here on a procedural issue. And this is a long meeting.
She's withdrawn the questions.
I'm withdrawing them.
Any other questions by board members in regards to this item?
Yes,
Go ahead, sir.
I think it was stated, and I just want to make sure. So the current use that's being proposed is already permitted by right, Ms. Busby or Mr. Sermons?
Yes, that's correct.
And actually went through the code to see the difference between downtown residential and downtown core, and I don't think I've seen anything. What exactly would be any difference between the two? Because both of them allow for, as building uses, multifamily houses. So do you know of anything in particular as it relates to this proposal? What would be different?
The uses that are allowed in either zoning district. The impetus behind the rezoning is just for consistency in review and construction for the project. Development services staff believe that it would be cleaner for the parcel and the development to be under one zoning district and not have a zoning district line drawn in the middle of one of the buildings. So it is more of a matter of housekeeping than anything.
Thank you. And in the event, in the very unique or perhaps unlikely or peculiar situation where the board chooses not to adopt this, tomorrow they still can submit an application for builder permits, am I correct? Because they've already complied with both DR and DC.
No, the site plan approved for this property is contingent on this specific application being approved and becoming active. So if this is not approved, the site plan is void.
Okay. Thank you.
Any other questions from the board in regards to this item? Madam Clerk?
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Pro Tem Mill Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Madam Chair,
Yes.
I would like for us to entertain the continuance of our agenda and seeing if there are some that we definitely have to get done tonight versus some we can move to another
Yes,
agenda.
let us take we got, audience, let's take a 5-minute recess, 5 minutes, so that we can discuss how we're going to move forward.
Amen.
Once you go get that 300,000.
to pick up our meeting and move on to the next item. Are you ready, Madam Clerk?
Yes, Madam Chair, we are now on to item number 14. Ordinance number 4132, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending the city's adopted comprehensive plan based on evaluation and appraisal review in order to provide consistency with current statutory requirements per section 163.3191, 4 Florida statutes, including but not limited to deleting any and all references to Rule 9J-5, Florida Administrative Code, as provided within all elements of the comprehensive plan, more specifically the future land use element and coastal management element, and to address peril of flood principles per section 163.3178, parent 2, parent F, Florida statute, providing for conflicts and severability and providing for an effective date. Madam Chair, members of the board, we do not have public comment on this item. The acceptance of public comment on this item is now closed.
Move to approve ordinance number 4132.
Second.
Mr. Evans?
Madam Chair, members of the board, if I can have Director of Development Services, Mr. Clarence Sermons, make this presentation.
Thank you, Mr. Manager. Good evening again, Madam Chair, members of the council. I will attempt to move very quickly through this presentation, as I believe everyone was briefed on the nature of this item, which is on second.
Sorry, let me interrupt you, but these are second readings. Have there been significant changes since the first reading to this?
In this particular one, yes.
Okay.
There's a typo in the first line.
So again, you all, as you all know, the state of Florida requires that all municipalities have a comprehensive plan and maintain it and update it regularly. It does require that every 7 years, each municipality conduct an EAR, or evaluation and appraisal review of their comprehensive plan, to ensure it is still up to date with any recently passed state laws. In May of 2017, the city notified the state that we were initiating our required EAR. We reviewed state laws and found that Rule 9J5 had been repealed, and municipalities were required to strike any language referring to it from our comprehensive plans. We updated the draft document of the comp plan amendment, and it was approved on first reading by council on August 1st, 2018. As the process is prescribed by the state, we then sent that document to them for comment. They responded, providing 8 comments to us and 1 objection. And they also gave the city 180 days to address those comments and adopt the amendment on second reading. After that, the city requested multiple extensions to our deadline to ultimately get to where we are today, where the city has addressed all of the comments and objectives of the state and are prepared to bring this to you for a second reading and send our final transmittal to the state. Proposed changes before you today are the original changes, which removed references to Rule 9J5. But in addition, in response to state comments, it also updates language related to coastal construction and beach construction. It updates the definition of coastal building zone and provides a map depicting that area. It updates flooding policies for new FEMA and CRS standards, and it updates future land use section to remove 9J5 references and updates Objective 1.8 future land use categories. After we wrap this up, and if it is the pleasure of the board to approve this on this second reading today, my department staff can focus on the future of the comprehensive plan and begin moving forward and looking at the additional changes that we know are needed for it. So our next steps, again, it's been since 2010, the last time we updated this plan, so it is time. Council has budgeted in this fiscal year the funds necessary for us to engage necessary consultants, and we've also, again, reorganized our staff to ensure we have dedicated personnel to work on this around the clock, since it is such an important item. After completion of this amendment, we will begin the procurement process and begin one-on-one meetings with the council members to make sure we understand your visions for a comprehensive plan as we develop our request for proposals to engage consultants for the endeavor. Up until now, staff has identified some top priority areas for the comprehensive plan, the elements that we want to address in the very near future, which are housing, the future land use element, of course, property rights, which is a new element that the state requires that must be included in our comprehensive plan with any future updates. Capital improvements, and then the analysis and monitoring of the policies and metrics that are described in the plan. We want to ensure we have those systems in place. And that concludes staff report on this item.
Thank you for your presentation. Are there any comments from the board in regards to this item?
Madam Chair?
Yes, go ahead, sir.
Mr. Summers, thank you for this. So we have an excerpt from the comprehensive plan listed as exhibits, but it doesn't really, it's not reduced in that fashion in the ordinance. Why not?
I don't believe I follow the question.
So I'm looking at the backup, and you can look at an excerpt from the comprehensive plan, actually the entire one, but why is it not reduced in complete ordinance form to be codified into the code? The ordinance is just a summary.
Sorry, let me.
I see the maps and all of that kind of stuff, but why wouldn't we, I guess, just repeat that language in the code? If it requires 2 readings, as most ordinances does, well, as all ordinances does, I'm sorry, why wouldn't it be just included into the code in its?
So we have language in our city ordinance that adopt the comprehensive plan, but it is a standalone document. So the changes made and proposed to this document, they are underlined and stricken through in the exhibits that are included in your backup. But the ordinance would only alter the code language that refers to the adoption.
Okay, fair enough.
Any other questions in regards to this item? Madam Clerk?
Councilperson McCoy?
No.
Councilperson Botel?
Yes.
Councilperson Lawson?
No.
Pro Tem Miller Anderson?
Yes. Oh. She's not here.
He's out. Chair Lanier?
Yes.
That motion fails. 2-2.
Madam Chair?
Yes.
I would like to bring to the attention of the board that if this item fails today, our routes are limited in terms of remaining in compliance with state requirements for the comprehensive plan. We are required to do an evaluation, an EAR, every 7 years, and if we did not complete it, the one we initiated in 2017, and this dies, and we have to bring this back on first reading again, we have to withdraw that previous application and start from the beginning, and all of the work that was done for this particular ordinance would have to be cast aside and begun again, and all new regulations that have changed since then would become applicable, and it would put the city in a very precarious position because the state can sanction us for not having a comprehensive plan that is in compliance.
Given that the item did fail, what is the course of action now?
I would recommend that a new motion is made, maybe with some amendments that would satisfy the council members that voted against it, or maybe the councilwoman that was not present during the vote could make a difference. But it is very important to the city that our comprehensive plan is intact.
Madam Chair?
Yes, go ahead, sir.
I think I've said this from day one, and I'm going to keep harping on this, and Mr. Sermons, we talked about this. We need to address this comprehensive plan holistically. It's gotten to the point now where we keep piecemealing it, and this piecemeal approach is just, I'm done with it. I'm not going to allow for us just to continue to look at little pieces of our code and address them individually. We're running into so many issues within this discussion for this restaurant, within the parcels and development. We're waiting on the actual intensities and densities to come back from Treasure Coast, but holistically, we have not addressed our comprehensive plan and our master plan. And until we do that, we do not have a full vision of what the city looks like, and we're going to keep just piecemealing this. I cannot continue to support us piecemealing our comprehensive plan. We have to make a conscious effort to be aggressive with changing it. And I know you and Mr. Evans put it in the budget that's up and coming, but I'm not going to continue to support anything unless it's done holistically. Thank you, Madam Chair.
Madam Chair?
Yes, go ahead.
I have a question for the city attorney. When a motion fails because it's a 2-2 tie, who is considered to be on the prevailing side?
It's a tie, and there is no prevailing side.
No.
Then how can a motion be brought up for right word.
For reconsideration, yeah, we're
Thank
looking
you,
into that.
reconsideration. Say again?
We're looking at it now.
Okay.
Perhaps you want to give us an opportunity to look at it and move to the next item in the interest of time?
Madam Chair,
Yes, go ahead.
being that I was out for a second and the vote was called, are we able to bring it back so that I'm able to participate?
That's what we're trying to find out.
Okay.
We haven't been confronted with this, so if you give us an opportunity to look at it, you can move to the next item, and if we can bring it back, then we will.
Would I be permitted to make a comment?
Yes, sure.
Okay, so, Ms. Wynn, let me help you out. There's not nothing you can find over there. I think Robert's rules are pretty clear. You have to be on the prevailing side. But here's what I would suggest. You know, I don't know what happens, but I'm telling you, for us to sit in the meeting as long as we did, I want our stuff to be really defensible. I got a call from somebody that told me today, and this is really bothers me. I've said this to you, Jonathan, at least, Mr. Evans, at least over half dozen times. It is so unfair to be a member of the governing body where I'm asked to make policies and create policies for our community when somebody just told me that we're going to be reviewing our procurement code on the first reading of November. I had no idea. So I don't want to see what I believe and what I've found that we've sometimes, whether it was intentional or inadvertently, have disregarded certain things in the code. So I want to be a part of the conversation and not, here's an ordinance, rubber stamp it. Like, my issue with this item and why I didn't support it is there's nothing about what's listed in the comprehensive plan summarized in underlined version inside the ordinance. So for that, it's just like, basically you're asking me to rubber stamp it. If it was that much of a routine item, we shouldn't even be up here to support it. You might as well just put it on consent if that's the case. But truly, I want to be able to go right back and point to when we adopted the comprehensive plan, which is a whole separate document. There was a summary that reflects that. But when I look at the ordinance, I can't tell what language is adjusted or what language was included to suggest that it was newly added.
Thank you for your comment, sir. Since there is no prevailing party with the tie 2-2, we will let the attorney look into how we can move forward with the item so that the member who was absent for a second to be able to participate in the vote.
Madam Chair?
Yes, go ahead, sir.
If I may, and I think it's important for Director Shermans to opine on it as well. Some of the items that are specified or discussed to be incorporated in the comprehensive plan with regards to development is more prevalent, and usually most of those components are found in your land development regulations. There's very little that's in your comprehensive plan that speaks to densities and intensities and some of those other components. And so it really is a cleaner process to modify the land development regulations to accomplish some of the things that the board has asked for, but we are going through the process to bring some of those studies to the board to get feedback from the board. So Director Shermans, I think it's important that you do respond to that particular matter.
Thank you. While the law department is trying to figure out our next move on this particular item, let us move to the next item. Madam Clerk.
4412. Item number 15, ordinance number 4186, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending the powers and duties of the city manager to increase the city manager's authority to award and sign contracts to $50,000, provided funding for the contract has been approved as part of the annual budget, deleting emergency purchase provision for city manager in Chapter 2, providing for repeal of laws in conflict, providing for severability, providing for inclusion in the code, and providing for an effective date. And ordinance number 4190, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending Chapter 16.5 Procurement Code, Article 3, Source Selection and Contract Formation, Division 1, Methods of Source Selection, Section 16.5-61, Competitive Sealed Bidding, to require that all contracts exceeding $50,000 be awarded by competitive sealed bidding, providing for repeal of laws in conflict, providing for severability, providing for codification, and providing for an effective date. Madam Chair, members of the board, we do have public comment on this item. The acceptance of public comment on this item is now closed.
Motion to approve ordinance number 4186. And did we not say we were going to move these separately?
How did we do it the first reading? How did we do it the first reading, Mrs.?
Ms. Busby recalls them being taken as companion.
Separate items, okay.
Yeah, okay, so I move to approve ordinance number 4186.
Madam Chair, members of the board, if I can have Deputy City Manager Ms. Elizabeth McBride make this presentation.
Madam Chair, just a quick question before Ms. McBride presents.
Sure.
It says to award and sign contracts, it should be up to 50,000?
Yes.
Okay. If that could be adjusted in the record.
Very good. Ms. McBride?
Yes. Madam Chair, members of the City Council, the two ordinances, 4186 and 4190, are here tonight for second reading, and the effect of both of them taken together will increase the manager's authority from 25,000 to 50,000, and provides for amendments to Chapter 2 of the City Code and to Chapter 16.5, the Procurement Code of the City Code. And as a basis for our recommendation, we relied on the statistics that you see in the slide presentation that examines the spending authority of city managers or city administrators within the county, and the average of their authority ranged to almost 50, and that's how we ended up with that amount. Some of the rationale also that was looked at related to data that was received from our finance office, focusing on the spending authority and purchase orders that were issued just to show the change from the year 2012 to presently. And 2012 would have been the last time that the Procurement Code, Chapter 16.5, was amended, which demonstrated approximately an increase of 100% of purchase orders since then, and greater than 150% in the amount of the purchase orders since 2012. In addition to Chapter 2, we eliminated an emergency provision that was codified in 1957, and that was primarily done as a housekeeping measure because once the Procurement Code was changed in 2012, a much more comprehensive emergency provision addressing emergency procurements were specified in Section 16.5-66 of the Procurement Code. That required not only for certain acts, but reporting back to the board time periods and things of that nature. And it granted certain authority to the manager and the procurement director to be used during emergency time periods. And the second ordinance, 4190, basically just increased the threshold from 25 to 50,000. In a discussion with the chair, the question came up as to how could we go about monitoring and providing you with information to monitor the contracts that might be signed in amounts from 25 to the 50. And so I recommended that we could, with procurement, prepare a monthly report that could be placed as a for-you item on the agenda. We did that with some of the procurement at my previous employer for those things that did not require solicitation, and that way we could get a feel for it. And I would suggest we could bring that at the first meeting, put it on the first agenda in December, because that would give about 6 weeks.
Very good. Any questions in regards to this item?
Madam Chair?
Yes, go ahead, sir.
But moving forward with this, this is for Mr. Evans, I believe, or even Ms. McBride. Does this allow for more contracts for MBE or WMBE programs and implementing this requirement for us?
I cannot, I would be being speculative if I tried to answer that for you. But what we could do, include in that report, not only who got the award, but we could include information as well as a local vendor, small SB or MWB, so you could see that data.
And I believe we have a follow-up, Madam Chair.
Yes, go ahead.
I believe we have, we've secured a consultant for our disparity study that we're currently working with.
Yes.
What can we put in place just to secure that if we increase the spending limit, that we can actually secure some, sorry?
For the manager?
Yeah.
Okay.
So it's looking at, because I just want to make sure, of course, our city manager understands.
I guess I never thought that our counting of the MWB participation, of SB participation, was limited just to actual solicited documents, anything that fell within our purchasing power.
Yeah, it's not limited, so anything. I would actually have a preference that we utilize this spending limit and this increase to assist our minority and women businesses and our local participation, because if we're going to do essentially unsolicited proposals up to $50,000, I want that to go to our local residents. I want it to definitely be spent here in our city if Mr. Evans is going to have that ability. And then I'm not sure if this concern was addressed the first time. I was actually out on first reading, but what happens when Mr. Evans, is gone off to Washington or to Tallahassee and he's left us? Is there a possibility for a reverter clause to where the spending limit can go back down to the 25? Because we're entrusting our city manager and we have complete faith in who we have in place right now, but changing this limit is just not for here and now. I mean, we have 100% faith that he will get the job done, and I would be in support of this because I know that he understands the mission. He understands the goal of providing support for our local and women business. He's going to make sure those funding is going towards them. But as policymakers, we're looking at the next 20 years.
You can always amend, you can always repeal whatever you've done. But that's how come we looked at spending of other municipalities. That's how come we added data from our purchase order, because we really should not legislate on an individual. Okay?
Correct. So
That really shouldn't be the basis for it. And our legislation should be written, so hopefully for longevity in some way. And you can look at.
Thank you, Madam Chair.
If you look at, okay.
Thank you. Any other questions in regards to this item? Madam Clerk.
Thane Losman.
Thane Losman. I think the question you should ask Mr. Lawson is, why don't we put this into effect after he leaves Riviera Beach? I've talked to a lot of people on Singer Island. A lot of people on Singer Island are supporters of mine, but they're afraid they'll be terrorized by Botel and by her little enforcer Summers. And that's why they
Sir,
don't
you
come to the
have to
meetings.
speak to the topic.
I am speaking to the topic, so stop interrupting me. Okay? So what they're concerned about is they are as horrified as I believe you were, Mr. McCoy. I didn't go to that meeting, that he unilaterally paid himself over $400,000 without coming to the council first to get the money. I do not trust this man with my taxpayers' dollars, with Halo's taxpayers' dollars, and with a lot of other people's taxpayers' dollars on Singer Island. That's your job, is to supervise procurement issues. Now, if it comes between $25,000 and $50,000, if it comes between $25,000 and $50,000, you put him on the consent agenda. But I do not trust this man at all, that he would come in and pay himself more than the President of the United States. That is gross. That's disgusting. He should have been fired for that. He should have been happy to get a job for $250,000 a year, but no, he had to go rip off the taxpayers for what, $400,000 or $500,000? And you, as the final policymakers, except for one guy there, McCoy, had no problem with it? It's gross. It's disgusting. That's malfeasance right there. You don't have a city manager in a little city make $400,000 or $500,000. And then I got a call a couple weeks ago, like, oh, well, what about the CRA money? He's going to go back and put that back in and backdate it. What do you mean backdating what? I don't trust this man. He's lied to me on numerous occasions. It's our taxpayers' dollars. It's not his to tell us what to do with them. You keep it the way it is. Once you get rid of this guy, then maybe you go to 50 grand. But I don't trust this guy at all. He's proven to be a liar to me. He came over to my property. He had no problem with being developed. He had no problem with the fence. No problem with anything. But then Botel tells him what to do, and he goes running like a little scared boy in the corner.
Sir? All right, very good. Next.
Madam Chair, members of the board, that concludes public comment on that item.
Very good. If there are any other issues in regard to this item, Madam Clerk,
Yes.
you got one?
I just want to debate.
Sure, go
I
ahead.
just want to renew my objection to this. It was just on October 6th that because we don't have a purchasing director, specifically, these kind of things fall in the cracks. There was a $36,000 contract that did not even go and get purchasing's approval, and it was set on the agenda, and had I not brought the question up to legal as to legal sufficiency, I mean, this is another one of those situations where it would have came and fell through the cracks because we don't have a purchasing director, and quite frankly, there was nobody that signed off that this was the single source of, this was the single source provider. So I can't support this, and I am going to specifically say on the record that if it does prevail, I'm going to encourage the mayor, well, this is my encouraging the mayor right now on the record to veto this item as well as the next one.
Thank you, sir. Any other questions in regards to this issue? Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Councilperson McCoy?
No.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved with Councilperson McCoy dissenting. We now need a motion.
Motion to approve ordinance number 4190.
So, second.
Any public comment? It's the
Nope.
same, it's the same item.
Same.
Any questions from the board in regards to this item? Madam Clerk?
Debate.
I'm sorry?
Renew my objection, and I'm going to encourage the mayor to veto this item as well.
Thank you, sir. Madam Clerk?
Councilperson McCoy?
No.
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Pro Tem Lanier? Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved with Councilperson McCoy dissenting.
Next item, Madam Clerk.
We're now on to item number 16, ordinance number 4185, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving the application from the City of Riviera Beach, requesting a future land use map amendment from an industrial designation to a community facilities designation for property known as 2129 North Congress Avenue, identified by parcel control number 564342 3016-000-0080 for the new library facility and providing for an effective date. Madam Chair, members of the board, we do have public comment on this item. The acceptance of public comment on this item is now closed.
Move to approve ordinance number 4185.
Second. Madam Chair,
Yes, go ahead.
question right quick. Are we, for these items that are on second reading, are we only going through presentation if something changed? Otherwise, we just see if there are any questions?
Yes.
Okay.
Yes, we can do
Y'all,
that.
we didn't
Yes.
talk about how we were going to change this agenda.
Mr. Evans?
Madam Chair, and members of the board, there's been no modifications since first reading. Staff recommends approval in second and final reading, and Director Sermons is available to answer any questions that the board may have.
Thank you, sir. Any questions for the board in regards to ordinance 4185? None? Do we have public comment? Okay, go ahead.
Fane Lozman? That concludes.
Madam Clerk?
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Thank you. Next item?
Ordinance number 4184, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving zoning map amendment from the City of Riviera Beach, requesting a zoning map amendment for an industrial PUD district designation to a CF Community Facilities District designation for property known as 2129 North Congress Avenue, identified by parcel control number 5643, 4230, 16, 000, 0080 for the new library facility and providing for an effective date. Madam Chair, members of the board, we do not have public comment on this item. The acceptance of public comment on this item is now closed.
Motion to approve ordinance number 4184.
Mr. Evans?
Madam Chair and members of the board, this item was approved on first reading. Staff recommends approval on second and final reading, and there's been no modifications.
Thank you. Any questions in regards to this item from the board? Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Next item.
We're now down to item number 19, ordinance number 4183, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving the application from the City of Riviera Beach, requesting a future land use map amendment from a commercial designation to a community facilities designation for 1.96 acres of property known as 1920 West Blue Heron, identified by parcel control number 564342302500100000, and providing for an effective date. Madam Chair, members of the board, we do not have public comment on this item. The acceptance of public comment on this item is now closed.
Motion to approve ordinance 4183.
Second.
Mr. Evans?
Madam Chair and members of the board, this item was approved on first reading. There's been no modifications in second reading, and staff recommends approval of the ordinance before you.
Thank you. Any questions from the board in regards to this item?
What ordinance, 4183?
Yeah.
4183, yes, number 19. Well, I mean, it's probably changed with the change we made tonight.
Yeah.
But the original
It's
agenda
19.
has number 19.
Yeah.
If there are no questions in regards to this item, Madam Clerk?
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Next item?
Item number 20, ordinance number 4182, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, approving the application from the City of Riviera Beach, requesting a zoning map amendment from an CG General Commercial District designation to a CF Community Facilities District designation for approximately 1.96 acres of property known as 1920 West Blue Heron, identified by parcel control number 5643 4230 25001 0000, and providing for an effective date. Madam Chair, members of the board, we do not have public comment on this item. The acceptance of public comment on this item is now closed.
Motion to approve ordinance number 4182.
Second?
Madam Chair and members of the board, this item was approved on first reading. There has been no modifications on since first reading, and staff recommends approval on second and final reading.
Thank you. Any questions for item or ordinance number 4182? Madam Clerk?
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Next item?
We're now down to item number 21, ordinance number 4178, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, amending Chapter 13 of the city's Code of Ordinances entitled Parks and Recreation, repealing Article 3, entitled Boats, creating Article 3, entitled Boats, Floating Structures, Liveaboard Vessels, and Other Watercraft, providing for applicability, severability, repeal of laws in conflict, and codification, and providing for effective date. Madam Chair, members of the board, we do have public comment on this item. The acceptance of public comment on this item is now closed.
Motion to approve ordinance 4178.
Second.
Mr. Evans?
Madam Chair and members of the board, staff is recommending approval of ordinance 4178 on second and final reading, and Assistant City Attorney Ms. Lina Busby is prepared to answer any question the board may have, and staff recommends approval.
Good evening. Good evening, Chair, members of the City Council. If Mr. Stevens would please put up our map. At the last meeting, this particular item, a vote on this item was postponed because members of the City Council expressed that they wanted to see a very clear map of the city's waterways and boundaries. Not only did our development services department create this map, but they also went out with the Marine unit and created an interactive map that can be used to essentially pinpoint derelict vessels, liveaboard vessels, other floating structures in the waterways in real time, and be able to document their locations that way using also the GPS tracking device. I will also point out that on this second reading, there were minor changes to section 13-55 on the exceptions, in which we did add some language to the exception to make it very clear that this ordinance will not apply to floating structures or liveaboard vessels that are lawfully moored in a permitted private mooring field or permitted public mooring field, provided that those structures and liveaboard vessels are not moored in less than 4 feet of water measured at the mean low tide. And that was earlier expressed in a different section, and we just added those provisions to the exception so that it was more explicitly clear in the law.
Any questions for, I'm sorry, public comment?
Fane Lozman, Mary Brown.
Thane Lozman, I have a letter here from Carrie Barsh, who represents Halo Development, myself and Renegade Trust 2. I am writing on behalf of Halo Development, Thane Lozman Renegade Trust LLC, the owners of real property located in the city of Riviera Beach, more particularly described in Exhibit A to the letter. The floating structure and liveaboard ordinance under consideration tonight should be voted down because, among other things, it is overly broad and violative of the United States Supreme Court decision Lozman versus Riviera Beach, 568 U.S. 115, 2013. In addition, the city does not have jurisdiction over vessels that have current state registrations anchored in the waters of the state of Florida. The city cannot therefore usurp the authority of the state of Florida to regulate the mooring of vessels that have current state registration. It is noteworthy that the city ordinance would also extend further in scope than the county ordinance, which allows the floating structures anchored on privately owned submerged lands. The city's floating structure is yet another example of retaliatory animus directed to Thane Lozman and Halo Development LLC. Please have the city clerk read this letter into the record. Sincerely, Carrie L. Barsh. Ms. Barsh is considered one of the top land use and environmental attorneys in the United States. She's been an attorney for 37 years at GT. 75% of Related's projects have gone through her group. She permitted the Port Tunnel, she permitted Brightline, all the rock mines go through her. She has a large group of environmental land use lawyers around the United States that work in conjunction with her as the national chair. You guys are going down a road, and the West Side will learn about it soon, based on Botel, based on this ordinance, you're going to look back and say, this is the stupidest thing you've ever done. Judgment Day is coming, and that will be the end of Botel in this city. There will be a riot on the West Side when that happens.
Thank you for your comments, sir. Any questions from the board in regards to this?
Madam Chair, we still have one more public comment.
Oh, I'm sorry.
Mary Brown.
Sorry about that, Ms. Brown.
Mary Brown, Riviera Beach. It's still breast cancer month, so we're still.
Could you speak into the?
Can you
microphone?
hear me? Can you hear me now?
Well, pull the microphone down to you a little bit.
Try it.
Yeah.
There
you go.
I'm going to call her name completely. The late attorney Pamela Hannah Ryan.
Ms. Brown, you have to speak on the issue that's on the table, which is about.
It is pertaining to this.
Okay.
It is pertaining to this. At our marina down there, we had everything going on down there. For the same reason here, why we're trying to come in compliance here. If we put our codes for land, we must put them for sea. I'm going to say something here. Floating structures within the territorial jurisdiction of the state of Florida and the waters of the city may pose significant threat to the environment, human health, navigational safety throughout the potential to discharge sewage oil or hazardous substances into the marine environment. Physical damage to surrounding ecosystem. This is what was going on down there years ago. And now, on June the 24th, 21, Palm Beach County adopted ordinance number 2021-017, amending its code of ordinance to prohibit floating structures, as stated in the summary with Palm Beach County. Now, each municipality came into this compliance here because they value their waterways as well as we do. We're not saying that you cannot live here, but it's how you come and want to live. If we have to be in compliance and protect our seas and our waterways, this is what we do. So when we shout out about Botel, Botel is not the only one that lives in this city here. We foresee our city too as being a city that is incorporated with the things for safety, environment, and for other natural resources. See, Ms. Bram loves the animals because they make Ms. Bram who she is. And those waterways are important to all of us. My grandkids swim. We swim. I don't want feces. We have feces, everything down there at our marina down there. For you newcomers here, Ms. Bram here to tell you. Here it is here. Here it is here. Ms. Bram don't talk off the top of her head. Commissioner Miller Anderson, she knows as well, too, what we had to go through to clean up that marina down there.
Thank you so much for your comments, Ms. Brown.
That concludes public comments on this item.
I said, thank you.
I just wonder if the Marine Industry Association.
Madam Chair, members of the board, there are two members of the
Hold
public.
on a second. There's too much cross-talk.
There are
Madam
two
Chair.
members of the public that indicated they put in a public comment card for this item. I don't have any other public comment cards for this item. Your name is?
Madam Chair?
Yes,
I
go
think
ahead.
they've been waiting on that. I think we should.
I think it's really
please-
very important
please
that
let
we
them
hear
go.
from the Marine Industry Association of Palm Beach.
Yes, have you found the card?
Just come on and give your name if it's the pleasure of the board, because I don't see anything with at least Alyssa Freeman on
Well,
it.
I would ask my colleagues to allow Ms. Freeman to speak because she represents a very
Yes,
important.
we've allowed, go ahead, ma'am.
Good morning. Thank you. My name is Alyssa Freeman. Good morning. Alyssa Freeman, Executive Director with the Marine Industries Association of Palm Beach County. We represent the marine businesses and boater interests here in Palm Beach County. And I'm here to just say that we do support the floating structure ordinance as approved by Palm Beach County. And I think Ms. Busby cleared up something about the exceptions with some of the liveaboard vessels. That was kind of where some of our heartburn was with the liveaboard section of the ordinance. And so if they're lawfully moored in 4 feet or more of water, then it's good, I think. So when I was reading it, I saw section 13-54A stated that any owner of a vessel may use or permit the vessel to be used for living quarters as a liveaboard vessel is defined in Florida statutes. That's fine. However, 13-54C in the same section states liveaboard vessels shall not be used for permanent living purposes. So if the exception is granted that they can be moored lawfully in 4 feet or more of water, then we're good with that. I think that's it. Thank you.
Thank you.
Thank you for your patience.
Yes, thank you for your patience. Madam Clerk, that's it for public comment?
All I got.
Are there any questions from the board in regards to this item? Madam Clerk?
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Councilperson McCoy?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Next item.
We're now on to item number 22, ordinance number 4179, an ordinance of the City Council of the City of Riviera Beach, Palm Beach County, Florida, repealing and replacing section 29-66, relocation and use of public right-of-ways of chapter 29, streets and sidewalks, article 2, division 2 of the city's code of ordinances in order to change the title of the section, inserting purpose, intent, and definitions, providing for a process for the abandonment of public right-of-ways, clarifying criteria for relocation of right-of-ways, providing for severability, preservation, conflicts, and codification, and providing for an effective date. Madam Chair, members of the board, we do not have public comment on this item.
Motion to approve ordinance 4179.
Second.
Mr. Evans?
Madam Chair, members of the board, if I can have Director Shermans of Development Services provide a brief presentation to the board, and then certainly on second and final reading, we can get into more specificities related to the topic. Director Shermans?
Thank you, Mr. Manager. This item amends, as read into the record, amends the section of the code that deals with the abandonment and the relocation of right-of-ways. The previous language had very strict prohibitions on the abandonment of right-of-way, and what this language does is put provisions in place for that process. If it is the pleasure of the council, it describes an application process, review parameters, and fees for the application, as well as a privilege fee that the city would be entitled to for any land, square footage of land that we would abandon to a developer for a project. We believe this is an important update to make to the code because there is development projects of scale that would make such requests, and we would want to make sure the city has a process for reviewing them and that the city is fairly compensated for any right-of-way that it allows to be abandoned. The power of that action is still in the hands of this board via ordinance, a first and second reading, but this establishes a process and fees associated with it.
Thank you, sir. Any questions from the board in regards to this item? Madam Clerk?
Councilperson McCoy?
Yes.
Councilperson Botel?
Yes.
Councilperson Lawson?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Motion approved.
Next item.
Item number 24, resolution number 103-21, resolution of the city of...
We're at 25.
25, that was removed.
Oh,
Resolution number
25.
104-21. 24 was deleted.
I see. Resolution number 104-21, a resolution of the City Council of the City of Riviera Beach, Palm Beach County, Florida, authorizing the city manager to commence a competitive solicitation process for the selection of a master developer for properties including but not limited to properties located at 600 and 601 West Blue Heron Boulevard and 2251 and 1715 Broadway for the construction of a new municipal complex, the city library and emergency operations center, fire and police facilities, Wells Recreation and Wellness Facility, and such mixed use as may be approved by the City Council consistent with Reimagine Riviera Beach, providing for pre-development costs and expenses in an amount not to exceed $1,500,000, authorizing the Director of Finance and Administrative Services to make payment for same, providing an effective date and for other purposes. Madam Chair, members of the board, we do have public comment on this item. The acceptance of public comment on this item is now closed.
Motion to approve resolution number 104-21.
Second.
Mr. Evans?
Madam Chair and members of the board, this is the culmination of a lot of work that staff has put in with regards to Reimagine Riviera Beach. The series of community workshops began in June 8th, 15th, 22nd, 29th. We also had a meeting on August 5th, September 13th, September 30th, October 5th, October 14th, and October 15th, and have had community polls and responses. And as a result of the participation that we got from the community, overwhelmingly there was support with regards to moving a City Hall campus between the roadway of 22nd and 23rd And so this is the process to allow for us to go forward with the solicitation document to secure a master developer to facilitate the Reimagine program that the board has worked with staff on to bring to life. At this particular moment, I'm going to turn the presentation over to the Deputy City Manager that can get in more specificities of the item.
Ms. McBride?
Yes, ma'am. Madam Chair and members of the council, basically, the resolution grants us authority to move forward, to work with some of the P3 consultants that you've approved previously. And the consultant we've identified to help us with this project is Avison and Young, in developing a solicitation for a master developer. This is a project that we see probably having several phases, because not only does it anticipate City Hall, but it also anticipates possibly a library on or not on the City Hall site, as well as the Wells Recreation Facility. And we anticipate that those structures, if done separately, would not all be built at the same time. But we wanted to select a master developer to help guide us in this process. Consistent with what we did with Fire Station 88, we're asking for pre-development costs in this tonight in the amount of $1.5 million. With Fire Station 88, we came to you initially for $500,000, and that was before we had gotten our estimates from the consultants. After we got our estimates from the consultant, our owner's rep, as well as the development team, we came back and we got an amount of $1.5 million. So basically, we will, and that's why we are requesting this for cost to cover our consultants, not only our consultants, but our legal advisors, be it a P3 or be it Street Construction, that will prepare all the documents, because this process will be a lot more complicated than building one building or fire station. And I think it would be wise, the manager and the team, we all felt it would be wise to have the consultants there with us as we start this process. Mr. Councilman McCoy, would you like to ask that question you asked me earlier? Okay. It's late.
Deputy City
Yes.
Manager, thank you for that. I think
Yeah,
I got to ask the chairperson. Madam Chair.
Yes, go ahead, sir.
Okay, so members, I guess my only concern, and it's not so much of a concern, but when you read this resolution, it just says, providing for pre-development costs and expenses in the amount not to exceed $1.5 million. You know, I would much rather choose language that says setting aside a budget of $1.5 million, because as you read that, and it says providing for pre-development costs, almost suggests that we won't see these items again, that we're just going to authorize $1.5 million. And the reason I'm saying that is because there was a couple things that I know came up, and I know we didn't exactly get around the meetings in every district, but I think I remember Councilwoman Botel saying something about having a rendering of, I guess, the different proposals on each property, of what the actual conceptual plan would look like on City Hall. But I guess I'm not okay with just authorizing $1.5 million. I would much rather would say providing a budget of $1.5 million, and whenever those consultants come, you know, then we'll see individually what that $1.5 million is being spent for. That's my only, that's the only thing that caught my attention, but as it reads now, it suggests that we're authorizing the expenditure of $1.5 million. So I'm asking for an amendment to the text.
Madam Chair?
Yes, go ahead, sir.
If I may, if it is structured like that, then every conceivable component does come back before the board, and there would be situations whereby it would have project delays associated with getting an item on the agenda, making sure it's not delayed or pushed or what have you. And so it's no different than the $782,000 that the board approved at the utility district for lift station 1A. This allows for us to move very aggressively and very quickly. Now we can provide you with updates and give you that documentation as it relates to the expenditures associated with that. but it will really be hard for us to hit that deadline as September 29th of 2022 to be able to break ground and then move forward with vertical construction if it has to come back to the board in certain forms and certain fashions. So just something to consider.
Thank you, sir.
So, Mr. Evans, you're saying you don't support changing it?
Madam Chair, if I may.
Go ahead, sir.
My only concern is that it would, if we have to place an item on the agenda and it's delayed or pushed or for whatever reason, invariably it's going to slow up the ability for us to move quickly on it. So if it's something that maybe the board wants to look at it at $500,000 increments or what have you, something that can get us started with a bulk of the work, because our consultants are queuing up and ready to go, and we really want to hit that on September 29th, 2022 for groundbreaking, and so that's why we're asking for the monies associated with the project.
Thank you. Any other questions in regards to this item? Madam Clerk?
Mary Bram.
Mayor Bram, good morning to you. This right here, reimagine Riviera Beach. This is exactly what we're doing. Last week, I spoke before a board meeting. 3 weeks ago, I spoke before a board meeting. And I inquired of how we were moving in this city too. And I challenged everyone to be a part with us. Every correspondent that I heard, they were pleased to know that we are family. Family is gonna do something to move this city here where we vision it should be. Our forefathers saw it, that we would grow out and leave this place better than what we leave it. This is what we are doing. It's so strange. Every board that has been here, it's always a delay. Because it's always nitpicking and choosing. And this is what has caused a lot of Riviera Beach down failures. Because when the board changes, everyone comes in with their own little agenda, because so many people be in your ear till you decide to downplay the progress. Because if it's not you, then who? Because somebody else will have all of those seats up there. And progress will go on, whether you like it or not. Every board that Ms. Bram has dealt with in this city here, the things that this city really that should have been doing before now, they never did it. Because they always injected their little feelings and their little whims, and then they nicked and picked and hacked till they delayed the whole board. We want to imagine ourselves, because Ms. Bram say and others believe in us. If some of you all don't believe in us, then that's your problem. Because if it's not you, it's going to be somebody else. And it just may be Ms. Brown, or it just may be Ms. Polk, or it just may be a lot of us that foresee this city here greater for my grandkids and your kids and everybody else that will come along that has always doubted us. And some of you board members have always doubted this city here.
Thank you so much.
Get out of that
comments, Ms.
nice.
Brown.
Thank you.
Thank you so much.
That concludes public comment.
Madam Chair.
Yes, go ahead.
To Mr. McCoy's point, I don't see what would be the harm in maybe just providing like a monthly update, if that would help out, give them some comfort and provide some sort of transparency.
Madam Madam Chair, if I
Yes,
may.
go ahead.
What we can do is we can also create an online portal that has all the expenditures associated with the Reimagine program. So it's there and can be available for public consumption, and the board can see what the activity that's going on with the project.
Thank you. Any other questions in regards to this item? Madam Clerk?
Councilperson Botel?
Yes.
Councilperson McCoy?
No.
Councilperson Lawson?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
That motion is approved with Councilperson McCoy dissenting.
As that is the end of our agenda. We gotta come back to one item, to get a ruling, further direction. Madam Attorney?
Yes, Madam Chair, thank you. In Robert's Rules of Order, Section 41, subsection 39, there is the opportunity for the chair to entertain a motion to suspend the rules to take up item number 14. The suspension of the rules, according to Robert's Rules, says that it's an important protection in cases where some of the members may be unable to be present through an entire meeting, and that is what happened when Pro Tem Miller Anderson stepped out. The chair wants to entertain a motion to suspend the rules.
Motion to suspend the rules.
Second.
Point of parliamentary inquiry. The suspension of the rules usually requires, what is it? 2/3?
2/3, correct.
Okay, all right.
Madam Clerk?
Councilperson Lawson?
No.
Councilperson McCoy?
No.
Councilperson Botel? Councilperson Botel?
Yes.
Pro Tem Miller Anderson?
Yes.
Chair Lanier?
Yes.
Madam Chair, members of the board, we do not have a,
It's a 2/3.
is it 2/3 vote?
It's not a supermajority.
Okay, motion approved.
I'm sorry.
2/3 is 3 of you, I believe.
Yes.
4-1 would be a supermajority.
We will come back to this item in regards to, what item was that?
Item number 14.
Item 14.
Madam Chair,
Yes, sir.
a question for the attorney. I want you to provide that rule.
Yes.
And not only that,
14.
yeah, can you give me that rule, please?
4139, section 41, subsection 39.
What edition?
The addition is 12.
Where do we go from this particular point, Madam Clerk?
So,
I'm sorry,
so,
hold on 1 second, Mr. McCoy, I'll let you get your question in. I need to know the next step that we take, Madam Attorney, after we have made that 2/3 vote.
Well, it is, Madam Clerk, however, you can take up a motion for that item.
Okay, very good. Go ahead, Mr. McCoy.
that's not 2/3 vote, so I just want to point that out.
Madam Chair, if I may.
Yes, go ahead, sir.
I think our resident expert with regards to mathematics, Mr. Sherman's here as well. But I think it's 2/3, 66%, which is 3 out of 5.
Yes. That's 66.
It's still not, 4 is a supermajority, so it has to be 3.
4 is a supermajority.
4 out of 5 would be a supermajority.
Yes. Can we bring this item back? Can I get a motion for that?
What's the motion? I don't have it in front of me.
Orders number 4132.
So move.
Second.
All right.
Any comments on this item?
What's the item? I'm sorry.
Ordinance number 4132.
Item number 14.
Well, I'm gonna vote again the same way, but I'm gonna assure you that that's not proper. 2/3 is 66%.
Yes. Madam Clerk?
Councilperson Botel?
Yes.
Councilperson McCoy?
No.
Councilperson Lawson?
No.
Pro Tem Miller Anderson?
Yes.
Chair Lanier? Motion approved with Councilperson McCoy and Lawson dissenting.
We are at the end of our agenda. In the discussions by the city manager.
Yes, Madam Chair, very briefly. A lot of times during citizen comments, I answer those questions, and I do want to speak on a couple of things that members of the public brought up with regards to the train and being able to make left-hand turns onto President Obama when they're at the intersection. We can definitely talk with the county and FDOT and signalization and see what we can do to possibly look to accommodate that. With respect to the question on parking and reasonableness test that Ms. Coffer brought up, that's something that I'll have the discussion with staff about and see what we can do. And then the concerns that were brought up as it relates to, I believe it was 10th Street and traffic calming. I do have a traffic calming meeting tomorrow with staff to talk about some of the standards that have changed with respect to that. And I do have some photos that Ms. Brent provided me concerning the rock pit and the dust and debris that folks have been complaining about. So we're certainly looking into that. And then lastly, Madam Chair, when people come to the podium, they're more than welcome to say whatever they want to say. That's their right. But I don't appreciate being called a boy. There's two people on this. Well, one that's on this earth, one's not with me anymore, but that can call me that. And so I don't appreciate Mr. Lozman utilizing some terminology that I think had some other undertones to it. But nonetheless, I'm a professional. You wouldn't do that at anyone else's job, and I don't expect him to do it at mine. So I don't think that's appropriate. So nonetheless, that concludes my comments, Madam Chair.
Yes, understood. Madam Attorney?
No comments, Madam Chair.
Any council committee reports?
I am going to take them up at the next meeting, even though it has been, I have notes on here from September, so at some point I have to make some committee reports. But I do want to say this, just very quickly. At the Housing Council webinar, Nick Urin was one of the speakers, and he's the Executive Director of Palm Beach Transportation Planning Agency. And it occurred to me that we have not had a report from the governing board of the Palm Beach County Transportation Planning Agency since I can remember. So I took a look at the TPA meetings for the past, this year, and our representative has not been at the January meeting, the February meeting, the March meeting, the April meeting, the May meeting, the June meeting, the July meeting. There was no meeting in August, and he was not there in September. I think it's very important that we have representation on that meeting, and I would like to make a motion that Chairwoman Lanier attend the meeting that is to be held tomorrow, if she's available, and at future meetings so that we can have representation.
I don't think she's the contact anymore. Isn't it Mr. Lawson?
Yeah, but we
we
have had no representation.
I know, but I remember I've always preached that every time because my husband was on there and we weren't being represented. But when we changed committees, I thought Ms. Lanier came off and either Mr. Lawson or Mr. McCoy assumed that role.
Well, who is the second then? Somebody has to be
Mr.
going.
Lawson assumed the role, and I think that McCoy assumed the subordinate role.
I would be in support of Councilwoman Lanier taking on the chair, taking on the position to represent for the TPA.
Thank you.
I'm absolutely supportive of that.
Thank you.
Madam Clerk, could you make that change?
It will be duly noted, and that was a motion to change, or are you all just going to agree?
We're just going to agree that, I mean, it's a committee.
Okay,
appointment.
then I'll make a change to the
Update
list that
the
was
committee
previously
report.
sent out to you all and resubmit it to you all with that change.
Yes, and make sure you send it to the TPA because they can start sending me the information.
I will.
And for several weeks now, probably a month at least, my legislative aide has been asking the mayor's office that we could read a petition, read a proclamation about Domestic Abuse Awareness Month. Reverend Dr. J.R. Thicklin has been asking for that for weeks and weeks, and we've had no response from the mayor's office, I guess because tonight he read a proclamation himself. But I would like to read the 2 proclamations from Reverend J.R. Thicklin at the next meeting, even though it's no longer October at the next meeting, but I did make a commitment to him that we would read those, so I appreciate that.
Thank you. We'll start with Commissioner Lawson.
Thank you, Madam Chair. I just wanted to kind of start off with clarity's sake. The Robert's rules for 2/3 vote is actually at least twice the number of votes. So when 5 members are voting, it's actually 2/3 would be 4 people. That's what's documented with Robert's rules, just for clarity. So I'm not sure what that does, Madam Attorney, or in reference to the motion, but I'm sure that'll be brought back up in the future.
Thank you, Mr. Lawson. What we'll have is the city clerk and the city attorney to bring that back to us, because if we have to undo it, then that's what we'll do. Any other comments, Mr.?
No, thank you, Madam Chair.
I'll save mine.
Okay. Miller Anderson? For me, our meeting is adjourned.